Adjournments. Page number 13, serial number 50 to 50 and 51. Page.
ಕಾಸು ಕೊಡ್ತಾರಂತ ಕಾಸು ಕೊಡ್ತಾರಂತ ಕಾಸು ಕೊಡ್ತಾರಂತ ನೋಡಿಲ್ಲ again
20 seconds. 20 seconds.
Serial number 52. It may kindly be taken up on 15 or 16.
60 IRDA.
IRDA.
Who's the counsel for IRDA?
He may not.
No, in some other case, I issued direction to IRDA.
Phone but Raghavan is the only counsel represents Southern India. In the Chennai.
Ask him to take notice in the other appeal also because I have directed Shanti Bhushan to take notice. Shanti Bhushan. If you can give his phone number, I'll ask the registrar to come.
My lord, senior.
Steve.
Wait. Page wise.
Page number 15, serial number 56 and 57. Page number
My lord,
60.
serial number 42 and 55. My lord's counsel appearing on behalf of the petitioners.
Please wait.
Serial number
You can't move
42.
an hearing on IA. Please wait.
Okay, serial number 55, my lords.
50.
55, my lords. Counsel appearing on behalf of R4 and R5, seeking for adjournment, my lords. Senior counsel is not well for the reason stated so near.
We informed them.
Shrikante.
Have you informed the other side?
Yes, my lords.
Page number.
Serial number? Please wait, madam. 2015. Please wait.
Page number 17, serial number 63 to 67.
No, 2015.
Page number 19, serial number 75 to 81.
May I please, your lordships, list number 1, serial number 65, your lordships.
Please wait.
Serial number 71, my lord. Some inconvenience, my lord.
Yarge.
Petitioner, my lord. For petitioner.
No,
After long time,
16 matter.
after long times it has come, my lord. I have seek further instruction from the client, my.
From next week, don't ask him. Today is the last.
Please, ma'am.
Page number.
May I please, your lordship, serial number 1, list number 1, serial number 65, your lordship. I am for the petitioner in this matter. We have to file our objections to the report filed by AEEE. So we are kindly requesting for adjournment, your lordship.
Commissioner report act vacancy needs some time in that matter.
I am for the petitioner. Serial number?
65, 65 and 61.
Please wait. 2015 matter. Please wait.
Page number 19, serial number 75 to 81. Page number 20, serial number 82 to 87.
Serial number
82. For respondents, he's not keeping well, sir. He requests for a time. Or President Council, request or one galate matter, I'll take it up. I'll try to inform you.
serial number. Serial number 84, my lord. 84. I am for the petitioner, madam. I will inform the other side. Connected up petition also, madam.
Page number 21, serial number 81 to 89, 88 to 91.
Serial number 45.
Orders.
You can't move hearing on IA. Please wait.
For preliminary hearing, serial number 1. Yes, welcome.
One.
Is last night. Sanju, you appear to that. It's connected. Maradin, on the first matter, I think Mr. Sanju's name should be shown, my lord.
Yes.
Mr. Sanju's name should be shown. I am no more, my lord, with the corporation now.
He stated that Sri B.L. Sanjeev, Sri N.K. Ramesh is not in the panel and Sri B.L. Sanjeev is going to take notice. August opinion of Sri B.L. Sanjeev is appearing for respondents 1 and 2 and release the matter.
17. Seal number 2, Sri Joseph Anthony.
For the petitioner in this matter.
ನೀವೇ ತೊಗೊಳ್ತೀರ ಮುರಳಿ ಫಸ್ಟ್ ಮ್ಯಾಟರ್ ನೀವೇ ತೊಗೊಳ್ತೀರ ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟರ್ ಅಂತೆ ನೀವೇ ತೊಗೊಳ್ತೀರ
Allah, Wakalat has been filed by Mr. Sanjeev himself. Wakalat has already filed, man.
Seal number 2.
Lord, in this matter, the section 18A, virus of section 18A of the Karnataka Town and Country Planning Act is unchallenged, my lord. In fact, there's a batch of petitions where similar issue is in consideration. I'll furnish the numbers during the course of the day, my lord, maybe connected.
Objections ಹಾಕಿದ್ರ 2019 madam. The DA seeks for a week's time to file objections. Released on so and so. Post along with
Petition 230. Wait, my lord, I will. Great.
number 25. 24. 24 or 25? 25.
Seal number 3, Sri V.V. Sidramaya. Appearing for counsel.
Author of the property and the name of husband of the petitioner. Suit for declaration is pending. In spite of a pendency of the suit, Kata has been transferred by the municipal commissioner. In the name of the third respondent, we have filed an appeal before the regional commissioner.
Who's the third respondent? Who is the third respondent?
Private respondent Brahmananda. And we have filed an appeal before the regional commissioner. Regional commissioner insisted the appeal on delay. Without condemning the delay, let they consider the appeal on merits.
ಎಷ್ಟು ದಿನ ಆಯ್ತು delay?
1 ವರ್ಷ 6 ತಿಂಗಳು.
How is the third respondent related?
Well, he claims that we have purchased the property totally 1 acre 7 guntras of land, but this property has not been sold to some respondent.
Is a registered sale deed.
Sale deed he claims, but we delayed.
ಸರಿ ಡಿಲೇ ಮಾಡಿದ್ದಾರೆ. There's a sale deed, isn't it?
ಅದು finding of the commissioner, but ಇಲ್ಲ.
ಇಲ್ಲ ಅಂದ್ರೆ
Sale deed ಯಾವುದು ಮಾಡಿಕೊಟ್ಟಿಲ್ಲ ಅಂತ ನಮ್ಮ contention. Suit for declaration is pending. He himself has filed a suit
ನೀವು
for-
ಹೆಂಗಿರೋ ದಾವ ಹಾಕಿದ್ರಲ್ಲ ಅಲ್ಟಿಮೇಟ್ಲಿ ದಾವ ಏನಾಗುತ್ತೆ ಅದ್ರ ಮೇಲೆ ತಾನೇ
ದಾವ pending ಇದೆ.
So I'll say to the ultimate decision of the civil court.
Let the regional commissioner consider
No,
the
if there is
appeal
a suit, if there's a suit pending,
on- in pendency of the suit, Kata has been changed.
There's a-
That is illegal.
if there's suit pending and the suit is filed by you, how can you get the kata done in your favor before the suit is decided?
Well, in pendency of the suit, Kata has been transferred in the name of the-
Either, he says there is a sale deed, isn't it?
Yes, madam.
He says there is a sale deed.
Sale deed he says, but suit for declaration is pending.
I will say any observation made here will not,
Let
But
the,
in the suit.
let the after, does not, till the dispose of the suit, then let they shall not act on the.
what is the, where is the reasoning?
Reasoning by the commission.
ನಿಮ್ಗೇನ್ ಬೆನಿಫಿಟ್ ಆಗುತ್ತೆ ಸಿದ್ದರಾಮಯ್ಯ ಅವರೇ ನೀವು ದಾವ
Declaration ದಾವೆ pending ಇದೆ.
I'll say that this will be subject to the result of the suits.
Let they shall not create any third
ನಾನು
party.
ಅಪೀಲ್ ವಾಪಸ್ ಕಳ್ಸೋರು ಅವ್ನು ಅಷ್ಟೇ ಮಾಡೋದಲ್ವಾ? ಈ ಕಾಂಟ್ ಸೇ ದಟ್ ಖಾತಾ ಶುಡ್ ಬಿ ಇನ್ ಯುವರ್ ನೇಮ್.
Indian manner, it is not created. ಖಾತಾ ಇದ್ದಿಂದ ಅವ್ರು ಮಾರಾಟ ಮಾಡ್ಬಿಡ್ತಾರೆ. Next ನಮಗೆ ನಮಗೆ ತೊಂದ್ರೆ
ಅಲ್ಲಿ ದಾವಲ್ಲಿ ಹಾಕೊಳ್ಳಿ ನೀವು ಅಪ್ಲಿಕೇಶನ್. Because if there's a registered sale deed,
ಹೇಳಿ 1 ಎಕರೆ 7 ಗುಂಟೆ. ಇದು ನಾವು ಕೇಳಿದ್ರೆ ನಮ್ ಕ್ಲೈಮು 100 into 40 ಅಷ್ಟೇ. ಉಳಿದಿದ್ದು they are southern extent of land.
civil suit ಡಿಸೈಡ್ ಮಾಡ್ಲಿ ಬಿಡಿ, ನೀವು ಇಲ್ಲಿ ಯಾಕೆ
Civil suit is decided ಆಗಿದೆ.
the petitioner is agreed by the decision of Kata in favor of the third respondent, which has also been confirmed by the deputy commissioner,
Regional council.
the regional commissioner, who dismissed the appeal on the ground of delay. Though in the normal circumstances, the matter will be remanded to the regional commissioner for consideration of the appeal on merits. And I regard to the fact that the petitioner admits that there are 2 suits filed
in respect to property in question, in which prayers for declaration have been made, in my view, remanding the matter to the regional commissioner would not serve any purpose. It would however be necessary to clarify that any decision relating to the registration of Kata would abide by the ultimate result in the pending suits, namely OS. ಎರಡು suit ಇದೆ ಅಂದ್ರಲ್ಲ.
Why is 108 of 2018 and 108 of 2018, ಇನ್ನೊಂದು 985 of 2017.
It is needless to state that the authorities would be bound by the decree that is passed by the civil court, and they have to register the Kata in accordance with the decree passed by the civil court. It also made clear that the petitioners would be entitled to seek for appropriate interim reliefs before the civil court in which the suits are pending, subject to the above.
ಒಂದು ಫೈಲಿಂಗ್ ಬರುತ್ತೆ ಟೆಂಡೆನ್ಸಿ ಆಫ್ ಸೂಟ್ ಟ್ರಾನ್ಸ್ಫರ್ ಮಾಡಿದ ತಪ್ಪು ಹೇಳಿ ನಾವು ಮಾಡಿರೋದು
Needless to
ಯಾರು
that
ಮಾಡಿದ್ರೆ
the orders impugned have been passed in the pendency of the suit, and they shall therefore abide by the result of the suit.
Seal number 4. R. Kiran.
The petition. The requisition by the petitioner to establish a Nandini milk farmer in Shimoga, in jurisdiction of respondent number 1, the Shimoga Manor. The requisition was accepted, and the jurisdiction also was established by respondent number 1, and the requisition for establishment of the milk farmer was also granted by the respondent number 2. In accordance to the same, it requested for the payment challenge from the revenue officer of respondent number 1, but the same was delayed for over a year.
No, they have refused permission on what, on technical grounds?
Yeah, they've cited vague technical grounds saying that the jurisdictional site has technical errors and the same needs to be looked into and the matter will be.
What is the technical error?
There have been no substantial ones.
You know who appears for the Shimoga? Nagaraj.
See, Nagesh.
Who appears for the second respondent? Do you have any idea? Any counsel? James Nagesh is written notice for R1. Issue notice to R2. It is also permanent record notice on R2 personally or the standing counsel FM.
Seal number 5. Lingraj.
Petitioners have constructed house in Vijayanagar, Fourth Street, Nagar. After construction method, they approached the Buddha for issuance of CR in the E-Asti Mallard.
Issuance of?
Issuance of CR and E-Asti Mallard. Because of jurisdictional issue, in the year 2003, the Buddha has delegated the power to Inkal authority, Inkal Gram Panchayat. That order was questioned before the court. Annexure C.
The notice ಮಾಡ್ತೀನಿ.
Annexure C ನಲ್ಲಿ stay order ಇರೋದ್ರಿಂದ CR issue ಮಾಡ್ತಾ ಇಲ್ಲ. Similar matter ಇದನ್ನು connect ಮಾಡಿ
First notice order ಮಾಡ್ತೀನಿ.
ಇದಕ್ಕೆಲ್ಲ connect ಮಾಡಿ tag ಮಾಡ್ಲಿಕ್ಕೆ
PTP Vivekananda take notice for R1 and R2.
HC ಶಿವರಾಮ್ appear ಆಗ್ತಾರೆ. HC ಶಿವರಾಮ್ ಆ ಕೇಸ್
ಮೂಡಾಗ.
ಮೂಡ
HC ಶಿವರಾಮ they take notice for respondents 1 and 2. Post along with
26417 of 23 Mallard. 20 date ಕೊಟ್ಟಿದ್ದಾರೆ. Please.
Number 6. Shri Srinivas V.
But I challenge the past by reaching the wherein I have called in question the 248 provisional order and the confirmation order. Now, Lord, the provisional order, the allegation is that Lord, I have not built excess. I have built less than the FAR.
What is the violation?
Lord, page number 15, annexure E, Lord.
In rare
ಬಲಭಾಗ 10%, ಎಡಭಾಗ 10%, ಮುಂಭಾಗ 100% ಇರ್ತದೆ, ಹಿಂಭಾಗ 30.43, average 20.50% is
ಮುಂದ್ಗಡೆ 100% ಇದೆ.
ಅದು ಒಂದು ಭಾಗ 100 ಇದೆ, average ತಗೊಂಡಾಗ 30.43% ಬರುತ್ತೆ. Even when it is 249 ಅಲ್ಲಿ ಬರುತ್ತಿದೆ. And Lord, ನಾನು coverage less ಕಟ್ಟಿದ್ದೀನಿ.
I need to take instructions from the concerned.
Stay Lord in the demolition.
Respondents 1 and 2. It's granted 2 weeks time, second instructions. Previous transactions until.
Till then, let them not.
ಕೊಡ್ತೀನಿ ರೀ ಯಾಕೆ? Until then, there should be an interim stay.
31st. Seal number 7, Shri Venkatrami Reddy.
Petition to grant. Direction, gave blood very rejected my application. I want to grant the trade license to run the Ozone Chicken Center. The groundwater. There is a college.
AGA notice for R1. ಇವ್ರು ಯಾರು ಮುನ್ಸಿಪಾಲಿಟಿ ಯಾರು
Kadur municipality.
ನಿಮ್ಗೆ ಗೊತ್ತಿಲ್ವಾ?
Kadu.
Kadur municipality ಗೊತ್ತಾ? Issue notice to R2. Petition forward take out notice on R2 personally or standing on to defend. Then list ಕೊಟ್ಟಿಲ್ಲ. ಸರ್ ಮಾಡ್ಬಿಟ್ಟು ಮೂವ್ ಮಾಡಿ.
Seal number 8, Shri Shivakumar.
Yes, sir. Paper. No, done there, actually, in page number 12, my lord.
Next year.
Actually, yeah, my lord, in page number 12, my lord. Final approval by Nala, issued my lord, found that the case is pending, my lord. The case, there is no interim order, my lord, the way no way concern in the case. The basis of the legal opinion of annexed.
ಯಾರು ಹಾಕಿರೋದು ದಾವ? Who has filed the suit?
File on the Jamil Sharif.
Huh?
Jamil Sharif.
ಅವ್ರ ಪಾರ್ಟಿ ಮಾಡಿದಿರಾ?
ಅವ್ರು ಇದ್ರಲ್ಲಿ ಪಾರ್ಟಿ ಮಾಡಿಲ್ಲ, there is no entry ಮಾಡ್ತಾರೆ.
ಬಟ್ ಪಾರ್ಟಿ ಮಾಡ್ಬೇಕಲ್ವಾ? ಅವ್ರು ಕೇಳ್ಬಿಡ್ತಾನೆ ಕೊಡ್ಬೇಕು.
They take the legal opinion, annexed B, my lord. They sought for the legal opinion.
Correct, but
Annexed B, my lord, on the basis of the legal opinion, they are not issued the final plan. Provisional sanction plan are issued on 17/2022, my lord. In the legal opinion, page number 16, my lord, in last paragraph, my lord, to last paragraph, to grant pen approval of the layout plan, release any sites on the layout plan, it is not made clear to me whether any indentation is operating of the land or not, my lord. Approve the entire order sheet, my lord, as in page number 62, my lord.
ಒಂದ್ಸಲ ಅವ್ರನ್ನ ಪಾರ್ಟಿ ಮಾಡ್ಬಿಡಿ, it will be easier for you also, or else they will file one more petition saying that an order was passed without hearing us. On their complaint, this order is passed. ಅವ್ರನ್ನ ಕೇಳಿದ್ರೆ ನೀವು ನಾನು ನೋಟಿಸ್ ಮಾಡ್ತೀನಿ, ಬಟ್ ಐ ವಾಂಟ್ ಯು ಟು ಇಂಪ್ಲೀಡ್ ದಿ ಕಂಪ್ಲೇನೆಂಟ್ ಆಲ್ಸೋ.
My lord, there is a, will be a investor use money, Provisional.
ಅದಕ್ಕೆ ನಾನು ಹೇಳ್ತೀನಿ, ಅವ್ರನ್ನ ಕೇಳ್ಬಿಟ್ಟು ಏನೋ ಒಂದು ಆರ್ಡರ್ ಮಾಡ್ಬೋದು. ಅವ್ರು ಕೇಳಿದ್ರೆ ಆರ್ಡರ್ ಮಾಡಿದ್ರೆ
Take time to.
ವಿಜಯ್ ಟು ಟೇಕ್ ನೋಟಿಸ್ ಫಾರ್ R1, ಯೋಗೇಶ್ to take notice for R2. ಇವ್ರು ಇಂಪ್ಲೀಟ್ ಮಾಡಲ. ನಾನು ಜಮಾಲ್ ಶರೀಫ್ is noticed that complaint was lodged by Jamal Sharif requesting the authority not to grant permission for the layout and on the ground that a suit had been instituted and was pending, and the same was pending consideration. That of the matter of Shri Jamal Sharif is directed to be implemented as the third respondent. Issue notice to the third respondent Jamal Sharif. Petition also permitted to take out notice on Shri Jamal Sharif personally. Released on. ನೀವು ಸರ್ವಿಸ್ ಮಾಡಿ ಎಷ್ಟರಲ್ಲಿ? ಜಮಾಲ್ ಶರೀಫ್
24. Seal number 9, Shri Srinivasmi.
Lord, I appear for petitioner. Sorry for the writ of bind us to include the order of the chief commissioner deviating.
ನೇಬರ್ ರಾ?
What?
ನೇಬರ್.
Yeah, I am the only brother of the private respondent, and he has built encroaching my property also, therefore I am.
ಯಾವ ಹಾಕಿದಿರಾ?
Dava.
The commissioners.
I have only lost the.
The commissioner's order is,
The plan.
the commissioner's order is already stayed by my lordship in WP 44 of 2025. So both may be connected either may.
WP ಎಷ್ಟು?
44 of 2025, where my lordship have asked the petitioner to
44 of
2025. So both may be.
giving you liberty to file a petition after the dismissal.
My friend just now told that his could have directed me to implement.
Implead anta, but it was not recorded in the order. My lordship has suggested.
ಅದರಲ್ಲೇ ಮಾಡ್ಕೊಡಿ, ಇದನ್ನ ಕ್ಲೋಸ್ ಮಾಡ್ತೀನಿ. ಬಿಡಿ, ಎಷ್ಟೊಂದು ಕಿತ್ತಾಡ್ತೀರಾ ನೀವು? ಈ prayer petition is for issuance of direct response 3 and 4 to implement the order passed by the appellate authority by annexed Shri Pawan Kumar, who accepts notice for respondents 1 to 4 submits that the order of the appellate authority has been stayed by this court in WP 44/2025, and therefore will not be possible to implement this said order. I view the right of this submission. It is obvious that the prayers of the petition cannot be granted. The petition is therefore dismissed, but liberty is reserved to the petitioner file a fresh writ petition after the order passed with the appellate authority is attained finality.
Number 10, the Nagaraja.
They ask you directly to file a letter by the members.
D12. Idiyala. There is a notice, what can the assistant commissioner do?
Members have not attended the meeting. From five.
But how can you find fault with the assistant commissioner for issuing a notice? How can you find fault with the assistant commissioner for issuing the notice?
Second notice, first notice has been stayed by.
But liberty was granted by this court to initiate fresh proceedings. Then
These members have not, no rights to. They don't have rights, madam, because from 5 to 6 months, I have produced the attendance list also, madam, case series.
ಅದಕ್ಕೆ ನಿಮ್ಮನ್ನು move ಮಾಡ್ಬೋದು. The
Absent is that our name is.
the petitioner is challenging.
And pass.
What will you do? Nothing that you can do.
Some matter is on group push.
So
Number 11, the Paniraj Kashyap.
The petitioner had challenged the demolition order passed by the second respondent before corresponding matter. But the reason for passing demolition order was that the petitioner had constructed a house without obtaining a plan sanction. But under the section 240 subclause 8, after paying penalty, plan may be sanctioned, even after construction. And they have, the petitioner has also given a representation to the concerned authority seeking plan sanction, and they are willing to pay the penalty. Now the first respondent has upheld the demolition order and.
The application is to be considered because unless they remove the deviation, the plan cannot be approved.
who are the parties in this order?
But the chief commissioner and the executive engineer.
Complaint ಯಾರ್ದು?
Petitioner is the complainant area. There are two more.
The power command to take notice for respondents and secure instructions. The counsel of the petitioner submits that. When did you file the application?
Well, its application was filed on
Shall I dispose it of?
18/6/2024.
Yes, I will take instruction as to
18/6,
what happened to what happened to their application.
18/6/2024.
So the pendency of the appeal, the petitioner had in fact sought for approval of a layout plan. But without considering the same, the appellate authority has dismissed the appeal. Only of the above. The Shri Pawan Kumar is also directed to secure instructions as whether the application filed with the petitioner has been considered or will be considered. Relist on. Till then, there should be an interim stay.
24. For order, serial number 12, P.S. Nagaraja.
For the respondents, 1 and 2, my lord. Lord, this honorable court had directed me to file a fresh inspection report along with the sketch. I'm filing copies served on the other side. As per the report, the deviation is negligible, my lord. Therefore, appropriate orders may kindly be passed.
The petitioner is challenging the orders of demolition, challenging order of confirmation, which has been confirmed by the Karnataka appellate tribunal. This court on 18/11/2023 had directed the counsel for respondents 1 and 2 to ensure that the property in question was inspected and an inspection report, including a sketch and a measure of the property, denoting the setbacks, constituted area and height of the building should be filed. Complaints with the said order, a memo. The inspection report has been filed today, along with a sketch. The perusal of the report would indicate that the total deviation by the petitioner is only to the extent of 2.77%. In my view, since the authorities are empowered to compound the deviation to the extent of 5%.
Yes.
The authorities are directed to compound the deviation and regularize the building. But petition accordingly disposed of. The said extension will be completed within a period of 2 months from date of receipt of a copy of this order.
Seal number 13, CPN Rajeshwara.
Yeah, who's R4?
ಇವಾಗ ಆಂಧ್ರದಲ್ಲಿದ್ದಾರೆ ಅಂತ ಆಂಧ್ರದಲ್ಲಿದ್ದಾರೆ ಅಂತ ಬಂದಿದೆ ಅದಕ್ಕೆ ಆಂಧ್ರ
ಏನ್ ಡಿಸ್ಪ್ಯೂಟ್ ಏನಿದು? ಡಿಸ್ಪ್ಯೂಟ್ ಏನು?
Dispute melon, the order passed against the person here is not been served. Annexure A. The first respondent in Annexure A is the person is not been served.
What is your interest? You are not a party in the proceedings, then. Annexurial, you are not a party. The orders against this Madhav Reddy, and he has not challenged it. ನೀವು ಕಾಸು ಖರ್ಚು ಮಾಡಿದ್ದೇನೆ ನನಗೇನು ತೊಂದರೆ ಇಲ್ಲ ಪೇಪರ್ ಪಬ್ಲಿಕೇಶನ್. An application is filed seeking for taking out paper publication. This was service of notice to the fourth respondent. Since notice has been issued thrice, and it is stated that the petitioner residing for third respondent in Nellore, the application is allowed. Let a paper publication be published on or before so and so, fixing the date of hearing as so and so.
On or before 31.
ಯಾವ ಪೇಪರ್ ಅಲ್ಲಿ?
31.
ಈನಾಡು. ನ್ಯೂಸ್ ಪೇಪರ್. ಈನಾಡು Nellore edition.
Seal number 14, the Anupest offer.
Waiting for the
Property which is acquired under the AD. It has been handed over to the petitioner for developing the land for industrial purpose.
property has been challenging annexure A is issued by the phone number 192, that is Taluk Panchayat, seeking for a trade line. Where the property is acquired under the district purpose in the trade. Of obtaining trade license from the concerned but doesn't arise.
Appealing for respond number 1 and 2, Malesh. According to which they have to appeal before the executive officer.
Now, do you have jurisdiction to demand a building license in respect of KDB property? Objections hakidara?
ಆಗ್ತಿದೆ Malesh.
Not phone number 3 as well. KDB has kind of objection. Have you obtained permission from the KDB? Please, sir. In the year 2011 itself, we obtained the plan sanction from the KDB. And we have paid all the necessary fees before the KDB. Now, how can you demand a license if the KDB has granted a license? ನಿಮ್ಗೆ ಬರುತ್ತಲ್ವಾ ಚಂದ್ರಶೇಖರ್, then ಅವ್ರೇನ್
Panchayat or but as per the regulations, we got a power to sanction a plan. And even now, government has passed a detailed order wherever the KDB, the planning authority. Also now it recently by virtue of the Sanko direction.
ನಲ್ಲೋದ್ ರಿಟ್ ಪಿಟಿಷನ್ ಇದೆಯಾ, ಸರ್ಕ್ಯುಲರ್ ಇದೆಯಾ? ಸರ್ಕ್ಯುಲರ್ ಇದೆಯಾ ಅದು?
Tanzila. It was issued by the Urban Development Department to all the panchayats.
ಏನ್ ಮೇಡಮ್?
Please, Malesh.
ಇದ್ರೆ ಸರ್ಕ್ಯುಲರ್
Tanzila, government order.
Monday. I was covering one of the division bench. He says there's a circular, I'll go by that circular. Monday.
Number 15.
ಇಲ್ಲ ತಂದ್ಕೊಡ್ತೀನಿ ಮಧ್ಯಾಹ್ನ ಅಂದ್ರೆ ಪಾಸ್ ಓವರ್ ಮಾಡ್ತೀನಿ.
15th.
Number 15.
Component authorities not undertaking exercise. I need to find whether there is batch carving in and around my property. They have demolished my property. But I even challenge section 288D for this reason. The article cover the misuse that cover. The matter is by me.
What is the matter?
What has happened is, BBMP not all of a sudden comes to my property, but I have not conversion of the land. I have plan sanction from the BBMP, Khata stands in the name, I have put up construction. But I'm residing in the house. All of a sudden, Lord, BBMP just comes into my house with bulldozers, demolishes my house, throws me out of the house. And then, Lord, forms not a drain in my property. And then, Lord, registers an FIR against me. But it is shocking, Lord, that something of this nature can happen even at this point in time. I'm residing in the house, no notice. What happened was, there was threat of demolition. Certain writ petitions were filed before the Honorable Court, saying that they should not take forcible possession. Then, Lord, they issued notice under section 192A. Therefore, Lord, writ petitions were withdrawn. But taking advantage of this, Lord, they just not come to the property and demolish and not form the drain. Lord, kindly see take my writ petition, Lord, that is WP number 4849.
My lord, the
ಮಾಡ್ಕೊಟ್ಟಿದ್ರ ಅವ್ರು?
Tahsildar has passed an order.
ಇಲ್ಲ ಅವ್ರು ಖಾತಾ ಮಾಡ್ಕೊಟ್ಟಿದ್ರ ನೀವು?
Allah, I am not aware regarding having affected the Kata in so far as construction is concerned. The Tahsildar has passed an order saying that there is encroachment on particular property. And based on that order, they have directed the corporation to take action. Now taking the orders of the Tahsildar, the BMTF, that is second respondent, with the help of third respondent, they have removed it. Whatever the encroachment made on the Raj Karwa, that has been removed it.
ನೋಟಿಸ್ ಏನು ಕೊಟ್ಟಿಲ್ಲ?
I am not sure, my lord, because today has come for
There is no notice, Lord. In fact, Lord, there is a sketch, what the corporation does is, Lord, they rely upon,
It is not demolished.
it's demolished, Lord. But what has
But
been
there is
done
an order of the Tahsildar.
They want-
Before that, there was the survey has been conducted by the Tahsildar, and speaking order has been passed by the concerned Tahsildar. And Tahsildar directed the corporation to take action along with the BMTF. Now BMTF had taken action, demolished it with the assistance of the BBM.
There is no notice issued, but there is no dispute about it.
But there is an order by the speaking order by the Tahsildar. Tahsildar is empowered to take action, which is under section 104.
This is the order of the Tahsildar.
Section 104, Annexure D, Malayand first petition, page number 45, my lords. Annexure D, page 45, my lords. In first petition, 46917/16, my lords.
You are parties to this order.
Yes.
Annexure D, there are so many respondents.
Annexure D.
There are about 26.
We have given a reply stating that they have paid tax, plan sanction by them only.
But you were heard in the matter, isn't it?
Yes.
Not- In that matter, we given reply, my lord, it is not heard.
Your client was,
I'm not aware of. Yes, I'm not,
what is your client's name?
my client's name is Lord Mahendra Kumar.
You don't appear to be a party.
My name is at number 17.
But the proceedings not under by the Tahsildar would be completely different.
In the present petition, my lord, Nama Naik is,
They only implemented an order of the Tahsildar
yes.
until that order is challenged.
But it is not so, Lord. What has happened is this. But when not, even if Tahsildar passed an order, of course, but I am not a party to it. Two, Lord, there is no survey conducted before not demolition.
But what does the Tahsildar say? Does he say that he conducted the survey?
We have-
Page 48, my lord. ಮೇಲಿನ ಹಿನ್ನೆಲೆ ಬೆಂಗಳೂರು ಪೂರ್ವ ತಾಲೂಕು ವರ್ತೂರು ಬಳಿ ಕಸವನಹಳ್ಳಿ ಗ್ರಾಮದ
ಉಲ್ಲೇಖ 1ರಲ್ಲಿ ಸಹಾಯಕ ಅಧಿಕಾರಿ ಅವರು ಸಲ್ಲಿಸುವ ಪಟ್ಟಿಯಂತೆ ಹಾಗೂ ಉಲ್ಲೇಖ 2ರಲ್ಲಿ ಮೋಜಣಿದಾರರು ತಯಾರಿಸುವ ಸ್ಕೆಚ್ ನಂತೆ ಹಾಗೂ ಕಂದಾಯಾಧಿಕಾರಿಗಳು ಸಲ್ಲಿಸಿರುವ ವರದಿಯ ಮೇರೆಗೆ ಈ ಪ್ರಕರಣ ಪ್ರತಿವಾದಿಗಳು ಒತ್ತುವರಿ ಮಾಡಿದ್ದು ಅನಧಿಕೃತವಾಗಿ ಕೆಲವರು ಕಟ್ಟಡಗಳನ್ನು ಕಟ್ಟಿರುವುದು ದೃಢಪಟ್ಟಿರುತ್ತದೆ.
Even assuming, Lord, there is a survey conducted not by them.
Oh, they formed a drain also, isn't it?
They have formed a drain property. Therefore, Lord, I filed a memo.
But then if this property is part of the Rajkaluwe,
No, it is not, Lord. In fact, from their own sketch, Lord, I'll point out. But I produced that sketch as well. But what has happened is this.
ಏನ್ ರೆಡಿನಾ ನೀವು?
your lords fix a date, my lords. Any date by next week.
PI is fine. The PI is not certain directions are issued. Under the garb of complying with those directions and to not favor some developer. What they do is not, the Rajakalu has to go in a different fashion. They're not trying to find out which is the best way out and not proceed and straight away do everything. Not assuming not have encroached, let people take up argument. Just not to say that there is something from their side. Even assuming not have encroached. But even then, not should not I be issued with the notice.
But in the,
I have planned sanction, Lord.
in their cases, they have issued notice.
But their
They
case.
participate in the inquiry.
But that-
Your case may be a bit different, but if they have conducted some inquiry, until this order is held to be bad,
They will have to answer that because in far I am concerned, Lord, there is no such notice issued. I am not a party.
how many people are involved?
According to the order, my lord, there are 25 people, my lord. 26. The question of local corporate does not arise because there is a speaking order passed by the Tahsildar.
Five petitioners.
There are 5 petitions.
And out of these 5 petitions, except Manmohan's matter, everybody else was a party to the order.
Yes.
ನಿಮ್ದಲ್ಲಿ ಮನೆ ಹೊಡೆದು ಮುಗಿಸ್ಬಿಟ್ಟಿದಾರ? You have a sanction plan.
Yes, we have a sanction plan, sanction. Even the CDP also says that.
Maybe sanction from village, not from the BBMP.
Then I will direct the jurisdictional engineer to be responsible for payment of this cost. You will
In
pay
fact,
this
my
money
lord,
and recover the money from it.
In fact, the state government has directed take action as concerned varied officer to in respect of the plan which was issued to in respect of the parties in question.
Our cost you will pay to them and recover it from that engineer.
You lordship may kindly fix a date for final hearing, any date by next week so that I'll come prepare and I'll argue the matter. my lords.
Post in B group one. Post in B group one. So
ಇಲ್ಲ ಕೊಟ್ಟಿದ್ದೆ.
70.
Case my lord,
70.
to the that was challenged. In that against the landowners, my lord,
let us see on the same, we'll then dispose it of altogether.
B group lot can be at 230.
So NR Jagdishwar has entered up the list for R2 and R3. The H. Devendrappa is permitted to retire in all these cases.
Can I request for 230?
230, but I'll have it. I'll take it up at 430 if it does not reach.
Very well. Not interim order. Interim order.
ಮನೇನ ಹೊಡೆದಾಗ ಕೂಡ
ಇನ್ನು ಏನಾಗಿದೆ ಪೆಂಡಿಂಗ್ ಇರುವಾಗಲೂ ಬಂದಿದೆ ಎಂಟ್ರಿ ಮಾಡಿದ್ರು ಇದ್ರೂ ಪ್ರಾಪರ್ಟಿ ಅದ್ರ ಬಂದು ಫರ್ದರ್ ಡೆಮಾಲಿಷ್ ಮಾಡ್ತೀವಿ.
ಅಲ್ಲ according to him, everything of demolition, but demolition ಮಾಡಿ ಬೇರೆ question once again going there and
there is a better way of doing this. You should not allow them to put up construction.
of course, there is some officers who are hired while sanctioning plan and we have taken action against them.
I have not come across you punishing any one engineer so far.
But BMTF has filed a charge sheet against the concerned errant officers.
That's why I told Pawan, in a confirmatory proceedings, the moment an order of confirmation is made, you will not go against the building until you go against your engineer first.
Of course.
I'll make that the order in one of these cases. You cannot play around with people's lives like this. ಅಲ್ಲಿ ಲಂಚನು ಇಸ್ಕೊಂಡು ಕಟ್ಟಕ್ಕೆ ಬಿಟ್ಬಿಟ್ಟು
ಅಲ್ಲ, in the meantime, the party who has put up construction, they had a responsibility before put up construction as such.
The bigger responsibility is paid to ensure that these things don't happen.
Of course, there is
So if he has allowed it to happen,
there is a latches on both the parties, including petition, including the officers of the corporation.
set your house in order first. Thereafter, you can set in other houses on order. I'll ask that engineer to pay the cost of the construction made by them and the cost of demolition also.
If the person was participated with the concerned officer, the Tahsildar,
Order of confirmation is passed, that means you're admitting there's a deviation of the sanction plan. It was your responsibility to enforce the sanction plan. You have held your engineers guilty because of that order. So punish him first and then go against the building. Or else I will not allow this to.
please.
We'll do it on which date you want.
70.
I'll get the 17. 17. All right.
17, sir.
Still number 16.
You want to continue? 15 point?
It's not numbered as point.
You have to delete the name of Shri Ganapati and show only the name of MB Aniruddha.
That name will be, Mr. P.K. Shikara name will be.
The name of Shri Sohan should be printed in the.
Still number 16.
I appear and I am filing a memo for dispensation of notice to R25 since MAD is only a formal party. No relief is sought against I am filing a memo.
In matter and ready na?
Now ready there because it is already
writ petitions pending. The writ appeal is also pending. They've already filed a suit in OS number 6. There is an interim order.
ನೀವೇ ಯಾರು?
ಅಲ್ಲ ನಾನ್ ಪಿಟಿಷನರ್ ಸಿನ್ಸ್ I am appearing for the petitioner.
Still number 17.
ಇಲ್ಲ ಇಲ್ಲ ಇನ್ನೊಂದಿನ ಹಾಕೊಳ್ಳ.
ಅಲ್ಲ ಒಂದು ಶಾರ್ಟ್ ಡೇಟ್ ಕೊಟ್ರೆ ಯಾಕಂದ್ರೆ ಫೈನಲ್ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ವರ್ಗು
There is already suit is pending. Suit was already interim order.
Argument ಮಾಡಿ.
24. Still number 17. Shri Chandranath Tariga.
My lord, I appear for respondent number 2, my lord.
Construction on the road which is proposed by the petitioner. There is an order by the corporation commissioner which was taken in appeal to the district court.
My lord, with respect to the present status, my lord, we have to seek some instructions, my lord. Any date may be fixed will be.
2006 is the order. 2006 is the order, several orders.
Post in D group. I'll post it in B group on one of these days. Please.
24th. 24th.
The application may be allowed or.
But ಹಂಗೆ ಇರುತ್ತೆ, ಹಂಗೆ ಇರುತ್ತೆ.
Great. Bill number 18, Shri Pramodar.
Second time.
R4 ಯಾರು?
R4 is the party.
Now, what is his interest?
He is the contesting respondent.
A week seems that to the need petition also promote take out notice on R4 personally.
Bill number 19, Shri Srimati Lakshmi Sola.
Acknowledgement ಇದೆಯಾ? Acknowledgement ಹಾಕಿದ್ದೀರಾ?
Formally, they responded to the submission that they are settling the matter, sir.
Acknowledgement ಇದೆಯಾ ಅದಕ್ಕೆ? ಕಳ್ಸಿರೋದಕ್ಕೆ?
Objection ಕೊಟ್ಟಿದ್ದೀವಿ.
ಏನ್ ಮ್ಯಾಟ್ರ್ ಏನು?
So they're asking for consideration of their application. We have already considered and we have already given an endorsement. In between, the private respondents and petitioner wanted to some settle regarding the rights over the property.
Where is the endorsement issued by you?
I have filed along with my objections, my lord. Annex R1. Objections were filed on 10th March 2021.
Also 10th March.
10th March 2021. My lordship may see in my.
The state has filed its objections. Have you not filed?
We have filed, my lordship. I have that acknowledgement also. They have filed the writ petition on 7 January 2019. Endorsement was issued on 1st January 2000.
No objections?
In objections, I have filed, where we have stated that there is proceedings pending before the land grabbing court. After the conclusion of proceedings before the land grabbing court, we will consider.
Filed by no spells stating that on the earlier counsel being designated as senior counsel, he has intimated to the petitioner what the said fact and has requested him to make alternate arrangements. It also stated that the papers have been handed over to the petitioner. In view of the memo, yeah, Ramesh is directed to, his name be deleted from the array. The prayer, the order sheet arrest. The prayer in this writ petition is for issuance of a mandamus to direct the respondents 5 and 6 to consider the request of the petitioner made at Annexure A, which is a representation dated 1/6/2018. The BBMP has filed a counter in which is stated that when endorsement dated 1/1/2019, the representation dated 1/6/18 has been considered. And it is found, stated therein that the request of the petition cannot be exceeded to. In view of the fact that the representation for which consideration was sought for in this writ petition has in fact been considered and an endorsement has been issued, it is obvious that the prayer sought from the writ petition would not survive for consideration. Is it in liberty to the petitioner to challenge the said endorsement? This writ petition is dismissed.
Number 20. Chandranath Ariga.
One of the president of the Panchayat, a bill is sought to be released. That I would tell you that the respondent number 2.
You are still the president?
No, that period is over, but it is public money. I will just find out and make the submission.
No, I did.
This person may not be interested now, but nevertheless, it's a public money. Only to that extent, I will make a submission.
Why do you say that the money should not be released?
Because one is that is not approved by the Panchayat. Estimation is given.
You are a member of the Panchayat?
President of the Panchayat. The work is done and the money has to be released, it should be. Maybe there was a tussle between the petitioner and the PDO. That maybe there is a.
Interim order then,
How will interim order then? If 2 days time, I find out. Respondent number 3 is the contractor. He may have to make the statement. Whether money is released.
No, I'll direct the PDO to consider your objection and then pass orders.
Please.
Why should I keep it pending?
Why should?
The prayer in this writ petition is for issuance of direction to the Panchayat Development Officer not to release any amount from the funds of the Panchayat without the approval of the President of all. It is stated in the petition that the petitioner was the President of Kokoda Grama Panchayat. The petition was filed and attempts were being made to clear the bills of the third respondent without his concurrence. In my view, having regard to the allegations made in the petition, it would be appropriate to direct the second respondent to consider the contentions raised by the petitioner before any decision is taken to release the amounts in favor of the third respondent. It is needless to state that if the work has been entrusted to the third respondent without the concurrence of the Panchayat or in the procedure established by law, the PDO would take appropriate action in the matter. That petition is only disposed of.
Then PDO also. There was.
PDO.
Please.
Number 21. Srimati
I
Leela
appear
Umesh
for
Shankar,
respondents
14%.
1 to 4. 14%. They actually, this petition has become infectious. We have already took action and the 5th respondent has obtained stay before the KAT. So I will
E-service e-court notice.
notice.
E-court notice.
Because the constructions made against the approved plan.
Is noticed that court martial will with the party in person. And he said notice has been returned with an endorsement. No such person. Is also endorsed. No such person at the address. There is also an endorsement that the address cannot be located during inquiry. Since the registry would have no manner of locating the petitioner except by pressing the notice to the address furnished by him. It is obvious that no steps can be taken, and the petitioner has also not evinced any interest in prosecuting his petition. Hence, petition is dismissed for non-prosecution.
Seal number 22, Sri Yes, Ravi Shankar.
Copies. Copies. Nobody has filed a call.
Petitioner was dismissed for non-compliance of subsections. An application has been filed for recalling the said order. However, there is no representation on the petitioner. It is obvious that the petitioner is not interested in prosecuting the petition, and hence the application that has been filed for recalling also dismissed in non-prosecution.
Seal number 23. The Karthik V.
Except for the. Disconnected. Now I've been told, my lord, the matter is adjourned today. Again, even the connection. Lord, the impugned order, my lord, is passed by the Tahsildar.
Who is opposing you?
For the state government, my lord, it is an order passed by the Tahsildar. My lord, petitioners here are in the business of, my lord, supplying water by water tanker. Now the Tahsildar, my lord, passes an order saying that to file criminal cases against all the persons who are supplying water in the water tanker. That is, that order, my lord, is without jurisdiction. There is a separate act, my lord, which says, my lord, how it has to be regulated. It's called as the Karnataka Groundwater Regulation Act. Lord, the affidavit filed by the state government, they say, my lord, they have passed the order under the Karnataka Land Revenue Act, my lord, section 73. The lordship may kindly see section 73 of the Land Revenue Act. There, my lord, any action has to be taken, my lord, is by the authority. Authority, my lord, is not the Tahsildar. The authority, my lord, according to section 3. Of Groundwater Authority, my lord, they have to, my lord, take action according to this, my lord. Since, my lord, the interim order has been granted. While granting interim order, my lord, are limited, they have, this court has directed us, my lord, to supply only to the hospitals and educational institutions.
But do you have a permit to extract the groundwater?
No, there is no law, my lord, which says that, my lord, we cannot do it.
See section 11 of this. What is section 11?
For section 11. Or in the notified area. Notified area is not a notified area. Section 11. So grant the permit to extract use of groundwater in notified areas.
Where is the notified area defined?
No definition is there in the notified area. I, my lord, means the area notified under section 10.
Notify ಮಾಡಿಲ್ವಾ ಕರೆಯಪ್ಪರ? Notify ಮಾಡಿಲ್ವಾ ಜಾಗನ?
Lord's by instance that part for the officer. Now, my lord, the order is passed by the Tashildar. Now, my lord, Tashildar, they file affidavit saying that we have passed an order under section 73 of the land.
If that is so, if he gets instructions and ask him to withdraw this notice and act in accordance,
It is all my lord, my only prayer is, my lord, the order which is
Let
passed
him-
without jurisdiction.
let him get instructions. Released on.
17, 17. 24th.
ಎಲ್ಲ ಕೇಸ್ ಅದೇನಾ?
ಎಲ್ಲ ಅದೇ.
But over exploitation ಆಗ್ತಾ ಇಲ್ವಾ?
After that, there should be some rules, my lord, that which they should do it. Lord, they cannot, my lord, the whims and fancies, Tashildar pass an order and say, and he says, my lord, only 12 people can do. My lord, the Gram Panchayat alle, ಅವ್ರಿಗೆ ಇಷ್ಟ ಬಂದಿದ್ದು 12 ಜನ ಮಾತ್ರ ಮಾಡಿ ಅಂತ ಹೇಳಿದ್ರೆ ಆಗಲ್ಲ. Rules, I agree, my lord, some over exploitation is there, some rules should be followed. My lord, it is not the authority of the Tashildar. And there is an act, specific act which is provided. The authority there, my lord, has to take action.
ಕರೆಯಪ್ಪ, look at it, this I think is something that you should be worried about.
So, and then, see over.
Seal number 24, Shri Cyril Prasad Payas.
The petitions for law. And Grama Panchayats may not have been demanding
ಇದು
taxes.
this may be,
Right.
this matter has to be heard. This may be posted in B group next week. and can-
The detailed order passed by the CEO, my lord. I don't think.
You could not have passed that.
Very, very, that will come to hearing of you.
Goes along with so and so in B group on.
Interim orders are right. Okay.
Not in first case ಅಲ್ಲಿ ಇಲ್ಲ.
ಎಲ್ಲೆಲ್ಲಿದೆಯೋ?
First case ಅಲ್ಲಿ ಇಲ್ಲ.
ಎಲ್ಲೆಲ್ಲಿದೆಯೋ ಅಷ್ಟೇ. Intermodal financial.
Number 25, Shri Samit S.
Matters pertaining to be connected.
Connect once. First my.
Number 2. Seal number 26, Shri Bimbadar. Seal number 27, Shri T. Sheshgiri Rao.
Weeks time.
Seal number 28, Shri Gautam.
Report is ready. During the course of the day, I will file in the counter after serving a copy to.
Interim order, Shri 17. Number 29,
My lords, in this matter, my lords, despite an interim order passed by this honorable court, the respondent number 5 is proceeding with construction. Now he's putting up all the interiors and plastering work is going on, my lords. No action has been taken by BDA till date. Sorry, the BVMP.
OPS or BVMP.
Mr. Praveen Kumar Raikote.
Praveen Kumar Rai.
I have all the photos, my lords, that the construction is still being carried out. Please, my lord. This was earlier disposed of. I had filed a review petition saying that the confirmation order filed before this honorable court pertains to another site and not the site of the respondent number 5. The review petition.
I will inform the council membership.
He says despite an interim order,
The construction is there. Kindly have it on Monday, my lordship.
Lordships may kindly
and ask him to be present.
No, sure, by Monday I will take instruction, make submissions to
Meet
what
the
has
lordship
happened.
shall kindly clarify that the interim order subsists, because the, according to respondent number 5,
Let's see what it's on Monday.
interim order may kindly be extended.
Seal number 33, Sarvana S.
In memo for dismissal.
Not suddenly, they, what they say is, since condition is imposed for according layout plan, we have to forgo the land. Non, recent judgment says, not that imposing of the condition itself is bad.
Annexure Q.
Not, I'm seeking for compensation or for alternative land. With respect of the land which have, they have made me to forgo.
But annexure Q has been considered and my lord, detailed endorsement is issued. I produced it my lord, along with a memo.
Petition.
ಅಲ್ಲ, ಅದು ನಾನು ಅಮೆಂಡ್ಮೆಂಟ್ ಮಾಡ್ಕೊಬಿಡ್ತೀನಿ instead of.
ಪೂರ್ತಿ ಚೇಂಜ್ ಆಗೋದಲ್ಲ, ಎಂಟೈರ್ ಬೇಸಿಸ್.
So only I have to change the endorsement, that's all. But the imposition of the condition itself is bad. There are recent, so there are series of judgments.
But here is a road margin area, my lord, he wants compensation.
Not, they
from the
say they
planning
want,
authority.
in the future, they want to
How
road on the
ಇವ್ರಿಗೆ
line.
layout approval ಕೊಟ್ಬಿಟ್ಟು ನಾವೇ alternate land 10,000 square feet ಕೊಡ್ಬೇಕು ಅಂತ ಹೇಳ್ತಾರೆ. How, I don't know.
Not, they say in the future, we want to widen the road, therefore you should.
If he wants
give
to
this.
challenge, my lord, let him challenge the endorsement, my lord, in a separate writ petition. This petition has become infructuous.
No, it will not become impetuous. The endorsement says only a condition is imposed. Not I will get it amended notes.
We're only talking about roads and parks to be relinquished.
Yes.
And
But
they're
that,
saying that road margin area should be in accordance with the Highways Act.
not that endorsement is not correct. Not. In fact, they wanted to leave the land for the future road widening.
ಆತರ ಬರ್ದಿಲ್ಲ ನೋಡಿ.
Vanilla, that I will not, that I will amend the
You
petition.
can challenge it separately. Why do you want to mix up everything?
I will,
With liberty notes, I will file a fresh petition.
The grave this petition was initially was for a direction. We issued a response to consider the representation dated 24/6/2024, by which the petitioner was seeking for allotment of an alternative site to the extent of 11,394 square feet, or for payment of compensation under the 2013 Act. A memo has been filed by respondents 2 and 3, stating that the said request has been considered and an endorsement has been issued on 25/7/2024. The light of the endorsement, it is obvious that the player and the petition do not subject for consideration. The petition therefore disposed of, holding that the petition become unnecessary, but liberty is reserved to the petitioner to challenge the endorsement dated 25/7/2024, if so advised.
Rule 31, Shri Manjunath. Shri Manjunath.
Week's time is granted.
Number 32, Srimati Lakshmi. I have correspondent to Lakshmi ji.
Appearing for petitioner. My lords, I'm challenging the notification, my lord. That is annexure G, my lords. My lords, with respect to the same notification, the coordinate bench already had passed an order, my lord, but the petitioner was different, my lords. I'm just producing the memo of the judgment.
What is the next year, Chief?
Corrigendum notification, my lords, page number 45, my lord.
Widening of the road.
Widening of the road, my lords. With respect to similar notification, the coordinate bench has passed in order.
Similar or same?
Same notification, my lords. But the petitioners were, are different, my lords.
I'll go through with this, my lord.
Page
Kindly have
number,
it on Monday.
please, my lord. It was a batch of petition, my lord. Unfortunately, this matter was not listed along with those writ petition. Page number 13, my lords. Page number 13.
You don't want TDR.
We don't want TDR, my lords.
Anytime next week.
No, simply follow this order in.
I'll leave it to my lords.
Your challenge is notification only insofar as it relates to the offer of TDR, isn't it?
Please, my lords.
But this notification is for widening the road. Where is it stated about the TDR rights?
My lords, earlier they had issued one notification, my lords. Unfortunately, we have not received that notification, even it's not with our record, my lords. And in page number 28, annexure D, in Rajapatra also, I mean, the petitioner name is not reflected. Later on, they issue
Next is a corrigendum to what?
corrigendum notification, my lords. Additionally,
What is the original notification?
my lords, we don't have the original notification, my lords. Even we inquired in the government office also, we have not received, my lords. Even we had made a representation with respect to the same, but we have not received any reply from the respondents, my lords. Representation with respect to annexure J, my lords.
Order late. Order. Judgment.
Order.
Tara? ಇಲ್ಲ, ಇದು ಅಫಿಡವಿಟ್ ಹಾಕಿದ್ರು ಬಟ್ ಇದ್ರಲ್ಲಿ ಅವ್ರು ಬರೀ ಅನ್ನೆಕ್ಸ್ಚರ್ ಜಿ ಚಾಲೆಂಜ್ ಮಾಡ್ತಿದ್ದಾರೆ. You have no objection for the acquisition.
My lords,
You have no objection for the acquisition.
we have an objection, my lords.
Because the third prayer in your writ petition is, madams direct the response to grant compensation to the petitioner in lieu of TDR.
My lords, that the respondent has to communicate, my lords. Till today, we have not received any
Your
reply.
prayer will contradict each other. If you are challenging the acquisition, you can't ask for compensation. And if you ask for compensation, you can't challenge the acquisition.
My lords, date may be given, my lords. I'll clarify, my lords.
Because you can't have it both ways.
Please, my lords.
Either you challenge the acquisition independently and stay with it. And if you fail, then maybe you can ask for compensation. But if you mix the two,
Please, my lords.
if I accept your prayer and this judgment,
Please, my lords.
all that I can direct is to pay you compensation. And thereby you are given the right to challenge the acquisition.
I'll seek for the clarification.
Number 34. Shri H.P. Leeladhar.
Who's R4?
People have to be done.
Yeah, R4 ಯಾರು?
R4 is owner of the property matters.
ನೀವ್ ಯಾರು?
Now is adjacent land, adjacent house of the owner.
By mistake.
It is state of in office to verify. Petitioner also permitted to take out notice on R4 personal service ತಗೊಂಬಿಡಿ ನೀವೇ.
Process ಕಟ್ಟಿದ್ದೀನಿ.
ಆಯ್ತು, ನಿಮ್ ಜೊತೆಲಿ ಇದನ್ನ ಮಾಡ್ಬಿಡಿ ನೀವೇ
ಹಾ.
ಮಾಡಿ.
Handsome. Please.
Number 35.
For petitioner, my lord. The violation of the building bylaws, my lord. The petitioner has seek information from the ADTP. And page number 23, my lord, that was issued the information 2/4/24.
no sanction plan was issued to the respondent number 7, page number 23, C1, my lord. C1, page number 23. That is information given by the ADTP to the petitioner. So on, sir. Second para, ಈ ಕಚೇರಿಯಲ್ಲಿ ಲಭ್ಯವಿರುವ ದಾಖಲಾತಿಗಳನ್ನು ಪರಿಶೀಲಿಸಲಾಗಿ ಬೆಂಗಳೂರು
B3 ಏನು ನೀವು ಕೇಳ್ತಿರೋದು?
annexure B3 minute, that is the dated 16/1/23 minute. That is prepared, the draft is 9/1/24 ಇದೆ. ಆ ಕೆಳಗಡೆ seal ಇದೆ 16/1/24. ಆ ಡೇಟ್ ನ ಕರೆಕ್ಷನ್ ಮಾಡಿ ಅಂತ, that is office objection, that may be over. Seal is issued by the BVMP ADTP on 16/1/24. And page number 23, it is information issued by the ADTP.
If I am not wrong, they have filed another writ petition 31816 by same
Another,
parties,
very same, correct.
where construction has been stopped already, my lordship. It is
Alla,
listed.
another petition is a separate site in respect of this survey number. This is the different matter. That is the writ petition 31816/24. That is posted on 21 this month.
Both may be connected. I will make my.
Both may be
submission.
connected. And in this case, the entire construction was stopped by this honorable court. Sanction plan and A kata, B kata, all is both.
ನೀವ್ಯಾರು?
I am the owner of the property. Why the partition suit is pending between the parties, my lord. Pendency of the suit, the no sanction.
ಅಲ್ಲಿ ಎಂಟ್ರಿ ಮಾಡ್ರಿ ಇಲ್ವಾ ನಿಮ್ಗೆ?
My lord, that is not alienation, my lord. This is the constructions in the property.
ಸರಿ, ಸಬ್ಜೆಕ್ಟ್ ಟು ದ ರಿಸಲ್ಟ್ ಬರುತ್ತಲ್ಲ ನಿಮ್ಗೆ?
My lord, in this case, my lord, the information given, I have filed the complaints, my lord, before the authority. Authorities have not taken action.
ಇದು ಈ ಪ್ಯಾರಲಲ್ ಲಿಟಿಗೇಷನ್ ಇಸ್ ಇನ್ಕರೆಕ್ಟ್. ಅಲ್ಲೊಂದು ಸುಮ್ಮನೆ ತೊಂದರೆ ಕೊಡುತ್ತಾನೆ ಇದೆಲ್ಲ.
No,
In case you succeed in the suit for partition, you will get the property also.
ultimately, my lord, in this
Then why
case,
do you want
my lord,
unnecessary?
in this case, my lord, the no sanction plans in this case. And my lord, the A kata, all are bogus, my lord. That is information, my lord, given by the.
ಅಂತ ಬೋಗಸ್ ಪ್ರಾಪರ್ಟಿ ನೀವು ದಾವ ಹಾಕಿದ್ರಲ್ಲ, ದಾವ ಗೆದ್ರೆ ಎಲ್ಲ ಬರುತ್ತಲ್ಲ. ಸುಮ್ಮನೆ ಯಾಕೆ ಒಂದಕ್ಕೊಂದು
My lord,
ಹನುಮಂತನ ಬಾಲ ಹತ್ರ ಬೆಳೆಸ್ಕೊಂಡು ಹೋಗ್ತಾನೆ ಇದ್ರೆ ಸುಮ್ಮನೆ.
my lord, after the construction, my lord, how can we, my lord? They are all, they will, they are constructed the properties without sanction plans. BBMP has to take action against them. ಅದ್ರಲ್ಲಿ ವೇಕೆಂಟ್ ಇದ್ರೆ ನಾವು ಭಾಗ ಮಾಡ್ಕೋಬಹುದು.
Take ಮಾಡಿದ್ದೀರಾ?
ಆ ಪಾರ್ಟಿ ಮಾಡಿದ್ವಿ, ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 7.
I don't understand this. You don't come out to take notice for respondents. 1 to 5. 1 to 6. You stated that the cleaners filed one more writ petition. But the 6th respondent is different than a 7th respondent.
That-
7th is different.
But petitioner is same.
Petitioner is same in the
It
both.
stated that the petitioner issue notice to 7th respondent. Petitioner is permitted to take out notice in addition by hand summons.
Both may be connected, my lord.
Both are connected. And number I interim order in this, that case, my lord, I published.
ಒಂದ್ರಲ್ಲಿ ಇದೀರ ಸಾಕ್ಬಿಡಿ.
ಅಲ್ಲ, ಅದು ಅವ್ರಿಗೆ ಮಾತ್ರ ಕನ್ಸರ್ನ್. ಇದು ಬೇರೆ ಸೈಟ್ ನಂಬರ್ ಇಸ್
ಅವ್ರ ಆಕ್ಷನ್
I
ತಗೊಂಡಿದ್ದಾರೆ.
will take instructions.
Number 36, Shri Kiran.
Please in this case, my lord.
ಕೋರ್ಟ್ ಫೀಸ್ ಕೊಟ್ಟಿಲ್ಲ.
ಕೊಟ್ಟಿದ್ದೀವಿ ಸುಮ್ಮನೆ.
ಯಾವಾಗ?
ನಿನ್ನೆ ಪೇಮೆಂಟ್ ಮಾಡಿದ್ವಿ.
Stated that the court fee is paid.
I filed a representation, submitted representation to the respondent seeking inclusion of father's name in the death certificate of my father. ನಮ್ಮ ತಂದೆ ಡೆತ್ ಸರ್ಟಿಫಿಕೇಟ್ ಅಲ್ಲಿ ಅವ್ರ ತಂದೆ ಹೆಸರು ಹಾಕಿಲ್ಲ.
ಇದೆ death certificate.
So death certificate is next appended in page number 12, annexure B. And it is covered by the reportable judgment of this court.
ತರಿಸ್ತೀರಾ?
Yes, lordship.
Next year, the name of the father husband is kept silent, is kept blank.
There has to be, inquiry has to be done, my lordship, with regard to that.
On what basis did you make this entry?
I will take his short accommodation.
You need the
Because
cash.
under rule 11, there is a provision for inquiry. And it,
Your father's name is Venkatesh, huh?
Father name is, I filed an election ID card. Timmayam. Father's name is Father name of the deceased is Timmayam.
Monday, my lordship, I will.
And disposed of Sumit, why do you want to keep it? He has produced the election card. And he has produced his other card.
Yes, my lordship, they have produced.
This is page number 13.
Kindly pass on. Yes, please.
Number 37.
Think for the petitioner, my lord. A week's time may be granted to take steps. my lord.
Number 38.
Copy, only objection, my lord, copy to be served, already served, my lord. My lord, to the office of BBMP. My lord, alteration and additional construction over the existing building made by the third respondent, who is the adjacent property owner. And now he is trying to put up construction over the setback area, my lord, towards my side. Without there being any plan and license from the authorities. Annexure, my lord, I have produced the photographs, annexure D1, kindly turn to ink page number 43.
ಮುಗಿಸ್ಬಿಟ್ಟಿದ್ದಾರೆ ಆಗ್ಲೇ.
ಅಲ್ಲ ಇನ್ನ ಇದನ್ನ ಹಾಕ್ತಾ ಇದಾರೆ ಅವರು.
ಆಗೋಗಿದೆಯಲ್ಲ ಎಲ್ಲ.
ಅಲ್ಲ ಸರ್ವೆ ಎಲ್ಲ ಕಟ್ಟಿದ್ದಾರೆ, ಮಾಡ್ತಾ ಇದಾರೆ ಇನ್ನ. 43.
You want to fight with your neighbor?
My lord, in the first instance also, my lord, the writ petition has been filed. Later, my lord, he removed the projection.
Notice for respondents 180. You notice to R3, petitions permitted to take out notice on R3 personally, realist.
Till then, my lord, interim order.
Sir, ಮಾಡ್ಕೊಂಡು ಬನ್ನಿ.
31st. Number 39.
Sir.
Ground matter, my lord. Ground rent matter.
Reserve ಆಗಿದೆ. Reserve ಆಗಿದೆ.
Yeah, it is.
Post of disposal of. Pawan Kumar is take notice.
Annexure claim, 85.
AG to take notice for R1 and R2. Subjection be complied with. What fee ಕೊಟ್ಟಿಲ್ಲ?
Court be cut my lord. Okay.
Number 40. Shri Shagar V. Shastri.
Please, Your Honor. Now, the petitioner who has the purchased the, not office objection is, not without impleading the petitioner, my lord, appeal came to be filed before the executive officer, Taluka Panchayat. Khata entered based on the sale deed has been cancelled.
Subjection kept open. What is annexure H?
Annexure is, H is the order passed by the Taluka executive officer. Kindly go to my lord, ink page 72. I have not been made as a party. Based on the 2022, my lord, sale deed, my name has been entered. As per annexure C, I have annexure C, kindly see.
Father stands in your name.
Yes, that has been cancelled without impleading me, my lord, without giving any opportunity.
Notice for R1. Who appears for R2 and R3? MS. MS Devraj, they will take notice for respondents 2, 3 and 4. Issue notice to R5 to R8. Till the next date of presentation, interim stay of annexure H.
Please, Lord, may I pray for hand delivery? Please.
Number 2 for orders. Seal number 1, Shri Satish Babu, yes. List number 2.
Neda.
List number 1 for hearing on IA.
Yes.
List number 2.
List number 2, seal number 1.
My lord, the sixth respondent has commenced the unauthorized construction in the without obtaining the license and the sanction plan
Who appears for the sixth respondent?
on January 2024.
Who appears for the sixth respondent?
Vyasatirtha.
Preparing for R6, madam.
Yes.
Once I have obtained all the necessary plans, I have filed along with my vacating application. I'll take my lord. For the bill.
What was your complaint that they should take action against?
There is no any action taken against the,
You are the brother or sister of the sixth respondent.
she is the GP holder.
Yeah, who is the GP holder? How are you related to this?
Respondent number 6, he is residing abroad.
How are you related to him? ಸಂಬಂಧ ಏನ್ ನಿಮ್ಗೆ ಅವ್ರದ್ದು? How are you related to the sixth respondent?
I'm the son.
R6 is your mother.
Yeah.
And you have filed
SP,
a
SP
petition-
holder is the mother.
and you filed a reputation against your mother.
Respondent number 6, she is a sister here. Respondent number 6 is the sister, my lord.
Sister.
Yeah.
You
She
are
is not,
content-
she is not obtaining any license from the January 2024. She is constructing the unauthorized construction. my lord. After that, the BBMP, I have issued the notice on 17th January, 31/1/2024. Till the 2/2/2024, 14/5/2024, and 14/5/2024, annexure A to,
Have you seen his objection? Have you seen his objections?
my lord,
Have you seen the objections filed by your brother? The objection, they produced the plan for having obtained.
there is no plan as not filed. There is no sanctioned plan as not.
There is, my lord, at page 37, my lord, for a moment, annexure 2. Along with my vacating application.
Which date?
5th February 2024, my lord,
February 24.
page 37.
They have constructed the
The payment
construction
receipt,
on
my lord.
17/1/2000, 31/1/2025, my lord. But they have produced the sanction plan on 5/2/2024.
Page 40, annexure A4, my lord, building license. 2nd July 2024.
They will hold that since they now have a plan.
I have my plan.
No, no,
It's not for, will not survey for consideration.
no, no.
They have produced a plan. No.
My lord, they have constructed the plan on, they have constructed the construction on 31/1/2024. But they have taken on the plan on 5/2/2024 as per their record.
Plan ಇದೆಯಲ್ಲ.
ಅಲ್ಲ ಸ್ವಾಮಿ, ಕಟ್ಟಿಬಿಟ್ಟು ಆಮೇಲೆ ಪ್ಲಾನ್ ತಗೊಂತೀನಿ ಅಂತ ಅಂದ್ರೆ
It's permissible.
ವೆದರ್ ಇಟ್ ಇಸ್ ಪರ್ಮಿಸಿಬಲ್.
It's permissible. Even if they were to construct without a plan, they can always seek for approval when they raise an objection.
ಆಫ್ಟರ್ ದಟ್ ಡಿವಿಯೇಷನ್ ಇದೆ ಅಂತ BBMP ಡಿವಿಯೇಷನ್ ಡೆಮಾಲಿಷನ್.
That they will take action. Your prayer will not survive. Your prayer is only to take action because there's no plan. Now there is a plan, your prayer will not survive.
ನಾನು ನೋಡಿಲ್ಲ ಅದನ್ನ ನಾನು
Post this threat petition, and you do whatever you want afterwards.
Okay.
The prayer in this petition is for issuance of
ಆಫೀಸ್
protection
ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಕಂಪ್ಲೈಂಟ್ಸ್.
to the PPMP to consider the legal notice and the representations on it, in which it was contended that the sixth respondent was putting the construction without obtaining a sanction plan. The sixth respondent has filed an application for vacating stay. And along with this application, he has produced the building license which has been granted by the BBMP. Date ಇದೆಯಾ ಅದಕ್ಕೆ?
2nd July 2024.
ಫೈಲಿಂಗ್ ಎ ಮೆಮೋ.
Second
Page
July.
40 and 42.
Date ಕಾಣಿಸ್ತಾ ಇಲ್ಲ ಇಲ್ಲಿ.
I'm filing a
The
memo.
prescribed fee
with
for
certain,
building plan sanction and
citations and all.
intimated demand date notice dated 1st July 2024 is limited by the para 2, my lord.
These are the payment details. Again, date ಕೊಡಲ್ವಾ?
Page 42, ಕಟ್ಟಡ ಪರವಾನಗಿ ಪತ್ರ.
My lord, I'm filing a memo.
Next
along
page,
with
my
that.
lord.
What citations?
Date ಹಾಕಲ್ಲ.
Actually, in the sanction plan, their date will be there, digital signature will be there.
Dated 6th of July 2011. in view of the fact that the petitioner has produced the building license, it is obvious that the request made by the petitioner to consider his representation, which was based on the premise that there was no license, would not survive for consideration. That way, the matter of the petition is dismissed and will become unnecessary. What is this?
The guidelines of the Supreme Court, my lord, the paper publication and the citations are.
You think that they are proceeding with the construction in violation of the sanction plan? Issue a fresh complaint and do whatever you want to do.
File the writ of mandamus, my lord.
Mandamus was to consider your representation in which you had stated there is no building plan. Now that there is a building plan, that prayer will not survive. Do whatever you want to do. Anyway, you want to fight with your sister, brother, isn't it? Sister.
In fact, the proceedings have been taken place under 248, 1, 2, and 3. That is also been done. That may kindly be noted, my lord. ಅಲ್ಲ 248 proceedings culminate ಆಗಿ 356 ಇಶ್ಯೂ ಮಾಡಿದ್ದಾರೆ.
ಚಾಲೆಂಜ್ ಮಾಡಿದ್ರೆ ಮಾಡ್ತಾರೆ ಬಿಡಿ.
But action ಮತ್ತೆ mandamus ಇನ್ನೊಂದು litigation.
After
That may be noted, my lord. We have taken note.
Even though order has been passed, the affidavit was filed before the honorable court. The contempt was also
Enjoy litigation.
made by the.
Not only you will enjoy litigation, these clients also will enjoy litigation. Isn't it?
Obliged. This one for hearing on IA, seal number 41. Great, sir. Shri Bharat Muralidhar.
Petitioner, my lord, had filed this petition for questioning the Nala construction by the BBMP on the boundary of my site, my lords. It's been a year since I have been in touch with the client, my lords. I'm seeking a short accommodation, maybe put up in the next week.
Go file a suit. Why should you come to this court? Can I determine whether the construction is in your property or in their property?
My lords, my property boundary, my lords.
Can I decide that does it not require evidence?
Yes, my lords.
File a suit. Why do you want to keep this petition pending?
My lords, 1 week, my lords, short accommodation.
In fact, there are 2 reports which were already filed by the ADLR, please, my lords, which
My lords, will check.
discloses
First, I
that
give a finding that the report of the ADL.
My lords, the BBMP is still constructing while the pendency of this matter, my lords. We want to inspect the
Your remedies to file a suit. You can't, I can't give a determination in the writ petition as to whether there is an encroachment of your property or not.
Please, my lords.
they are not claiming
Asking for
that
a
the
short
ala has
application, my
been
lords, I'll get
existing in their
instruction.
property, my lords, in the boundaries of their property.
My lords, it may be held up in the next week.
The list.
17.
Grateful.
Seal number 42. Shri S.V. Giridhar. Seal number 42.
Giridhar. In matter.
And matter pertains to where they are saying that we have formed the road without acquisition. It was heard earlier and we have given them an offer also.
Do not acquire this land.
No, because there was a Kaldari and that was used for landfills, my lordship, for the garbage. We have our landfills which passes on, the road passes through the, some portion of the property of the petitioners. It is to be,
Extent.
yes, my lordship.
What is the extent?
Extent are different, my lordship. My lordship says when memo was filed, their extent was also.
Ready ಇದೀರಾ?
Yes, my lordship.
Passport ready ಇದೀರಾ?
There's some, needs to be heard, my lordship. I pray for some time. And when the offer was given to them for direct purchase, but they refused it. Then some proceedings. were established.
17. Number 43. Shri K.V. Narasimhan.
My lord, week's time, my lord, to file the objection to the impleading application filed by the impleading.
Who wants to be impleaded?
My lord, one Krishnappa,
This is application filed by the impleading applicant, not by us, my lord. It is read as filed by the
Why
petitioner.
does he want to get himself impleaded?
My lord,
Why does he want to get impleaded?
my lord, we have objection to his impleading application.
Why does he want to get impleaded?
My lord, he is a complainant, my lord.
Then I'll allow the application.
My lord, one objection, we'll file the objection, my lord. Let our objection come on record, my lord. Maybe posted on next week.
I'll note your strong objections and then pass them. What is the order impugned?
My lord, it is a notice issued by executive officer for demolition of construction.
For initiation of proceeding, you have issued a notice.
My lord, my contention is the executive officer is not authorized to issue the notice.
On the basis of your complaint, this had been done.
No, R3 is mine.
The new complaint put it,
ಇಲ್ಲ
Alla, before Lokayukta, they made a complaint, my lord.
They made the complaint.
They made complaint. Krishnappa made a complaint.
It is noticed that the impugned order is an outcome of complaint to the third respondent. Linked with the Lokayukta, who had in turn made recommendation in section 12(1) of the act. On the basis of which the impugned notice is issued. It would therefore be necessary to implead the third respondent who was the complainant. Then consequently, this over seeks time to file objections. In my view, there cannot be any objection for the pleading of the complainant, the basis of which the empty complainant, the basis of which the impugned order has been passed. Post and view group, first it will be amended.
My lord, interim order may be extended.
Remote continue.
Bill number 44, Srimati Deena.
Filed an IA for
Petitioner, Your
vacating the
Lordship.
interim order. Just, my lords.
What is the interim order granted?
The interim order granted is not to construct on the property, my lords. Now, what has happened is, this is a suit filed by the Residents Association. It is a surrogate proceeding, my lords, to lay stake on the land of the original erstwhile landowners. If your lordships kindly sees,
Interim order in force for the past 4 years.
my lords,
Interim order in force for the past.
Illa 15/9/2023, they kept the file pending, my lords. They filed it on 27 February 2020. Till September 2023, they do not move the file. If your lordship sees, the interim order date is 15/9/2023. They do not move the file, my lords. For 3 years, they keep the file pending. And immediately in September 2023, they move the file, they suppress facts before this honorable court, obtain an interim order.
On submission, Your Lordship, we are an apartment owners association.
What is your prayer?
Your Lordship, a small brief, Your Lordship, actually, we are an association and the project was completed in 2010. Occupancy certificate also was granted.
Please consider your complaint dated 25/9/2019.
The project was completed in 2010. We all have occupied in the project. After 12 years, they filed an application before the BBMP for giving an approval for constructing a 3-storied building inside our complex, Your Lordship.
Inside Allah.
Inside, of course, inside our complex, Your Lordship, and I have approached the court and an injunction is granted against them. Even after the injunction, they have gone ahead with the payment of the court fee.
You are challenging the land that was sanctioned in the year 2018 after a period of 3 years.
No, Your Lordship. 2000, Your Lordship,
See your prayer first.
yes,
Your complaint is of the year 2019. The land sanction is of the year 2018.
consider the no, Your Lordship, we have sent a letter, you and T actually, T and you
Waited-
is a representation letter, Your Lordship.
Waited for 3 years.
No, Your Lordship, immediately we have approached the civil court. Civil court has granted an injunction. After that, we came here for a direction to the BBMP to cancel that. Immediately we approached here. 2018 is the sanction. 2000,
What is your complaint? What is your ground for attack?
Your Lordship, this 2010 project, 2007 project, we all have occupied. It is around 312 units. After 12 years,
what they did in the sense, an area which is earmarked, which is reserved for STP, in 2010 itself, they removed that STP area and placed the STP in somewhere else. And now after 12 years, they are coming back by saying that it is their property.
Where is your sale lead? Do they indicate the adequate interest of the entire
Yes,
land, including
yes, Your Honor.
the STP portion?
Yes, the entire Schedule A property is 2,35,000.
Where is the plan that is approved in favor of the project?
Annexure D63.
Annexure D is the old plan.
That is the modified plan which was executed, my lords. The original plan.
Modified plan, Your Lordship. Annexure D is the one which they had obtained
Correct.
in the small.
63, my lord. 63 of the writ petition. Now, my lords, if your lordship sees 63.
Sale deed is annexure H, Your Lordship, page number 70.
You have a smaller plan with you?
Smaller plan, I will just. A3 will be there.
In fact, there are two stays, Your Lordship.
My lords, I have a smaller plan. Yes, I have submitted, my lords. My lords may kindly see that for a moment. I will just demonstrate to your lordships what they are seeking to lay claim upon.
Where is the STP here?
My lords will kindly see at the top right, STP anta heli vandu right side portion nalli.
Harvesting ಅಂತ ಇದೆ.
Rainwater harvesting ಕೆಳಗೆ STP anta ಇದೆ. If your lordship sees. Adralli, a lordships will also see
Sir,
a rainwater harvesting ಕೆಳಗಡೆ, third box below rainwater harvesting, if your lordship sees.
So this is a part of the project.
It used to be, my lords. What has happened, my lords? This was also called as an owner's reserved area. Madhyadalli one road bantu. If your lordships kindly sees one photograph, it makes it very clear.
In this sale deed,
Illa, this is not included because this was excluded as part of the owner's reserved area. Even in the plan, my lords will kindly see for serial number 4.
when it's reserved area.
ಹೌದು.
For owner's reserved area is the apartments that will be given to the owner, isn't it?
ಅಲ್ಲ ಹಂಗಲ್ಲ ಅಪ್ಪ, ಇದು ವೇಕೆಂಟ್ ಲ್ಯಾಂಡ್. ಬಿಕಾಸ್ ಮಧ್ಯದಲ್ಲಿ ಇಡೀ ಪ್ರಾಪರ್ಟಿ 5 ಎಕರೆ 16 ಗುಂಟೆಲಿ ಮಧ್ಯದಲ್ಲಿ ಒಂದು CDP ರೋಡ್ ಇತ್ತು. ಇದು 2007ರಲ್ಲಿ ಇನ್ನೂ ರೋಡ್ ಆಗಿರ್ಲಿಲ್ಲ. At that point in time, the CDP had just come into force, my lords. Because of that aspect, the CDP road had not happened. We had to leave that area and construct. Therefore, my lords, I could not put up a sewage treatment plant and a rainwater harvesting across the road for an apartment which is constructed on the other side of the road. Kindly see one picture. It makes it very, very clear, my lords. I've produced it as part of my objection statement.
That the road is not going to be formed.
ಅಲ್ಲ, ರೋಡ್ ಫಾರ್ಮ್ ಆಯ್ತು, ಕೊನೆಗೆ ರೋಡ್ ಫಾರ್ಮ್ ಆಗಿದೆ.
Your Lordship.
2010 ನಲ್ಲಿ it is an asphalted tarred road formed by the BBMP. Now my lords will see this one picture. If your lordship sees, this is a vacant property on the other side of the road.
The part of the project, isn't it?
Yes, Your Lordship.
My lords-
Page number 61, Your
My
Lordship.
lords, this was not conveyed as part of the UDS that is conveyed to them. Kindly see, my lords, ಅವರೇ ಮಾಡಿರುವಂತ DOD ಇದೆ.
Deviate from this plan, you seek for modification of this.
We have sought for a modification. What has happened, my lords? Previously, it came within the BDA jurisdiction. ಇದು BDA issue ಮಾಡಿದ್ರು.
This plan was approved on the basis of the entire extent of this particular area. In
5 acres, 16 guntas ಅಂತ ಹೇಳಿ.
the area in which STP was shown,
But there was no construction, no built-up area there.
or not, the built-up area that was permissible or that was permitted was on the basis of the entire extent of land.
No, ಇಲ್ಲ, because my lords will kindly see serial number 4 in that table. ಅದನ್ನ separate ಮಾಡಿದ್ದಾರೆ. ಪ್ಲಾನ್ ಅಲ್ಲೇ separate ಮಾಡಿದ್ದಾರೆ. If your lordship sees site area analysis ಅಂತ ಹೇಳಿ ಮಧ್ಯದಲ್ಲಿದೆ, ಅದರಲ್ಲಿ serial number 4, my lords will see.
Who appears with the planning authority? Neeva.
This is the development plan, my lord. Now their contention, my lord, they have shifted by obtaining the permission from the license from the BBMP. They shifted the,
No, I want to know when they put up this apartment.
Yes.
Did you grant them the built-up area in, by considering this owner's reserved area or apart from that?
Apart from that, my lords.
No, your
The
lordship.
FAR that is
All of you can talk, I can't really.
No, that is a wrong submission, clearly wrong
The
submission.
planning authority.
Yes, Your Lordship.
my lord,
If this built-up area that was granted to them under the plan
yes,
is by including this area in which STP was shown,
that is including,
can't change the plan.
no, that is included in the plan itself, my lord.
The development plan. This is a part of the development plan.
This is a part of the, my lords may kindly see two aspects, my lords. Idralli, ಈ site area analysis ಅಲ್ಲಿ, the net site area that they have arrived at, my lords, for the purpose of computing the floor area ratio, is dehors this particular area that was there on the other side of the road.
How can I?
My lords will kindly see the site area analysis here. 5 acres 16 guntas ಅಂತ ಹೇಳಿ. In the middle of the page, my lords, ಅದರಲ್ಲಿ ದೊಡ್ಡದಲ್ಲೇ ನೋಡ್ಬೇಕಾಗತ್ತೆ. ದೊಡ್ಡದು ಕೊಡಿ.
Which plan?
Condition number 10, my lord, in the right side, plan ಅಲ್ಲಿ.
Oh, you see column number 5, Samir, it says 1 minus 2 plus 3.
ಹೌದು, 2 plus 3. I am
Plus 3 is the reserve for proposed road.
ಹೌದು. 4
So,
is the extent.
4 was not taken out.
My lords will see
Let's say
2 plus 3 plus 1104 ಅಂತ ಹೇಳಿ ಅದ್ರ next ಗೆ 4 ಅಲ್ಲಿ number ಇರೋದು 1104.
That is also taken into consideration.
That is not taken into consideration, my lords.
Net set area is 1 minus 2 plus 3 plus 1104.
ಅಲ್ಲ, if your lordship
Purpose
see,
of computing the FIR, this 1100 square meters is also taken into consideration.
now if your lordships kindly sees this one ನಿಮಿಷ, sorry. This entire aspect, my lords, we could not build it because of the road area. Now,
That
the,
is a different aspect. That extent, they did not take the road area for the purpose of computing the FIR.
ಹೌದು.
Now the road is formed.
Alla, even this area also in the occupancy certificate, when we went later, my lords, this has been regularized. I have furnished it with the memo because
Get the regularization.
ಅದೇನಾಗಿದೆ ಅಂದ್ರೆ we had not built the additional area that we had proposed to initially build. We could not build as much, my lords, of FAR because the entire area got reduced. If your lordships kindly sees the notings in the occupancy certificate, which is of the year 2010 itself, it makes it very clear. I produced it along with a memo. Now, may I just point it out to my lords? ಅದರಲ್ಲಿ ಕಂಪ್ಲೀಟ್ ಇದೆಲ್ಲ ಶಿಫ್ಟಿಂಗು ಏನೇನಕ್ಕಾಗಿದೆ ಅಂತ ಹೇಳಿ detailed reasons are there, my lords. This area originally was within,
Total built up area according to you.
my lords will see. No objections. Lords, the total site area, my lords, is 5 acres 16 guntas, out of which, my lords, the conveyed area,
The occupancy certificate is given for how much?
howdu, 204,927 square feet or 19,038 square meters.
That's the.
Alla, adu sanction plan. If your lordships are seeing the sanction plan, subsequently the occupancy certificate is issued. That is there, my lords. That is also made a part of the
Page
annexure
68.
G.
No, I'll assume for a minute that there you were not able to put up the full construction as per the approved layout plan.
Approved.
Suppose you are not able to construct, can you go against the other area and
Alla.
put up, make up the deficit?
Now, my lords, what has happened is that area could not be constructed at that point in time.
So then,
Now, that area is a vacant land, my lords. It is across the road. It is a vacant piece of land. If your lordships kindly sees the photograph, for a moment, my lords may kindly see the photograph.
itself indicates it is vacant.
My lords,
The plan itself indicates it's vacant. One is for rainwater harvesting, the other is
then I had to shift it within the other side of the road itself, where the building is constructed. There itself, I have shifted it with due permissions.
You execute a sale deed, you execute a sale deed of undivided interest in respect.
Yes.
to-
Without, my lords, without. That is why I'm just pointing.
That can't be because the plan itself is including the.
ಅಲ್ಲ,
owner's reservation.
ಅದಕ್ಕಾಗಿ we have made a specific provision in the sale deeds also. My lords may kindly see the sale
What
deeds.
do you mean by owner's reserved area? Are you saying that the owner can develop it afterwards?
That portion, remaining area of the property,
ಇಲ್ಲ, ಅದೇನು owners reserved area ಅಂತ ಹಾಕಿದಾರಲ್ಲ.
the owner,
Does it mean that
For future development ಅಂತಾನೆ ಇದೆ ಇನ್ನೊಂದ್ರಲ್ಲಿ.
ಅದು separate ಆಗಿ ಬರೀತಾರೆ ಅವಾಗ RFD ಅಂತ ಮಾಡ್ತಾರೆ. They don't do that.
My lords,
Did that you can allow the owner to use it?
ಇಲ್ಲ ಇದರಲ್ಲಿ, ಇದೇ plan.
now what has happened, my lords, this is a question of two planning authorities taking over. 2007 ನಲ್ಲಿ originally it came within the BDA's jurisdiction, my lords, because it was not part of the 110 villages. Then in the year 2007, 110 villages notification came.
BMP became BBMP. Then this particular property came within those 110 villages. It came within the BBMP's jurisdiction. BDA was the original plan sanctioning authority in the year 2007. Subsequently, in the year 2010, BBMP became the approval relevant authority. Subsequently, my lords, the occupancy certificate was obtained in accordance with the BBMP bylaws, whatever was there in the BBMP bylaws. After regularizing the deviations and after regularizing this particular aspect of movement of the STP and RWH across the road inside the building campus itself. Now, my lords, this area that was on the right-hand side, which your lordships are seen in the plan, was always vacant. A road separates it. It is a vacant piece of land, even as of today, my lords. This area was reserved for owner's future development. It was never
What is the meaning of owner's future development? Are you the owner or the developer?
My lords, I am the developer who has entered into a joint development with the owner.
So you have no right over this particular property. This is reserved to the owner.
How do they have entered into a joint development with me only, my lords. This is of the year 2007 itself.
2005.
After this, according to the JDA, you sought for approval, you got an approved plan.
Howdo.
In which a particular portion is reserved for owner's use.
Howdo.
Yes, sir. Obviously, you cannot have any claim over that.
Illa.
If anybody has makes a claim, only with the owner.
The owner, my lords, has given me the joint development. The owner is with me. The owner is with me, my lords.
After this plan,
How do?
is there a fresh agreement with you?
My lords?
No, my lord is, it is entered into the along with the 5 acres and that. Joint development is,
If I go by the nomenclature in the plan, this particular area is reserved for your use.
yes, brother.
They cannot make an application for modification in the scope of your area. Once the plan says owner's reserved area, if the BBMP says, all right, it's owner's reserved area, you can do whatever you want with it, that's a different thing. But either way, Summit's client can't come and say, I'll seek for modification of the plan and use this particular area.
Yeah, my lord is, it is a joint
ಅಲ್ಲಲ್ಲ
development.
ಅವ್ರ ಹೆಸರಲ್ಲೇ ಅಪ್ಲೈ ಮಾಡಿರೋದು. And we, my lords, the owners do not have a dispute with us.
Dispute. There
It
no
is the flat purchasers.
Who made the application for approval for modification?
It is made in the owner's name with me as the GPA holder, my lords. With me as the GPA holder, because contemporaneous with the joint development agreement, a GPA was also executed in my favor.
Where is that application that you gave for?
There is a separate
modification?
proceedings. was,
My lords will kindly see that is also part of the writ petition itself.
Your lordship may submit.
I'll come to you. I'm just getting my doubts cleared here.
Yes, my lords. My lords will kindly see that the impugned sanction, my lords, is at Annexure D, page 63. 63 nal tav nodbodu.
This is the original plan, isn't it?
Sorry, this is the, sorry, my lords, this is the original plan.
2007 plan.
Annexure, my lords, the Annexure A and B. Annexure A and Annexure B is what is under challenge, page number 29.
Who has executed, who has approved this? BBMP.
The BBMP, now the BBMP is the sanctioning authority, my
BBMP. My lord, I approve. The owner's reserved area ಬಿಟ್ಕೊಡಕ್ಕಾಗತ್ತಾ?
Hello, my lord, as far as when occupancy certificate was first issued, my lord, there was a modification of the original plan.
ಹೊಸ ಪ್ಲಾನ್ ಹೇಗಿದೆ? Proposed residential.
My lords will see it's N Hanumanta Reddy, building license page 29 nalli, N Hanumanta Reddy GPA holder by Messrs Kirti Estates Private Limited anta heli.
This particular plan is exclusive in respect of the remaining area, correct?
My lord, the plan which is under challenge, my lord,
Now, the original plan was showing those owner's reserved area.
please, my lord.
For what was the owner's reserved area and on what basis did you consider this application afresh?
My lord, when the application was first given, my lord, for the extent, for the entire extent, my lord, that was issued by the BDA. Subsequently, it fell within the jurisdiction of the BBMP, for
doubt-
which, my lord,
The doubt that I have is this, when the apartment approval was granted for the first time,
please,
it included your area for determination of the FIR and for permission to have X amount of building area.
that was given by the BDA.
Now, once the built up area is given,
Please, my lord.
then that particular land cannot be used. Because the moment a building is allowed to come there, the built up area, the FIR will be violated in the original plan.
Please, please.
So how did you deal with that issue?
Subsequently, the
while giving the occupancy certificate, they produced another fresh plan, which I have considered. How can you give the fresh plan? Because the first plan, please, was taken into consideration this particular land area for determination of the built-up area. Please. My lord, this happened in the year 2010 when the STP and the rainwater harvesting, my lord, they had. You didn't get my point. Suppose the land is 10,000 square feet. Please, my lord. On that basis, FIR is calculated. Please, my lord. For the purpose of calculating FIR, in this original plan, please, my lord, this particular owner's reserved area is also included. Please, yes. So therefore, his built-up area cannot be in excess of this particular area granted to him under the year 2006. Please, my lord. How can you grant a separate plan, thereby increasing his built-up area in this particular area? No, I have not.
If I may answer, my lords, for a second, if I may answer and clarify. My lords, when I went for occupancy certificate, I have to submit an as-built drawing, my lords. Because the usual norm with the BDA or the BBMP is, once a plan is granted, you either obtain a modified sanction plan if you need modifications in the plan. However, because of the change in authorities, my lords, I was not able to obtain a modified sanction plan. Therefore, when I went for occupancy certificate in the year 2010, I showed them this modification, the impracticality of putting up the STP or the RWH in that side, or utilizing that FAR, and therefore my FAR, my lords, what was initially conceived also I could not achieve. And there only after, my lords, I have constructed only a limited portion. In that 5 acre 16 guntas, I have left out about 1,000 square meters of land. And subsequently, excluding that 1,000 square meters or 990 square meters, I have constructed, and that FAR is computed only in respect of the area excluding 990 square meters.
Not correct from
That is there, my lords, in the final occupancy certificate noting Ali.
For the original approved plan, that area is also included for calculating FAR.
It was, my lords, but I had not been able to construct as per the originally approved plan. I had made modifications, and that modification has been ratified.
Total area that you are permitted to build.
My lords,
What
may
total area that you build.
yes, my lords. May I just point out the total permitted area as per Annexure D, my lords, will see. No, the old plan. Adರಲ್ಲಿ the entire plan is contained, my lords. Area abstract sheet contains FAR calculation. Everything is computed in that.
This 26,884 square feet.
Yes, my lords. If your lordship sees the net site area FAR calculation anta heli adu right side bottom corner alli ide.
26,884 square meters anta ಹೇಳಿ.
Total FAR area 26,884 square meters.
This 26,884.
I was not able to achieve, my lords. I was not able. From 312 flats, whatever is shown, total number of units, my total number of units.
Where do I get that you're not able to achieve?
Yes, my lords. That is there in the occupancy certificate subsequently obtained. Occupancy certificate I have produced along with them. If your lordships kindly sees, they have produced it along with a memo, and it is filed in open court on 29th July, my lords.
OC is in page number 68. Your lordship.
And annexure A, the figure is different, Samit.
My lords.
It says FAR.
Because all this clarification has now been given in the occupancy certificate. Kindly see that occupancy certificate note, my lords, that has the entire calculations, computations, everything.
Back to annexure A, there is a tabular column indicating existing apartment building area as per occupancy certificate issued from BBMP.
Annexure A is the impugned plan, my lords. That is not the original plan. Annexure A is the presently 2018 plan, though.
2018, there's existing apartment building area.
Yes, my lords.
That is the earlier building existing.
Yes, my lords.
And the third column is combined area state. At the bottom, there are three.
Yes, my lords. A combined area statement is 21,890. ಹೌದು, combined area statement if you
ಅದ್ರ ಪಕ್ಕದಲ್ಲಿ existing apartment building area, it's for occupancy certificate to BBM,
Yes, my lord, that is 20,829 square meters.
45,358 square meters.
ಅಲ್ಲ 40,000 ಅಲ್ಲ, if your lordship kindly sees. ಈಗ ನಾವು combined area statement if your lordship.
Combined area ಇವಾಗ building ಸೇರಿಸಿ.
ಹೌದು.
You said there was a deficiency.
ಅಲ್ಲ, ಅದಕ್ಕಾಗಿ if I may just point it out to your lordships that OC contains that OC.
That is what is recorded here in this tabular column. That is the title, existing apartment building area.
ಹೌದು, site
As
area,
per-
if your lordships may kindly see the site area that is mentioned. Site area is 20,829.32.
Yes,
Out of the original 21,000 odd.
that's why I said you're wrong, because when they granted you the original plan, it was on the basis of land area of 21,000.
Original was, yes, my lord. I do not dispute that for a moment, my lord.
You are now trying to take advantage of the fact that that 1,000 square feet has remained vacant. And you're saying that, no, I've actually. built
Illa,
upon-
because I could have utilized the FAR only that was available for 20,890.
You could have used FIR on the basis of 21,000 square meter site area.
I could have, my lords, but I did not.
You can't reduce the site area by way of another plan.
By way of other plan, I have not reduced the site area. What has happened, my lords, this is only a modified plan that I have sought for. Because of the simple fact that I could not use it since the road came in
Use
between.
it or not, you could not have used it because of the specific marcation made in the plan.
But I have not utilized that FAR at all, my lords.
But utilize it.
I have not utilized that FAR at all.
If you want, you cannot utilize it because it is earmarked for two purposes.
Howdu?
And that area is also taken into consideration for the purpose of computing the built-up area.
Originally, it was taken into consideration, my lords. However, when we modified the plan
Can
because of the
consider your
road.
request only if you show, assuming that 21,000 square feet, including the owner's reserved area, there's a deficiency in the built-up area.
Howdu, ಅದಕ್ಕಾಗಿ I will demonstrate it.
What you are doing is, you are now reducing the area by 1,100 to 104 square meters and saying that FIR.
FAR itself, FAR computation, if your lordship
You
sees,
didn't understand the point I'm trying to make. If you were to include the entire 5 acres 16 guntas, including the owner's reserved area, show me the total extent that you are permitted to build under the original plan.
my lords, I'll give a tabular statement. If your lordships may have it tomorrow, I will give a detailed tabular statement
Not
along
for-
with,
Wait,
one date may be fixed, my lords.
One submission, your lord.
My lord.
I asked them to verify whether they can, what is the meaning of owner's reserved
Yes,
area?
sir, I will.
What should happen and whether the BBMP can thereafter modify the approved layout plan.
Yes, sir.
In this, from what he says, owner's reserved area, theoretically speaking, the owner can again apply for approval.
Yes, that I will get to.
So that I don't think they can come and have any grievance.
Yes, sir.
But if that is taken into consideration for the purpose of computing the built-up area, then there is some difficulty.
Yes, sir, I will.
As far as the legality of this structure is concerned.
Yes.
ಇಲ್ಲ, I will demonstrate to your lordships that FAR, my lords, what was finally ratified and occupied.
BDA says that the owner's reserved area is permitted to be used by the owner subsequently. This approval will be.
Now, my lords, the plan sanctioning authority after 2007 has changed to BBMP, my lords.
The bylaws are the same. The law is the same.
ಇಲ್ಲ,
But
ಅದಕ್ಕೆ
the BBMP cannot overcome the resolution made by the original plan.
the BBMP cannot overcome, my lords, but the ratification as per the 2010 happened as per the building bylaws 2003.
If there are new building bylaws, the earlier plans can't be
ಅಲ್ಲ,
modified.
ಇಲ್ಲ, the earlier plan was also granted in terms of the building bylaws, my lords. What has happened is BDA did not,
But your proposal is, your project is safe if BDA were to say that this owner's reserved area, they can use independent of the original plan.
very well, my lords. I will also
Not
give a
have to go through
computation.
all
I
this.
will also give a computation, my lords, because this area was never computed for the
That is
purpose
the
of
second
FAR.
part. If the first part you succeed, you don't have to worry on the second.
Very well, my lords.
If it is reserved for an owner's future development and it is permissible for that area to be used independent of your apartment, you will have no grievance. You can't have any grievance.
Your lordship, what did they show to me? That is 5 acres, 16
What they
gunta.
showed to you, what you understood is
No,
different.
your lordship, sale deed, it is my undivided share is calculated on 5 acres, 16
But
gundas.
The approved plan indicates it was reserved for the owner's future use. You will have obviously no right over that property.
No, your lordship, but they have calculated my UDS in the entire land area.
You have,
And now they are coming back
No.
by saying that it is theirs,
Sure.
that too after 13 years.
you are bound by the original plan.
Yes, your lordship.
In the original plan, if a particular area is reserved for the owner's future use, The apartment owners will get no right over that particular property.
That area was used for, it was reserved for STP, your lordship. There are many
Long as an
complaints.
STP is provided for.
STP, they removed from that area and they put it nearby the H block.
You
And with an intention to grab this land.
understand the first point that I made. If it's reserved for the owner's development in future, none of the apartment owners will have any right over that particular area.
It was not because, your lordship,
Plan indicates it's owner's reserved area.
that is just they have mentioned that plan that on.
It's not mentioned. It's
No, your
it
lordship,
is-
but the land is divided into 312 pieces. My undivided share is calculated on the entire land area and they sold to me.
But
I
still,
have also submitted.
Undivided
schedule-
share is not
schedule C.
included to the reserve area, my lord.
ಯಾಕೆ ಮಾತಾಡ್ತಿದ್ದೆ?
Please.
ನಿಮ್ಮಲ್ಲಿ argument ಮಾಡ್ತಿದ್ದೆ ಅಂತಾನೆ? ಸುಮ್ನೆ ಇದ್ಬಿಡು.
Please.
Once it is reserved for owner's use, neither the apartment owner association nor any apartment owner can have any right over that particular property.
It is not reserved for the owner's use.
is
That
what
is
the
what
plan
my
says.
submission. All the documents are showing that 5 acres, 16 gundas.
Does not matter what your document shows. It
Yes.
matters what is mentioned in the plan. In the plan, if it's mentioned that this particular 1,104 square
1,104.
is reserved for the owner's development, that means that area cannot be claimed by anybody else other than the owner.
Yeah,
If it's the owner's land, he can use it for any purpose. that he
Your
wants.
lordship, one more submission. STP was there initially planned in that 100 and 104. We have occupied the premises in 2010, 2007 plan, 2010, we all have occupied. And they approached for changing the STP in 2012 without getting consent from me, because we are the owners of that entire land. Section 7 of COFA clearly mentions that once the plan is approved, without getting consent from the
Suppose-
owners,
Suppose the owner comes up and says, how can you have a STP in my area which is reserved for my use? What is your answer?
no, your lordship, that a plan shows that STP is reserved in that
The
1104.
owner comes to you and says, it is my area, it is reserved for my use. How can you have an STP or a rainwater harvesting in my area?
No, your lordship, because it is not reserved for owners. That is, first of all, that is the first
Tell me
point.
The plan is black and white.
No, but what did they sell to me? They sold
Does it matter?
UDS, including that area.
You think there's a violation of your sale, you'd go to the civil court.
No, your lordship, we had already approached the civil court, but I have approached your lordship for,
What have you gone to the civil court?
civil court has already granted an injunction. That is what I'm making.
For what?
Injunction against creating any charge or any constriction or any alienation on that property, your lordship. Your lordship, may I submit, your lordship? I couldn't submit at all. 3-7, there is an injunction order. They approached,
What is the suit for?
this is an injunction against using that particular area or non-alienation of that 1104 piece of land
The basis of the original plan.
based on the original plan.
Suppose I uphold the modified plan.
There is no modified plan at all, your lordship. I couldn't understand what do they mean by
Okay.
modified plan?
Yes, my lord, that
What
clarify-
pass ಮಾಡ್ಲಾ ಇಲ್ಲ?
next day ಒಂದು date ಕೊಡಿ sir.
In 1104 piece of land, they have obtained a plan sanction. Does that mean that it is a modified piece of land? That too after 12 years?
I'll repeat, if that particular land is earmarked for owner's future development, none of you will have any right over it.
One more submission, your lord, that I perfectly understood. One more submission, your lordship. 3-7, there is an injunction order. They had gone before the BBMP in 27, after 20 days. Even after there is an injunction order restraining them from doing all these things. They paid the fee. That shows the attitude of them. And they again come back before your lordship.
Release, when do you want?
Next week ಅಲ್ಲಿ ಒಂದು ಯಾವ್ದು date ಕೊಡಿ, ಅವ್ರು ಕರೆದು
The interim order may be extended.
Friday, 17.
ಮತ್ತೆ
You satisfy me on the ground that it is owner's reserved.
Indeed, my lords. And that I have not utilized the FAR that was initially sanctioned under the
Reference to bylaw, if you can show me what is the effect of that? it will
Yes,
be-
my lords.
My lord,
bylaws and also the zoning regulations, because the FAR is granted under the zoning.
my lord, 18th, my lord, 17th is inconvenient.
ಅವ್ರು ಹೇಳ್ಬೇಕಲ್ಲ ಇರ್ರಿ, ನಿಮ್ಗೆ ಯಾಕೆ?
Owners,
ಇರ್ಲಿ ಬಿಡಿ.
18th.
Number 45, you were in copy ready?
Saturday, huh? ಇಲ್ಲ ಅಲ್ಲ. Saturday.
Current for petitioner, yes, senior counsel engaged in this matter, my lord. He is suffering from throat infection and cold, my lord. Kindly 2 weeks time may be granted.
My lords.
only agreed by the period from 16 to 20.
Lords, he has not paid the lease amount. He has taken the property for the period of 10 years, my lords, on lease
No,
basis.
this order dated 29/11/2021.
An interim order has been granted by this honorable court by virtue of that, he is holding the property and he has paid
Yes.
the amount.
In this, it is stated that the swimming pool was in a dilapidated condition and after repeated demands for repair, the repair was entrusted on 8/12/2017 to a contractor who completed the repairs and handed over the swimming pool back to the petitioner in the month of December 2019.
Yes, my
So
lord.
from December 2017 till December 2019,
Yes,
swimming
not.
pool was not functioning. How can you ask for lease amount?
My lords, 2019 COVID period has been commenced, my lords. Even before that, he says that there was a repair work was going on. As per the agreement, he has to pay the repair charges, my lords,
Even
not
when
the
you-
corporation.
Even when you close the swimming pool for repairs,
My lords, closing it different, my lord. There is a fixed leased amount, he has to pay, my lords, for
If-
the period of 10 years when he is.
permit him to use the pool. If you're
Now he is using the property,
ಆ period ಹೇಳಿ ಸಾಕು.
my lords.
ಆ period ಹೇಳಿ, that period from December 17 to December 19.
My lords, as per lease agreement, my lords, I want to take your lordship to.
Madam, I understand the lease agreement.
Hmm.
In the lease agreement, is there a clause which says even if the swimming pool is closed, because you want to get it repaired, he still has to pay your rent. We don't allow anybody to use the swimming pool. How can you collect rent from him?
But I will check it out, my lords, but lease, repair work and other thing, he has to pay the expenses, my lords. It's not the
Annexure K?
corporation. My lords, annexure K is the show cause notice issued by the corporation, my lords.
Interim order complaint ಮಾಡಿದ್ರೆ ಅಂದ್ರೆ interim order complaint ಮಾಡಿದಿರಾ?
Yes, my lord, they have paid the amount 20 lakhs and after paying the interim, that amount, still he is holding the property and he is running the swimming pool, my lords. He has not handed over that to corporation. And after this show cause notice, my lords, he gives the representation stating that he needs some extension of time.
Objections ಹಾಕಿಲ್ವಾ?
I have filed IA for vacating stay, my lords. And also memo of calculation, my lords, the due amount which he is supposed to pay.
ಅವತ್ತು ಹಾಕಿಲ್ಲ?
IA filed on 4th December 2023, my lords.
You admit that it was closed from 8/12/2017 to 27/2/2019. So barring that period,
And it's COVID-19, this thing we have deductions we have given, my lord,
COVID
but
is
not that,
COVID is 2020. This is prior to COVID.
yes, my lord, this is, he has not paid since 2017, my lords, August 2017.
That is because it is closed. Come to page number 4 of your counter. Where is the lease agreement?
Lease agreement is at page 16, page 15 onwards, my lords. I want to take your lordship to page 16, my lords. Page 16. The lessee has to appoint experienced personnel and to bear the entire cost of his establishment and any other repair, including special repair, general repair to the leased swimming pool. Because of that, the repair work is, he
Who did
cannot,
the repairs? Who did the repairs?
he himself has done the repairs, and he is saying that since the repair work was going on, he is not, he
Was the
was,
repair done because of your permission granted?
no, but once the property has been handed over to me, it's his concern. Not, if he wants to get it repaired, he has to get it repaired and he has to pay, bear the expenses.
No, can he do whatever he wants, said the swimming pool
Yeah, but
without your permission?
for 10 years, after 10 years, he has to hand over the to BBMP.
He has made a statement that at the instance of the corporator and the corporation, he got the thing repaired. So if the repair is to your benefit, should he not get the extension of that 2 years when he did not use the pool?
It was not completely for the period 2 years, my lords. I'll
ನೀವೇ
just,
ಒಪ್ಕೊಂಡಿದ್ದೀರಾ para 6 ಅಲ್ಲಿ?
it may be taken at next week, my lords. I'll just call the concern official. But as per the agreement, he has to pay the lease amount every year, my lords.
If he is running the swimming pool and if he does not pay the lease amount, you have a case. When he has closed the swimming pool 2 years, it is not in dispute. How can you ask for, he is a tenant. If he is
Yes.
not able to occupy the house for 2 years, will he be able to pay you rent? If he is repairing it for your benefit.
But he has not filed any representation for extension also, my lords. It's only after when we give show cause notice, he says that he needs some extension for the this thing, my lords. Running of the swimming pool.
Exempt that 2 years for him. And remaining you go against.
Next week, my lords, I'll take it. 16th. my lords.
2 ವರ್ಷದ ನಿಮ್ಗೆ ಮಾಫೀಸ್ ಮಾಡಿದ್ರೆ ನಿಮ್ಗೆ ಮಿಕ್ಕಿದ್ ಕೊಡ್ಬೇಕಾಗತ್ತೆ.
Even COVID-19
10 ವರ್ಷ ಆಗೋಯ್ತಲ್ಲ ಇವಾಗ 10 ವರ್ಷ ಆಯ್ತಲ್ಲ ನಿಮ್ಗೆ ಖಾಲಿ ಮಾಡ್ಕೊಂಡು ಹೋಗ್ಬೇಕಲ್ಲ.
still he is in possession of the property. He has not handed over it to BBMP and he is running the swimming pool, my lords, by virtue of the interim order.
Kindly interim order to be extended. Interim.
Want to continue the.
Bill number 46, Shri Surat Samsakar.
First filed in pleading.
The association, my lords, which is formed under the Societies Act as 46, file an pleading application, my lords. I have filed my objections also, my lord.
Challenging here.
I am non-grant of OC, my lord. OC has not been granted where I've applied in 2022, my lords. They don't even respond back to me, the BBMP. So I've sought for either them to consider my representations or
What is your interest?
Your lordship, we are for the apartment owners. We have filed an impleading application that may be considered, your lordship.
What is your interest?
Your lordship, ultimately, the rejection of OC will be affecting to us.
You
We are the
supporting or opposing?
Pardon?
You supporting or opposing?
Supporting.
But my difficulty is they're registered under the Societies Act, my lord. What the Honorable High Court in the Division Bench has held is that such a.
They are the residents, isn't it?
They are
Yes,
residents.
owners.
No, but I don't know, my lord, sir, because I have not formed this association. It is under the Societies Act.
Yeah, pass on, please, my lord. Inspection will not just conducted as per the direction. Infirmities will not very serious in nature are suggested.
Lords, insofar as they were concerned,
But your presence and in the presence of your architects only, please, my lord, we have kept the inspection. ಅಲ್ಲ ಇದೆ ಸ್ವಾಮಿ ಅಲ್ಲಿ ಕಾರ್ ಪಾರ್ಕಿಂಗ್ ಮಾಡ್ತಿದ್ದೀವಿ.
They have not responded to this?
No, we have issued the endorsement. Now they'll have to act upon this.
This was in
10/10/2023.
I'll have to respond to this, my lords. He's giving me a copy.
prayer. The prayer will not survive.
No, my lords, what would happen is if my lord sees the interim orders passed in this matter, initially, they don't respond to my representation at all.
Now that he has placed this on record,
I will respond to this. I've also already filed a memo.
I will permit you to respond to this. And in the event they refuse, then you can always come. As of now, your
No.
request was that.
No, my lords, this was pursuant to a direction by this honorable court to conduct an inspection because they were not.
Conducted.
In fact, this honorable court already has held in this matter, my lords, that they're asking for documents like the kata and tax paid, which are already with them. Their intention is to drag it on and not to grant. It is not their case that I've deviated from the plan. This is for the first time now something new is being given to me.
This was given to you in October 23.
No, my lord, now he's just giving me a copy right now.
Maybe to you as a counsel, but your client has got this. This was done after in your presence.
My lord,
Yes, yes, yes.
Inspection.
No,
was
my
done
lord,
in
if
a
my lord
process.
sees on the next thing also, it's
The
only to
second paragraph ಅಲ್ಲಿ
only to the landowner. The builder is not given a copy.
ದಿನಾಂಕ 7/10/2023 ವಾಸ್ತುಶಿಲ್ಪಿಗಾರರು ಗೊತ್ತಿನ ಮಾಲೀಕರಲ್ಲಿ ಒಬ್ಬರಾದ ಜಿ.ವಿ. ಶಂಕರ್ ಹಾಗೂ ಮಿಸರ್ ದಿಶಾ ಲೋಹಾರೂಕ ಇನ್ಫ್ರಾಸ್ಟ್ರಕ್ಚರ್ ಪ್ರಾಜೆಕ್ಟ್ಸ್ ಪರವಾಗಿ ಶ್ರೀ ಅಭಿಜಿತ್ ಸೆನ್ ರವರೊಂದಿಗೆ ಜಂಟಿ ಸ್ಥಳ ತಪಾಸಣೆ ನಡೆಸಲಾಗಿದ್ದು ಈ ಕೆಳಗಿನಂತೆ ನ್ಯೂನತೆಗಳನ್ನು ಗಮನಿಸಲಾಗಿರುತ್ತದೆ.
Lord, there is no signature.
If you have responded to this, we'll consider it and pass an order.
Let me seek instructions on this, my lord. I've already anyway placed my documents on record, which would, from what I see here, some of it would anyway be covered. I've already placed it on record in this matter.
Thought it will be your benefit if I were to say that pursuant in interim order, they have inspected, pointed out a few deficiencies which are required to rectify. If the same is rectified, they will proceed further.
My lord sees the first deficiency. Please see the nature of those deficiencies, my lord. Please see the first one.
I can't annul them.
I'm not saying that. I'm just saying they're not even clear about what is the deficiency. Please see the first one itself, my lord. ಸದರಿ ಸ್ವತ್ತಿನಲ್ಲಿ ಗ್ರಾಮ ನಕ್ಷೆಯಂತೆ ಹಾದು ಹೋಗಿರುವ ನಾಲವನ್ನು ಅನುಮೋದಿತ ನಕ್ಷೆಯಲ್ಲಿ ಗುರುತಿಸಲಾಗಿದ್ದು. They only given a plan.
ಆಮೇಲೆ ಓದಿ.
ಈ ಪ್ರದೇಶದಲ್ಲಿ ಯುನೀಕ್ ಡಿಸೈನ್ ಅಂಡ್ ಸ್ಟೈಲ್ ಎಸ್ಥೆಟಿಕ್ ವಿನ್ಯಾಸಕ್ಕಾಗಿ ಕಟ್ಟಡಗಳು ನಿರ್ಮಿಸಲಾಗಿರುತ್ತದೆ.
When you put up a construction on that Nala area,
We have not put up anything. I don't know what this unique design. There is no in their photographs also.
your architect was there, your owner was there.
I mean, I've not been given a chance to respond to this, my lords.
And the thing is, ಪ್ರದೇಶದಲ್ಲಿ ವಾಹನ ನಿಲುಗಡೆಗೆ ಸ್ಥಳ ಕಾಯ್ದಿರಿಸಲಾಗಿರುತ್ತದೆ.
Lords, in the buffer zone, it's an open car park even if it is so, my lords. There is no construction there for an open car park.
Directions, please, not we have to follow. We can't into these buffer zone. There is a nala going there, please, Lord.
I cannot put up any construction, but I can use an open car parking space. Gas bank is very much there, my lord.
Contrary to the sanction plan.
Even the BBMP bylaws.
2220 kV at high tension line is going, not below that they have constructed the children's play area, which is fatal killing.
But I think clause number 6 is of some substance.
Lords, at no point have they given either the 321 notice earlier, my lords, or even under the new act also to.
Want them to do it now.
No, I'm not saying that, my lords.
So,
I'm saying after construction, now when I come before this honorable court for OC, they give me this. At this stage.
My lords had directed, my lord, that we go and inspect it in their presence, which we have done. These are all the infirmities, my lord.
That is because they did not act upon my application for OC.
ಇದೇನ್ witch hunting ಅಲ್ಲ ತಾನೆ?
Illa, nothing at all, please. That's my court.
My instructions are, that's what it is, my lord.
That is, they're all, my lord.
Because the basketball court and the tennis court are below the
220 kilo KVA line.
There is a height limit. There is a height limit. There is no construction for a basketball court.
Here, please.
for what? Basketball go that high ಅಂತ.
Not that, my lord, but it is considered to be.
Gradations. The bylaws has a limit, my lord.
Except 6, I think everything else is only for the purpose of objecting.
ಅಲ್ಲ ಈ ಸೆಟ್ ಪ್ಯಾಕ್ ಅಲ್ಲೂ ಇದೆ, ತೊಂದರೆ ಇದೆ. ಅದನ್ನೇ ನಾವು ಸಜೆಸ್ಟ್ ಮಾಡಿದೀವಿ. ಅನುಮೋದಿತ ನಕ್ಷೆಯಂತೆ ಸದರಿ ಸ್ವತ್ತಿನಲ್ಲಿ ರಾಮ ನಕ್ಷೆಯಂತೆ ಹಾದು ಹೋಗುವ ನಾಲಾದ ಅಂಚಿನಿಂದ ಈ ತಲಮಾಡಿಯ ಅಂಚಿಗೆ ಕನಿಷ್ಠ 2.46 ಮೀಟರ್ಸ್ ಅಂತರವನ್ನು ಕಾಯ್ದಿರಿಸಬೇಕಾಗಿದ್ದು ಕೇವಲ 0.75 ಮೀಟರ್ಸ್ ಮಾತ್ರ ಅಂತರ ಕಾಯ್ದಿರಿಸುವುದು ಕಂಡು ಬಂದಿದ್ದು ನಕ್ಷೆ ಮಂಜೂರಾತಿಗೆ ವ್ಯತಿರಿಕ್ತವಾಗಿ ತಲಮಹಡಿಯನ್ನು ಹೆಚ್ಚುವರಿಯಾಗಿ ನಿರ್ಮಿಸಲಾಗಿರುತ್ತದೆ.
FIR ವೈಲೇಷನ್ ಏನ್ ಹೇಳ್ತಿಲ್ಲ.
FIR ವೈಲೇಷನ್ ಹೇಳ್ತಾ ಇಲ್ಲ. ಬಟ್ ಈ ಬೇಸ್ಮೆಂಟ್ ಗಳೆಲ್ಲ ಅಡಿಷನಲ್ ಬಂದಿದ್ದಾವೆ.
ಎಲ್ಲಿ ಬರ್ತಿದ್ದಾರೆ?
ಅಲ್ಲಿ ಬರ್ದಿದೆ ಹೆಚ್ಚಾಗಿ ಕಂಡು ಬಂದಿದೆ. ನಕ್ಷೆ ಮಂಜೂರಾತಿಗೆ ವ್ಯತಿರಿಕ್ತವಾಗಿ ತಲಮಹಡಿಯನ್ನು ಹೆಚ್ಚುವರಿಯಾಗಿ ನಿರ್ಮಿಸಲಾಗಿರುತ್ತದೆ.
ಯಾವುದು?
ಸೀರಿಯಲ್ ನಂಬರ್ 6, please.
Again, that is a setback, isn't it? Instead of 2.4.
ತಲಮಹಡಿ
And the height.
ಮಾತ್ರ ಅಂತರ ಕಾಯಿಸಿದ್ದು ಅಲ್ಲ. ಸೆಟ್ ಬ್ಯಾಕ್ ಅಲ್ಲಿ 2.46 ಇರಬೇಕಾಗಿತ್ತು, 0.75 ಕಂಡು ಬರ್ತಾ ಇದೆ. ಮಾತ್ರ ಅಂತರ ಕಾಯ್ದಿರಿಸುವುದು ಕಂಡು ಬಂದಿದ್ದು ನಕ್ಷೆ ಮಂಜೂರಾತಿಗೆ ವ್ಯತಿರಿಕ್ತವಾಗಿ ತಲಮಹಡಿಯನ್ನು ಹೆಚ್ಚುವರಿಯಾಗಿ ನಿರ್ಮಿಸಲಾಗಿದೆ.
ಎಷ್ಟಿದೆ ಹೆಚ್ಚುವರಿಯಾಗಿ?
ಒಂದು ಫ್ಲೋರ್ ಏನೋ ಇರ್ಬೇಕು.
ಇದೆಲ್ಲ 0.275, 2.4, 0.7 ಆ ಡಿಫ್ರೆನ್ಸ್ ಅಷ್ಟೇ.
ಇಲ್ಲ ಅದು ಸೆಟ್ ಬ್ಯಾಕ್. ಅನುಮೋದಿತ ನಕ್ಷೆಯಂತೆ ಸದರಿ ಸ್ವತ್ತಿನಲ್ಲಿ ಗ್ರಾಮ ನಕ್ಷೆಯಂತೆ ಹಾದು ಹೋಗುವ ನಾಲಾದ ಅಂಚಿನಿಂದ ತಲಮಾಡಿಯವರೆಗೂ ಕನಿಷ್ಠ from the nala, there is a nala passing.
Therefore, instead of 2.45 meters, he is 2.7.
No, the difference, the gap between the nala and the, please, my lord, at the edge of the building.
As a consequence of which the area of the basement is increased. That is what you have been.
Please. Now what happens is, that is honorable Supreme Court order, please, not for this, ಬಿಡ್ಲೇಬೇಕು ನಾನಾ natural flow ಗೆ ಇಷ್ಟು ಬಿಡ್ಲೇಬೇಕು.
Apartment ಹೊಡೆದಾಗ ಪೂರ್ತಿ.
ಇಲ್ಲ, they will have to take up some remedial measures, they will have to.
What is the remedial measure?
They'll have to ask my engineer, please, what is the remedy available?
Okay, I got think there was some.
Sanction planning ವ್ಯತಿರಿಕ್ತ ಆಗಿದೆ.
Not just that, my lords,
Now,
the claim.
the violation will not get in the clear cut violation.
I have my doubts whether it is genuine or.
My lords, even that, if I may clarify.
Go there and have a look at if my engineers are at fault, they'll have to suffer the consequence. Because based on the direction issued by at the hands of my lords, they have gone and inspected, please.
Because in none of the 8 objections,
Please,
you state that the buildings are constructed in deviation from the sanction plan. You don't state extra floor, you don't say extra
but we have not said.
built up area.
ಇದರಲ್ಲಿ ಕಂಡು ಬಂದಿರೋದು ಈಗ for the purposes of partial OC ಇಷ್ಟು informative ಇದೆ. ಅದು totally ಅವರೆಲ್ಲ ಕೊಟ್ಟ ಮೇಲೆ full as built drawings ಎಲ್ಲ ಕೊಟ್ಟ ಮೇಲೆ plan sanction ಜೊತೆಗೆ ಅದನ್ನ tally ಮಾಡಿ.
The first one is again vague.
Please, my lords.
It's not stated as to what katada is there. Unique design and style aesthetic, we don't know whether it's for habitation or simply some design that they put there.
ಇಲ್ಲ, ನಾಲಾ ಪ್ರದೇಶದಲ್ಲಿ ಅವ್ರು ಕಟ್ತಾ ಇದಾರೆ ಅಂತ.
ಏನ್ ಕಟ್ಟಿದ್ದಾರೆ ಅವ್ರ ಅಪಾರ್ಟ್ಮೆಂಟ್ ಏನು ಅಂತ
ಬೇಕಾದ್ರೆ ಫೋಟೋಸ್ ನಾನು ಹಾಕ್ತೀನಿ ಸುಮ್ಮನೆ ಏನ್ ಕಟ್ಟಿದ್ದಾರೆ ಅಂತ ನಾನೇ ಫೋಟೋಸ್ ಹಾಕ್ತೀನಿ. Tell my engineer to go there and do it.
ಅಲ್ಲ, they file photo.
asking if they have responded to 10-10-20.
ಅದು ನಾವು STP playground below ನಾನು ಫೋಟೋಸ್ ಹಾಕಿದ್ದೀನಿ, ಇನ್ಸ್ಪೆಕ್ಷನ್ ಮಾಡಿದ್ದೆ. I produced that.
Location of STP from point A to point B by itself will not render the entire structure illegal. So long as they have an STP.
Yes,
that is a requirement.
STP is a requirement.
ಮಾಡಿದಾರಲ್ಲ.
ಅಲ್ಲ, ಮಾಡಿದ್ದಾರೆ, ಬಟ್ ಅದು manner in which it has been constructed, please.
Find out if they have responded to this, if that is so.
Otherwise they can respond to it, please, my lords, I will request.
Find out if you have responded to
My lords,
this.
additionally, even the fact, the claim that there is a nala, I've got it stated by this honorable court. I've produced that with my petition itself.
Whatever you do, if there's a plan in which you are supposed to follow certain directions, you can't get away with.
Allah, they have not said that. In the plan, there is no nala at all.
There is one in clause 6.
The approved planal, there is no nala at all.
Clause 6.
Adala, I understand that. Even for that, my lords, now the fact, the existence of this, the alleged existence of this nala has come into the picture in
Suraj, I
22.
told in the beginning, if you have responded to this, I'll ask him to consider the.
I'll seek instructions. One, my lord, but my difficulty is.
Find out whether they have responded and what is to be done to solve the problem.
Please, my lords, I will ascertain.
Your lordship,
My interim order may
this is
kindly
a
be
2014 project. And we, out of 4 towers, they have only constructed 2 towers. And we have occupied, around 150 apartment owners have occupied, even without getting this occupancy certificate. And the other 2 towers, they have completely abandoned. That is the situation. So, your lordship, we
But
have
their
formed an
concern-
association. We have formed a society, considering that at any moment, the builder may be abandoning the project and he may be moved out. So the real affected party, aggrieved party will be the apartment owner. They have already collected the entire money from us also. Kindly implead us, your lordship. That is the, I have filed an impleading
I'll consider your
application.
application along with the main matter.
Without the occupancy
Pardon, your
being
lordship?
issued, without the occupancy being issued. they
Yeah,
cannot sell.
ನಾನು ಏನಂತ ಇದ್ದೆ, if you make that statement, that means you are in violation of the law.
Occupancy, your lordship, for two,
And occupy a building unless there's an occupancy certificate. If you are admitting that, that means you are in violation of the law.
we didn't have any other option in the sense, your lordship. to-
Please wait, let us see. if the matter
Understood,
can be solved.
understood.
Find a way out of this.
ಇಲ್ಲ, ascertain.
ಸುಮ್ನೆ ತರಲೆ ಮಾಡ್ಬಿಡಿ ಅಂತ.
ಇಲ್ಲ ಸ್ವಾಮಿ, ನಾನು ಖಂಡಿತ ಮಾಡ್ತಾ ಇಲ್ಲ ಸ್ವಾಮಿ.
ಹಂಗೇನೋ ಸ್ವಲ್ಪ ಹಂಗ ಅನ್ನಿಸ್ತು ಸ್ವಲ್ಪ.
ಇಲ್ಲ ಸ್ವಾಮಿ. I'll go down to my lords and lords.
They collected the entire money, your lordship,
That is
and we
between-
didn't have any other option.
My lords, the interim order may kindly be extended,
What is the interim order?
not to take any coercive steps by the BBMP.
ಇಲ್ಲ, ಏನು ಮಾಡಿಲ್ಲ ನಾವು. ನಾವ್ ಯಾಕೆ
Allah, the interim order has been now enforced for almost 2 years.
ಅದು ನಾವು coercive steps only up to 248, not at this stage.
Want to continue the next day.
Till 47. Road application under section 269 of Karnataka Panchayat Raj Act for transfer of Kata was given, my lord, to the respondent number 2. Order was passed in my favor in the allowing the appeal, my lord. Now, after passing order in my favor, after lapse of 1 year, my lord, the same order is recalled by the same respondent number 2, my lord.
This was the respondent. What is the reason given?
Reason given, my lord, my transfer of Kata was done based on the registered gift deed, my lord. Reason is
ಓರಲ್ ಪಂಚಾಯತ್ ಪಾರಿಕತ್ ಅಂತ ರೆಸ್ಪಾಂಡೆಂಟ್ ನಂಬರ್ 4 ಸೆಟಪ್ ಮಾಡಿದ್ದಾರೆ. ಅದಕ್ಕೋಸ್ಕರ ನಂದು ನಿಮ್ದು ಚೆಕ್ ಬಂದಿ ಚೇಂಜ್ ಇದೆ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಮೈ ರಿಜಿಸ್ಟರ್ಡ್ ಗಿಫ್ಟ್ ಡೀಡ್ ಇಸ್ ಅನಲ್ಡ್ ಅಂಡ್ ಖಾತಾ ಇಸ್ ಟ್ರಾನ್ಸ್ಫರ್ಡ್ ಇನ್ ದೇರ್ ನೇಮ್. My father's property, my lord. Registered gift deed is of
Actually said that there's a discrepancy in the
boundaries.
This is executive officers ನಮ್ಮ ಮಂಡಲ ಬರಲ್ಲ.
Can you say that?
ಹೇಳಕ್ ಬರಲ್ಲ. ಇದು ಪಂಚಾಯತ್ ಅವ್ರ ಆನ್ಸರ್ ಮಾಡ್ಬೇಕಾಗುತ್ತೆ.
ಯಾರು ಬರ್ತಾರೆ ಪಂಚಾಯತಿಗೆ?
ಪಂಚಾಯತಿಗೆ ಯಲಾಂಕ ಇವರು ದೇವರಾಜ್ 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 ಪ್ರದೀಪ್
ಯಾವ ಪಂಚಾಯತಿ?
ಯಲಾಂಕ
ತಾಲೂಕ್ ಪಂಚಾಯತ್ ಎಕ್ಸಿಕ್ಯೂಟಿವ್ ಆಫೀಸರ್ ಬೆಂಗಳೂರು ನಾರ್ತ್ ತಾಲೂಕ್. ಮತ್ತೆ ಯಾರು ಅಂತ?
ಇಲ್ಲ ದೇವರಾಜ್ ದೇವರಾಜ್
ದೇವರಾಜ್.
ದೇವರಾಜ್
HV Devraj is there to take notice for respondents 2 and 3. List.
Lord, the fourth respondent has already entered appearance, filed wakalat. Fourth respondent, the private party, has filed wakalat. Now, Kata should not be transferred.
There is a stay, isn't it?
Stay is given not with respect to give effect of that impugned order, my lord. It is for
Free of annexure.
gift deed basis mele marata ಮಾಡಬಾರದು ಅಂತ ನನಗೂ ಸ್ಟೇಟಸ್ ಕೋ ಇದೆ. I am not selling, but as complete stay may be extended, my lord. Interim order may be extended.
There is no time limit.
Time limit to fix.
24.
Number 48.
Please, ma'am.
I appear for the petitioner in connected matter, my lord.
Lord, in serial number 48, my application seeking NOC for an electricity connection has been rejected, my lord. On the ground that in an OS, there is a injunction operating against me. That injunction order is limited to not to alienate the property, my lord. That has nothing to do with the electricity connection.
Where is the impugned order?
Annexure C, my lord, page number 27.
This is WP 18361.
WP 18361 is a connected matter at 48.1, my lord. The Kata in respect of the scheduled property was mutated in my name by the order of the district commissioner. That order has been challenged in WP number so and so.
The suit for
Suit for partition, my lord.
same parties,
Declaration.
Declaration and partition.
same parties.
Same parties.
What is the interim order granted in the suit?
Not to alienate it.
Then how can there be a refusal?
Therefore, I am before your lordship, my lord.
New petitioner.
Naked matter, I am for respondent, my lord. My party, same parties, my lord. This petitioner and
I'm for R3.
Who's for the petitioner? Arend Batra.
I am the petitioner in 18361, my lord. I was not arrayed as a party in the first matter, my lord, which I learned when making submissions.
Now, what are you challenging in your petition?
That is the revenue entries I have challenged, my lord. Your lordship may fix a date and may dispose of the matter in the next week, my lord.
Lord, there's some
So why
urgency.
you have an- Is your suit filed by you or by him?
Suit is filed by them, my lord. I
Suit
am a
is
defendant
filed
about
by us, my lord. I do concede suit is filed by us seeking for a partition.
So I'll direct them to issue NOC for getting electricity connection. That should not come in your way.
Grateful, my lord.
I was not arrayed as a party in the connected matter, my lord. That is the issue. They did not array me as a party respondent in the first matter.
Who appears for the Gram Panchayat? You are.
Respondent one.
Since the interim order is only understood not to alienate, grant him an NOC. That's the only prayer here.
My lord,
That's
that's
only
the
prayer.
only prayer, my lord.
One submission is this, my lord. The revenue entries were mutated solely on the basis of a representation. I was not heard. Since revenue entries were mutated in the name of the petitioner in the connected matter, I have challenged the same in this proceedings, my lord.
What is that you have challenged here?
revenue entries were mutated to the name of the petitioner in the connected matter. Lordship may see my petition in 18361 of 2023, page number 76, my lord.
But you already filed a suit, isn't it?
Suit is with regard to partition. There are series of issues in this, my lord. With regard to wills and from 2 to 3 wills, and with regard to dispute is from 1976, my lord. With regard to title.
You ultimately succeed in the suit. The
Yes.
Kata will be done as per the suit, isn't it?
Please, my lord.
So I'll direct them to give NOC for the purpose of electricity connection. Why should the two of them be linked?
That will not come in a way of a partition and possession with regard to the property, my lord. Your lordship may observe that, and your lordship may.
And you want me to dispose of this suit also, saying that you subject to the suit of the suit? Nimrate petition dispose madlange. Can you dispose of your writ petition?
Our writ petition may be kept pending, my lord. We will make submission with regard to revenue entries and change of kata.
Do not consider the petitioner to submit that. 28338 by 2024 may be considered independently of WP 18361 by 2023. Since the only issue in that writ petition is the refusal by the Panchayat to grant an NOC. Accordingly, WP 28338 by 2024 is taken up for consideration. Annexure C indicates that the Panchayat has refused to grant electricity connection, grant NOC for the petitioner to avail of an electricity connection on the ground that a suit in OS 7 by 2022 has been instituted by the petitioners in WP 18361 by 2023. It is not in dispute that the only interim order granted in WP in OS 7 by 2022 is an injunction to restrain the petitioner in WP 28338 or 2024 to alienate or create third-party interest. In that view of the matter, it is obvious that the Panchayat could not have refused the grant of an NOC to the petitioner to avail of electricity connection. Accordingly, Annexure C is quashed and the Panchayat is directed to issue an NOC to the petitioner to avail of the electricity connection. It is needless to state that the grant of the NOC is subject to the pendency of this writ petition, pendency of WP 18361 by 2023, and also the suit that is said to be filed pending between the parties. Grateful, ma'am.
Lordship, there is a small subsection in smell. They have to file an application to form one of the
Madam Kapara.
Number 49.
Your lordship's kind permission. But they have to give a,
Filing the copy of the provisional order, my lord.
they have given that provisional order.
The grievance of the petitioner was that provisional order was passed. 248.1 was not served to them. 248.2 is pasted on their wall. And no Mahazar was conducted. So I'm giving the Mahazar copy and inspection report and 248.1 notice. It's a provisional order. They can give a reply to it. Copy is served to the others.
Objection accurate.
No, madam.
Illa, idu on 27th on account of death of former Prime Minister, the Xerox copy of Annexure C was handed over to security.
They've given
ಅಲ್ಲ ಈಗ ಕೊಟ್ಟಿದ್ದಾರೆ ಅದು ಏನೇನೋ ಹೇಳಿದ್ದಾರೆ ನಾನು I'll come back to next week, my lord.
with objection, I'll direct you to file objections to this and they'll pass an order. Why should you keep the petition? Nimget benefit and ಸಿಗುತ್ತೆ. I can't watch the provisional order.
ಅಲ್ಲ ಅದು ಸರಿ ಬಟ್ ಏನೋ ಹೇಳಿದ್ದಾರೆ ಅದನ್ನೊಂಚೂರು ಕೇಳ್ಬಿಟ್ಟು ನಾನು ತಮ್ಮ ಮುಂದೆ ಹೇಳ್ತೀನಿ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಹಾಕೊಂಡ್ರೆ ಅಷ್ಟೇ ಇನ್ನೇನಿಲ್ಲ ಅವಾಗ ಮಾಡಿಬಿಡಿ.
17.
Week after next
20.
20.
20. For further consideration, seal number 50.
Petition number. Your lordship, the SPP is next in the neighboring court. He has instructed me to make a submission there. Charges, article of charges have been framed against the ring inspector. So 1 month time is quite a lot.
Lord, in this report, my lord, there are two aspects I just want to highlight. My objections are ready.
One is, my lord, they pin the blame. They had not submitted a report of non-compliance of an interim order to the Honorable City Civil Court. They pin the blame, my lord, on a person who is not living, an ASI who is not living. The second aspect, my lord, the violation happened on 17/2/2020 and continued, my lord, till November 2023. They demolished the building and constructed a new building in the premises, my lord. So the status quo order was violated from 17/2/2020 to November 2023. But they pinned the entire blame, my lord, on one officer who was there from January 23 to May 23, on the ground that the second respondent has made a statement that the construction happened only during this period. So they rely on the statement of, my lord, the person who has violated the order. And they said this person has said the construction has happened only during this period, so only this officer is responsible. In fact, my lord, I've produced photographs from 17/2. I went to the City Civil Court also complaining that they have come to demolish the property. Please direct the police. So I produced photographs before the City Civil Court, my lord. I produced it also over here, that from 17/2, he started demolition, he's started construction without sanction plan, and he's completed in 2023. They don't look at all of this, my lord. They only rely on the statement of the.
What is the period you said, which is not?
17/2/2020, my lord, he came to the property and demolished. He started construction, my lord, and completed probably in the month of November 2023. For 3 years.
Which is the period you said the status quo order was violated and no action is taken against that officer?
My lord, now there are 5 officers, my lord, who are in charge, my lord, during that period. They have left all these 5 officers. I don't know the reason why they've pinned it all on, my lord, only one of.
20th of February 2020 is the maintenance of status quo.
Please, my lord.
21st was the acknowledgement given.
Yes, my lord.
Who were the officers who were working from 2020?
My lord, they've said in the report, my lord, there are 6 officers totally. B.K. Manjaya, D.R. Nagaraj, Mr. Muni Krishna, Subramanyam K, Papanna, and Chaitanya.
I appear for the second respondent. All these facts are denied, my lord. All are false allegations.
Is right. This is only for the period, the first period, 2020, when Papan was there. What about the remaining period?
No, I was just instructed now. Because
May-
he was here and then I'll inform the SPP about.
Literally, I appear for the second respondent. The charge sheet which they have challenged is because they have assaulted me. Nanna ಹೊಡೆದ್ರು, ನನ್ನ murder ಮಾಡ್ತೀವಿ ಅಂದ್ರು, ನನ್ನ ಇದು ಮಾಡ್ತೀವಿ, ಅದಕ್ಕೋಸ್ಕರ charge sheet ಹಾಕಿದ್ರು. Based on that, they have come here and the litigation has been misled. And my submission is this construction was completed in 2017. The corporation has measured the thing and they have mentioned in the form issued in 2018 itself.
I'm concerned about the fact that the sub-inspector.
No, that is it. It should go for, it's a disputed fact, whether the construction was been done.
Why are you getting involved in that? This.
No, I have, it's allegation against me that I have demolished, I have constructed, ಎಲ್ಲ ನನ್ನ ಮೇಲೆ ಹೇಳ್ತಾ ಇದ್ದಾರೆ. And these things without any knowledge, clandestinely, they just say, our construction ಆಯ್ತು, ಇದಾಯ್ತು, they are only holding the inquiry. ಅವ್ರದ್ದು 39 rule 2A, it's still pending. The inquiry has to be done there, evidence has to be adduced. I should give given an opportunity of, basic thing is audio alterum partem, they cannot be condemned unheard. ಇದ್ರಲ್ಲಿ ಏನಾಗ್ತಿದೆ ಅಂತ ಹೇಳಿದ್ರೆ
Person who did not choose to appear despite service of notice.
No, I was not served. I was not served. Once I was served, I have before this court.
That you were served and you chose to remain unrepresented.
No.
It's only after went after the sub-inspector you got up.
No, only then I came to know about the pendency of this.
About audio alterum part.
No, my lord, I came to know about this litigation only on when the officers came to me. Earlier to that, I was not aware.
Ask Paliappa to verify about the remaining period.
No, I was just informed that construction happened during Papana's period. So they.
Papanna disobeyed the order in as much as he did not comment, report to the court.
Right.
But the construction has gone on even after Papanna's period.
Okay, right.
Action is to be taken from them.
Right.
Just pass on one certificate of the corporation, my lord.
ಅದನ್ನ
ಅಲ್ಲ
ಮಾಡಿ.
ಅದರಲ್ಲಿ 2017 ಅಲ್ಲ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಆಗಿದೆ, ತೆಗೆದ ಮರ ಇದು ಎಲ್ಲ ಹಾಕಿದ್ದಾರೆ. Extent of construction is also.
Main matter ನೀನು ತಗೊಂಡೇ ಇಲ್ಲ. I am only on this.
Allah, this main matter is only challenging the complaint that they have assaulted me and they have abused me, and they said they gave a threat that they will finish me.
That I will.
And 10 people they came and that is the complaint, that is the charge sheet which has been filed. And it's a matter for trial.
And
That I will hear separately and just on.
Allah, that is the only thing before this court.
ಏನ್ ಸಂಬಂಧ ಇಲ್ಲ.
ಯಾವ್ದಕ್ಕೆ?
ಇವಾಗ
ನನ್ ಮೇಲೆ ಇಂಪ್ಯೂಟ್ ಮಾಡ್ತಾರೆ, ನನ್ಗೆ ಪಾರ್ಟಿಸಿಪೇಷನ್ ಕೊಡ್ತೀವಿ, ಅವ್ರು ಇಷ್ಟ ಬಂದಂಗೆ ಸ್ಟೇಟ್ಮೆಂಟ್ಸ್ ರೆಕಾರ್ಡ್ ಮಾಡ್ತಾರೆ. ರೈಸ್ಡ್ ಅನ್ ಅಬ್ಜೆಕ್ಷನ್ ಬಿಫೋರ್ ದಿ ಡೆಪ್ಟಿ ಕಮಿಷನರ್ ಆಫ್ ಪೊಲೀಸ್ ಆಲ್ಸೋ. ಅವ್ರೇನೋ ಅಂತ ಹೇಳಿದ್ರೆ ಇನ್ನೇನೋ ಫೋರ್ಸ್ ಮಾಡಿ ಅವ್ರ ಹತ್ರ ಸೈನ್ ಹಾಕ್ಸ್ಕೊಳ್ತಾ ಇದಾರೆ. ಐ ಡೋಂಟ್ ನೋ ವೇರ್ ಐ ಆಮ್ ಲೀಡಿಂಗ್ and I am not constricted during that period. I may be permitted to file an affidavit and place my
this charge sheet is only in respect of Papa
assault.
Who's supposed to have filed, who should have filed the report to the civil court.
Yes.
But thereafter, also the construction, if it has gone on, are you going to allow the other succeeding officers scot free? Whether Papanna or anybody else who's occupying. If the construction has gone on despite an interim order, when the direction was to the inspector to maintain status quo, everybody who was in office will have to be held responsible.
It could be that Papana was there for a tenure of 2-3 years and then the construction has come up. Yes,
Please
that is,
verify. If Papana was there only for limited period,
yes,
you can't allow the other people also to go away scot free.
yes. No, normally they are there for 2 years. So therefore,
Verify.
Allah, this is affecting my rights.
that yes.
All these things they are forcing at the days. I've raised an objection before the DCP. ಇವ್ರನ್ನ ಕರ್ಕೊಂಬಂದು ಅವ್ರಿಗೆ ಹೆದರ್ಸ್ಬಿಟ್ಟು ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಆಯ್ತು ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಸ್ಟೇಟ್ಮೆಂಟ್ ತಗೊಳ್ತಾ ಇದ್ದಾರೆ. ಆಲ್ ದಿ ಸ್ಟೇಟ್ಮೆಂಟ್ಸ್ ವೇರ್ ಆಮ್ ಐ ಹೆಡಿಂಗ್?
ನೀವು ಕೊಡಬೇಡಿ, ನೀವು ಸ್ಟೇಟ್ಮೆಂಟ್ ಯಾಕೆ ಕೊಡ್ತೀರಿ ನಾವು ಎದುರ್ಕೊಂಡು?
ಅಲ್ಲಲ್ಲ, ನಾನು ಸ್ಟೇಟ್ಮೆಂಟ್ ಕೊಟ್ಟಿದ್ದು
ಸಬ್ ಇನ್ಸ್ಪೆಕ್ಟರ್ ಮೇಲೆ ಹೋಗ್ತಿರೋದು, ನಿಮ್ಮ ಮೇಲೆ ಏನ್ ಹೇಳಿಲ್ವಲ್ಲ ನಾನು?
ಅಲ್ಲ, ಬಟ್ ಇದರಲ್ಲಿ
Civil court granted an order, specific order against the inspector. My grievance is that he has disobeyed.
that disobedience of this one, there is a separate proceedings which is pending. Trial ಆಗ್ಬೇಕಲ್ಲ. 39 rule 2A miscellaneous is registered.
Violation of injunction ge.
Huh.
Police officer cannot ignore an order of the court regarding filing of a report. And when it comes to my notice, I should ignore it?
No, they say that report was there in their file and that person has been dead.
ಅವ್ರ ಮೇಲೆ ತಾನೇ ಹೋಗ್ತಿರೋದು. Why are you aggrieved?
ಬಟ್ ಇದ್ರಲ್ಲಿ ಪ್ರೋಸೆಸ್ ಏನಾಗ್ತದೆ, ನಾನು ಬಲಿಪಶು ಆಗ್ತಾ ಇದ್ದೀನಿ. ನಾನು ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಮಾಡಿಲ್ಲ, ನಾನು ಡೆಮಾಲಿಷನ್ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಎಲ್ಲ ಅವ್ರಿಗೆ ಬಂದಿದ್ದೆಲ್ಲ ಹೇಳ್ತಾ ಇದಾರೆ. ಅವ್ರಿಗೆ ಯಾರು ಇಷ್ಟ ಇಲ್ವೋ ಆ ಆಫೀಸರ್ಗಳ ಮೇಲೆ ಎನ್ಕ್ವೈರಿನೂ ಮಾಡ್ತಾ ಇದಾರೆ. ಅಲ್ಟಿಮೇಟ್ಲಿ ಇಟ್ ಶುಡ್ ನಾಟ್ ಬಿ
First.
Number 51 and 52 kindly be extended. Interim order may continue.
Number 53. KK Vasan.
For the petitioner, my lords, senior is in another court on his legs.
Release ಮಾಡ್ಬಿಡ್ಲಾ?
Date might be given, my lords.
I'll release it, let it come before somebody else.
No, my lords. Today he wanted to argue the matter.
Release.
Please attend. Number 54, Sri Narayan Swami KV.
ಏನಾಯ್ತು?
Now, the issue is, my lords have it has to be by virtue of a judicial order. Lords, if my lords recollect that as on 2003, my lords is the last date, my lords, when the grant in aid amount was paid to him. And thereafter, my lords, till 2012, till he superannuated, it was paid by the management, that by 55 lakhs was paid. Now, the only thing, my lords, was with regard to pension has to be calculated on the basis of the date of the grant in aid or the date of the superannuation. Lords, my lords had permitted us to pay him in terms, to make calculations in terms of the date of the grant in aid, pay provisional pension and pay it up. So that we have paid it. Now, my lords have to decide whether it is the grant in aid amount. My lords, we cannot concede that it is the date of the superannuation. So formally we'll have to make submission with regard to that it is from the date of the last date of the grant in aid period, because afterwards he was not in grant in aid. But if it is taken from the date of the superannuation, basic, my lords, will be around 50,000 rupees. If it is taken from the date of the grant in aid, it is 10,000 rupees. So we have provisionally settled this pension and all the arrears have been released in terms of the admitted position. Only thing is, my lords have to decide now. Last time they were not able to get in touch, my lords, with the petitioner because the interest ಬಗ್ಗೆ ಸ್ವಲ್ಪ ಏನೋ issue ಇತ್ತು. I'm told he is there in court. ಬಂದಿದ್ದಾರೆ
ಮಾಡ್ಲಿ.
ಇದ್ರಲ್ಲಿ ಏನಾಗಿದೆ, ಈವನ್ ಈಗ 10,000 ಚಿಲ್ಲರೆ ತಗೋಬೇಕಾಗಿತ್ತು, ಅವ್ರು ಬರೀ 5,000 ಚಿಲ್ಲರೆ ತಗೊಂಡು ಇದು ಈಗ ಟ್ರೆಜರಿಯಿಂದ ಕೊಟ್ಟಿರೋ 5,000 ಚಿಲ್ಲರೆ ತಗೊಂಡಿದ್ದಾರೆ. ಅದನ್ನ ನಮ್ಮ ಪ್ರಕಾರ 2003 ನಲ್ಲಿ ಅವ್ರು ಕೊಟ್ಟಿರೋ ಕ್ಯಾಲ್ಕುಲೇಷನ್ ಪ್ರಕಾರನೇ 16,200 ರೂಪಾಯಿ ಬೇಸಿಕ್ ಇದೆ ಸ್ವಾಮಿ. ನಾನು ಡಾಕ್ಯುಮೆಂಟ್ 19 ಸೆಪ್ಟೆಂಬರ್ 2024 ಅಲ್ಲಿ ಫೈಲ್ ಮಾಡಿದ್ದೀನಿ. ಅದರ ಪ್ರಕಾರ
ಇದು 50% ಅದ ತಗೊಂಡ್ರೆ
ಅದೇ
ಅಲ್ಲಲ್ಲ ಬೇಸಿಕ್ ತಗೊಂಡು ಕ್ಯಾಲ್ಕುಲೇಷನ್ ಫಾರ್ಮುಲಾ ಪ್ರಕಾರ ತಗೊಂಡ್ರೆ ಆ ಬೇಸಿಕ್ ತಗೊಳ್ಳಿಲ್ಲ 10,000 ಚಿಲ್ಲರೆ ತಗೋಬೇಕಾಗಿತ್ತು ಅವತ್ತು ಅವ್ರ ಪ್ರಕಾರ. 2003 ಪ್ರಕಾರ 10,000 ಚಿಲ್ಲರೆ ತಗೋಬೇಕಾಗಿತ್ತು.
According to us, the calculation that we had given, the basic that we had shown was 10,833. This treasury sheet, my lords, my learned friend has just passed it on. I'll have it checked up, my lords. Because my information was, we had sent, the calculation that we had given with basic of 10,833 was, my lords, by one sheet was passed on, my lords, and we had, in fact, the loose sheet, 2 sheets were there, my lords, 2 different calculations were there.
ನನ್ನ ಕ್ಯಾಲ್ಕುಲೇಷನ್ 19 ಸೆಪ್ಟೆಂಬರ್ 2024 ಅಲ್ಲಿ ಫೈಲ್ ಮಾಡಿದ್ದೆ.
ಅಲ್ಲ ನಾವು ಒಂದು ಎಂಟ್ರಿ ಮಾಡರ್ ಮಾಡಬೇಕಾದ್ರೆ, otherwise I'll just put it this way, my lords, 10,833 is what we had shown as the basic, and then, my lords, into qualifying service in half years, but the multiplier we had shown was 1.839, which was they're all come under UGC pay scales, my lords. So as FD objection was as on the date of if you take it as grant in aid period of 2012, multiplier was still 1. The multiplier, my lords, came in subsequently. So therefore the calculation was based on that multiplier. But now my learned friend is shown this document where basic is taken as 5891. He just passed it on to me, my lords. I'll verify that.
ಬಟ್ 2012 ತಗೊಂಡ್ರೆ 50,800 rupees ಬರುತ್ತೆ.
ಅದು my lords, that I will formally make some submission, and if interest is given up,
And let them give the calculations as
If interest ಬಿಟ್ಕೊಡ್ಲಿಲ್ಲ ಅಂದ್ರೆ
is the professor.
I will not convince him. I am telling
ಇಲ್ಲ
you.
ಇಲ್ಲ ಗೊತ್ತಾಯ್ತು.
Interest you will have to give up.
ಅಲ್ಲ let them give correct calculation at least, my lords.
ಆಮೇಲೆ interest ಅಂತ you will not get.
Please, some portion of the interest, my lords. ಅಲ್ಲ ಸರ್ಕ್ಯುಲರ್ ನಾನು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದೀನಿ, ತಮ್ಮದು ಒಂದು ಆರ್ಡರ್ ಇದೆ ಸ್ವಾಮಿ.
You are getting money
That's
without
true.
having worked for one day.
That's true, my lords.
So you should also be a bit.
That's true, my lords. It's not my fault, my lords, because it's illegal termination,
Because
my
it
lords.
was their fault. I went after them and got.
That's true,
So if
that's
you
true, my
want-
lords. That's true, my lords. When the illegal order is passed, ಅಲ್ಲ ತಾವೇನೆ
One
ನಮ್ಮ ಆರ್ಡರ್ ಅನ್ನು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದೀನಿ.
One
ಅದ್ರ ಬಗ್ಗೆ ನೆಕ್ಸ್ಟ್ ಟೈಮ್ ಡಿಸೈಡ್ ಮಾಡಿ.
ನೀವು interest ಅಂತೂ give up, or else I will not do anything. I just close the matter and ಇನ್ನೊಂದು 10 ವರ್ಷ ವ್ಯಾಜ್ಯ
ಇಲ್ಲ
ಮಾಡಕ್ಕಿಲ್ಲ.
ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ಅಲ್ಲಿ ನೋಡೋಣ.
One
Some portion at least.
next
ನಾನು ಹೇಳೋದು 8% ಇದೆ ಸ್ವಾಮಿ ಈ ಸರ್ಕ್ಯುಲರ್ ಪ್ರಕಾರ, ಗವರ್ಮೆಂಟ್ ಸರ್ಕ್ಯುಲರ್. ಅಟ್ ಲೀಸ್ಟ್ ಸಮ್ ಪೋರ್ಷನ್ ಆಫ್ ದಟ್
ಅದೆಲ್ಲ ಬೇರೆ. ನೀವು ಇದನ್ನ
ಒಂದು 4% ಆದ್ರೂ ಕೊಟ್ರೆ ಅಟ್ ಲೀಸ್ಟ್.
ಅವ್ರ ಹತ್ರ ಇಸ್ಕೊಟ್ಟಿದ್ದೀನಿ ಮ್ಯಾನೇಜ್ಮೆಂಟ್ ಹತ್ರ. ನೀವು ಸ್ವಲ್ಪ ಅಷ್ಟೊಂದು ಇದು ಮಾಡಿ-
ದಟ್ ಟ್ರೂ, ಮೈ ಲಾರ್ಡ್ಸ್. ಅದೆಲ್ಲ ನಾನು ಡಿಸ್ಪ್ಯೂಟ್ ಮಾಡ್ತಾ ಇಲ್ಲ ಸ್ವಾಮಿ. ತಮ್ಮಂದಾಗಿದ್ದಕ್ಕೆ ಅದು ಆಗಿದ್ದು, ಅದ್ರ ಬಗ್ಗೆ ಏನು
ಆರ್ಡರ್ ಮಾಡಿ ಬಿಟ್ಬಿಡ್ತೀನಿ, ಇಲ್ಲಿಗೆ ಬಿಟ್ಬಿಡ್ತೀನಿ ನಾನು.
ಇಲ್ಲ ಇಲ್ಲ ಹಂಗ್ ಬೇಡ ಸ್ವಾಮಿ.
ಏನ್
ಇಲ್ಲ
ಮಾಡಲ್ಲ.
ಹಂಗ್ ಬೇಡ, ತಮ್ಮಂದೇನ ಆಗ್ಲಿ.
Yesterday, my petition was disposed of. I'm filing my memo for,
Date may be given, my lords.
just once.
memo for being spoken to my lord. Since my lord, there is observation that my lord, subject to result of the suit and yesterday the writ petition was disposed of. But the suit is already disposed of in view of the 7 Rule 11 application. Hence the matter has,
My suit is still pending.
and that has been not, information has been not given to us.
ಏನಂತಾಗಿದೆ ಸೂಟು?
Suit 7 Rule 11 will dismiss it. Suit for partition has been dismissed.
May I make a submission? Serial number 44, serial 64, madam, I stand. Idralli recently I have entered appearance. The lords can have it. Grant me 2 weeks' time. I'll just go through the entire thing and then.
Please wait, 2014 I can't. grant.
Next matter, that Panchayat matter, my lords, there's a special bench at 2:30, my lords, in Kotal 6. I'm held up there from 2:30.
Serial number?
Next 55. It's urgent. Great.
Bill number 61, my lords, could be taken in next week. Senior council is held up today, my lords.
Which, what is the date?
61,
of this?
senior council ಆಗಲ್ಲ ಅಂತ ಹೇಳಿದ್ರು ಇವತ್ತು. ಇಲ್ಲವ್ರು otherwise I was ready.
Please wait.
Please, my lord.
ಬೆಳಗ್ಗೆನೆ ಎತ್ಕೊಂಡ್ರು 21st.
53. Sir.
ಅವ್ರೇನೋ ಹುಷಾರಿಲ್ಲ.
Court officer? Court officer. Court officer.
ಹೇಳಿ ಮೇಡಮ್.
ಸರ್ ನಮ್ಗೆ ಸ್ವಲ್ಪ ಕೇಳ್ಸಂಗೆ ಇಲ್ಲ ಏನು.
ಕೇಳಿಸ್ತಾ ಇದೆ ಮೇಡಮ್?
ಹಾ ಈಗ ಕೇಳಿಸ್ತಿದೆ. ಸಾಹೇಬ್ರು ಮಾತಾಡಿದ್ದು.
ಇನ್ನು ಬಂದಿಲ್ಲ.
ಇದು ಗಿರಿಜಾ ಹಿರೇಮಠ HCGP ಧಾರವಾಡ.
ಆಯ್ತು.
Yes. Hello, court officer.
ಹೇಳಿ ಸರ್.
Sir, Kalburgi bench matter ಯಾವಾಗ ಕರೀತೀರಿ sir?
ಸರ್ ಕರಿತೀವಿ, ಫಸ್ಟ್ ಧಾರವಾಡದಿದೆ, ಅದಾದ್ಮೇಲೆ ಕಲಬುರಗಿ.
Okay sir, thank you.
ಬೆಂಗಳೂರು ಏನ್ ಕಲಬುರಗಿ ಬೇಗ ಆಗೋದು. 56 ನೀವು ಮೆನ್ಷನ್ ಮಾಡಿ ಆದ್ಮೇಲೆ ಬೆಂಗಳೂರು ತಗೊಂತೀವಲ್ಲ ಅವಾಗ ನೀವ್ ಹೇಳಿ. ನಾ ಹೇಳ್ತೀನಿ ಬೆಂಗಳೂರು ಬೆಂಚ್ ಅಂತ ಕಾಲ್ ಔಟ್ ಮಾಡ್ತೀನಿ, ಅವಾಗ ಹೇಳಿ. ಫಸ್ಟ್ ಹೌದಾ ಜನ್ ಇಲ್ಲ 57 ಫರ್ದರ್ ಮಾಡಿ ಅಂತ. Question number 1 for pronouncement of order. Seal number 92. The O Mahesh.
Consequently, the effort of the insurer is dismissed. Thus, in modification of the order of the tribunal, the claimants will be entitled to rupees 11,62,700. The appeal of the claimants is accordingly allowed in part.
Seal number 93. The electrical order.
Appearing for the petitioners.
Light of the above, the impugn orders cannot be sustained. In the same or accordingly quashed, and it is held that the proceeding for resumption in the dispute of 1 acre 22 guntas of land in number 32 was wholly without jurisdiction, since the land could not be construed as a granted land. The petition is accordingly allowed.
Seal number 94.
The petition is accordingly allowed.
Serial number 95.
Not appearing for respondent number 11.
Pay for petition. Consequently, the writ petition filed by Munanta person, that is WP 22712/2016, is also dismissed. However, liberty is reserved to him to pursue his remedies before an appropriate forum which possesses jurisdiction to advocate upon his contention that land bearing number 140 measuring 5 acres has been granted to his father in 64, and the grant of the land bearing number 11 of Muniga in the year 28 was a bogus grant. It is made clear that any observation made in these exemption proceedings relating to the validity of the grant made in 64, Guru Munivenkatappa shall not be held against his son, that is petition WP 22712/16, in such proceeding that he may initiate. Consequently, WP 36885 of 2016 is dismissed, and WP 22712/60 is also dismissed, but subject to liberty reserved to the petitioner in WP so and so as stated above.
Obligement. Serial number 96.
Consequently, there is no merit in these writ petitions, and the petitioner is therefore dismissed.
Serial number 97. Shri Madhukar Nadi.
The impure notice are set aside and decided that the proceedings for exemption initiated by Rangappa on the premise that the land in question was a granted land is held to be totally without jurisdiction and they are quashed. Writ petition accordingly allowed.
Forward bench matters. Serial number 1. Shri Chetan.
Lords, appear for petitioner, my lords. My lords, it is covered by judgment. Lords, I have handed over the memo along with the judgments, wherein, my lords, this honorable court has already quashed in respect of accused number 5 to 7 and accused number 2, my lords. Present petition is by accused number 9 and 10, my lords.
Who appears to the government?
Please, your lordship. Girija Hiramati, lordship.
Petition 102513/2024, which was filed by accused number 5, 6, and 7. This court has quashed the proceedings that was initiated against those petitioners and also which was initiated against the present petitioner. In fact, that judgment was rendered on the basis of an earlier decision rendered in criminal petition 100515/2024. So, since the proceedings in respect of the other accused have already been quashed, we appropriate to quash the proceedings so far as the present petition is concerned, that is annexes 9 and 10. Accordingly, petition is allowed.
Please, my lords.
Admission. Serial number 2. Shri N.L. Bhattakurti.
Please, my lord. But it requires the hearing, my lords, that sometimes it's also covered by the judgment.
We must.
17. Serial number 13. Serial number 3. Shri Anil Kumar.
Very for the petitioner, I pray for short accommodation. Any date,
For further
Date.
consideration.
next week or any
17.
date 17th.
Serial number 4. Shri Vishwanath Padige.
My lords, I appear for respondent number 3, my lords, in this matter. My lords, may I seek for a short accommodation, my lords? I've informed the other side.
I'll complete my side of.
ನನಗೆ ಕಷ್ಟ ಆಗುತ್ತೆ ನೀವು ಮಾಡ್ಬಿಟ್ಟು ಹೋಗ್ಬಿಟ್ರೆ ತಿರ್ಗಾ ಅವ್ರೇನ್
ಹಾ.
ಮಾಡಿದ್ರು ತಿರ್ಗಾ this will go on forever. It's better to hear both of you and then pass an order immediately. ಇನ್ನೊಂದ್ಸಲ ಕೇಳೋದು ಅವ್ರೊಂದ್ಸಲ ಕೇಳೋದು. I'll find it difficult because he will raise some point for which he will not be able to answer. Then he'll raise some point. I again can't come back to you.
My submission, my lord, the only point that remains is on the last date of occasion, he has submitted that the Bangalore Medical College rules have been adopted to be service rules, which has come into effect from 22/12/2023.
Next Friday man ಮುಗಿಸ್ಬಿಡಿ.
Friday, there's a function.
Please.
We'll just. Next time if you ask for time, I'll proceed to pass orders.
24.
My lords, the inconvenience is that, my lords, the senior's father-in-law has passed away. Therefore, taking this adjournment.
24th.
Please, grateful, my lords.
Final is the last chance. The other side may kindly be.
But he has passed away soon.
I'm sorry then. Obliged.
Kalburgi bench matter.
For further consideration, serial number 1, Shri R.J. Pusare.
My lord, appearing for petitioner, my lord.
Ms. Mallar.
Lordship, the calculation from the petitioner is not been received from the
No, no,
agent.
no. My lord, I have served government also, my lord, and filed in the counter, my lord. My lord, the government filed a memo along with the calculation, my lord. They have calculated, my lord, 23,33,998, whereas, my lord, the petitioner also calculated, my lord, for the same period, wherein, my lord, the amounts comes to 26,78,000, my lord.
ಯಾವ ಕೌಂಟರ್ ಫೈಲ್ ಮಾಡಿದಿರಾ?
ಗುಲ್ಬರ್ಗ ಕೌಂಟರ್ ಅಲ್ಲಿ, my lord.
ಇಲ್ಲಿ ಪುಟಪ್ ಆಗಿಲ್ಲ.
Sir, 4/12/24 da. Sir, 4/12/24 da.
15/12/24.
ಬರೀ 4/12 ಇದೆಯಂತೆ.
ಇಲ್ಲ 4/12 filed by government, my lord. I have filed on 15/12.
Stated that the petition council has filed a memo 15/12/2021 at the counter in Gulbarga. Office to put up the same.
My lord, 16/12, my lord. Seal is, my lord, 16/12/24.
16/12.
17th. Serial
Please,
number
my
2,
lord.
Shri Ravi V. Patil. Serial number 2.
My lord, appearing for response number 2 and 3, my lord.
I appear for the petition in this matter. But this matter was heard at length by Lordship, my lord. Where now, my lord, the government wants to contend that, my lord, they require 1 more year time, my lord, to finalize the issue. My lord, now, my lord, the entire matter, my lord, one of the petitioner would be retiring, my lord, if the government wants to, my lord, take such long time. Therefore, my request, my lord, this matter.
Statutes ಏನು ಅದ್ರ ತಾನೆ?
ಹೌದು sir.
Madam, I'll decide the matter.
Yes, sir. On merits, it may be disposed. If at all you adopt also, it is prospectively applicable, Lordship. So the C&R will be applicable prospectively. So the present petitioner's case will be considered as per the prevailing C&R. That is the Harvard Agriculture.
Argument ಮಾಡ್ತೀರಾ?
That is my submission and it may be passed on merits.
Well, appear for response number 2 and 3, my lord. It will take a next week candidate, my lord. Only.
My lord, if some date, my lord, specific date, my lord, last time I had come to Bangalore for arguing this matter, but my learned friend had taken time. ಅವ್ರಿಗೆ ಏನೋ ಇನ್ಕನ್ವೆಂಟ್ ಇತ್ತು 17th may I request. Please.
Serial number 3, Shri S.J. Math.
Interim order in operation may kindly be extended.
Serial number 3, S.J.
But to appear for the petitioner in connected.
Daily wages ಇದೆ.
Yes, Lord. In the connected matter, in 4 of matters, I have received the affidavit. There was a common order stating that all the deputy director of the backward caste department should file the affidavit. But in some of the cases, the district officer is not the party. Only commissioner is the party. If Lordship permits, I will file the affidavit of the deputy director of the concerned department.
ಮಾಡಿ.
But they are not the party.
All right, file it. What does it mean? What difference does it make?
Obliged. They are all ready, Lordship. By next date of hearing, I will serve the copy and file.
My lord, I want to club the 5 more cases in this case, my lord. Same address ಇದೆ. My lord. Same address. I want 5 cases to club the 5 cases in this matter.
Again, for each petitioner, I have to file a separate affidavit, Lordship. Since some of them have been appointed by the different outsourcing agencies and every 2 years they get transferred.
You file an affidavit, who is available file?
Yeah, available. No, now again they want to club some more of matters.
5.
ನೋಡ್ರಿ ಫಸ್ಟ್ ಇದು ಮುಗಿಸೋಣ ಆಮೇಲೆ ತಗೋಣ.
On last date of hearing, my lord said directed learned government advocate to verify with regard to payment of arrears of salary to all the my lord's employees working on daily wages. Though work has been extracted from them, they are not being paid the salary regularly. ಅದನ್ನೊಂದು ತಾವು ಕೇಳ್ಕೊಂಡು ಹೇಳಿ ಅಂತ government
No,
adult
no. For that, please let there be a direction to the concerned the agencies. So which agency they have appointed, they are also necessary party.
Do one thing,
ಅಲ್ಲ
do one thing, make an application, give him details and ask them to pass orders on that application.
ಸರ್ ಪಾರ್ಟಿ ಪೆನ್ಷನರ್ ಕಡೆಯಿಂದ ಕೆಲಸ ತಗೋತಾ ಇದ್ದಾರೆ ಸರ್, ಬಟ್ ದೇ ಆರ್ ನಾಟ್ ರೆಡಿ ಟು ಪೇ ಸ್ಯಾಲರೀಸ್. ಜನತೆಗೆ ಇನ್ ಆಲ್ ಕೇಸಸ್ ಇದು ಸ್ಟೇ ಇದ್ದನ್ನು ಕೂಡ ಅಂತಂದ್ರೆ ಅವ್ರಿಗೆ ಇದು ಮಾಡ್ತಾ ಇಲ್ಲ.
ಇಲ್ಲ, ನೀವು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿ ಎಷ್ಟೆಷ್ಟು ಬಾಕಿ ಬರ್ಬೇಕು ಅಂತ ಡೀಟೇಲ್ ಮಾಡ್ಕೊಡಿ ಒಬ್ಬೊಬ್ರದ್ದು. ಐ
ಹೌದು
ಆಸ್ಕ್ ಟು ಕನ್ಸಿಡರ್ ಅಂಡ್ ಪಾಸ್ ಅನ್ ಆರ್ಡರ್.
ಓಕೆ
please
ಪ್ಲೀಸ್.
17.
please
Serial number 4. Here, my lord. Yes, lectures matter was heard sufficiently, my lord, and the lordship directed us to give synopsis ಮತ್ತು judgments ಎಲ್ಲ ರೆಡಿ ಇದೆ. Matter in fact, my lord, request decided. ಅವರೇ ಹೇಳಿದಾರೆ ವೇಕೆನ್ಸಿ ಇದೆ ಅಂತ, ಅವರೇ ಪೊಸಿಷನ್ ಕೊಟ್ಟಿದ್ದಾರೆ. I think
ಏನ್ ಮೇಡಮ್?
much time.
Lordship, the contesting respondent on behalf of university, the Sudarshan M sir is appearing.
My lord, please, my lord, we have filed, my lord, statement of objection and also, my lord, last occasion, my lord, judgments allowed on behalf of, my lord, list of judgments also, my lord, I have filed. Lord, accordingly, my lord, it may be taken up in, my lord.
Lord, I am also filing, my lord, my friend is filing. Judgments ಮತ್ತು synopsis complete ಇದೆ. Lord, they on the last occasion, last chapter recollect, my lord, they are given the, my lord, the vacancy position also. They are with us on that line also, my lord. Therefore, matter requires to be, my lord, decided.
Lord, the point involved in this case is, my lord, a guest lecturer. Lord, the university, my lord, it is, my lord, making submission, my lord, with regard to that guest lecturer. Lord, at any point of time, my lord, not entitled for any regularization. As my lord, on that line of argument only, my lord, we, my lord, rely on.
May I pass on these two? The judgments plus synopsis also is there. Even first judgment itself by your lordship, my lord, in that Vijay Rani case alli, my lord, all these aspects have been considered, my lord. First judgment alli ide. Your lordship judgments, my lord, dated 25th September 2024, my lords. Following Uma Devi's case, my lord, your lordships have held it. Synopsis may, my lord, kindly see.
Even not your synopsis, Sudarshan.
Statement of objection.
Please, my lord, I have filed, my lord, my lord, judgments which relied, my lord. It is a compilation dated, my lord, 29/11/2024.
Have you seen a synopsis?
Lord, Synopsis, my lord, I have not received, my lord.
ಅವ್ರು ಕೊಟ್ಟಿರೋ ಕಾಪಿ.
ಇಲ್ಲ ಅವ್ರಿಗೆ ಲಾಸ್ಟ್ ಟೈಮ್ ಒಂದು ಬೇರೆ ಈಗ ರೀಸ್ಟ್ರಕ್ಚರ್ ಮಾಡಿ ಕೊಟ್ಟಿವಿ ನಾವು. Earlier in fact ಕೊಟ್ಟಿದ್ದೀವಿ ಬಟ್ ಇವತ್ತು
Actually, if he agrees on those aspects, then dictation would be easier.
ಅಲ್ಲ ಡೇಟ್ಸ್ ಅಂಡ್ ಇವೆಂಟ್ಸ್ ಪಿಟಿಷನ್ ಅಲ್ಲೇ ಇದೆ ಬಟ್ ಟುಡೇಸ್ ಸಿನಾಪ್ಸಿಸ್.
Why don't you give this to him? Let him have a look at it and then we'll take it.
Very very
Monday, because ನಾನು
very well. I shall see that served upon him. Judgments as well as my lord. So that let him also, my lord, you will also direct him to, my lord, before ಅವರು ಕೊಟ್ಬಿಟ್ರೆ that ends the.
ನೀವು ಹಾಕಿದ್ರೆ synopsis.
My lord, I filed my memo of citations, my lord, and statement of objection. Lord, it is for the, my lord, anyhow petitioner to, my lord, place the synopsis in, my lord, chronological way. Lord, please.
Monday, my lord, can I expect?
Friday.
Much of, please.
17th.
Serial number 5.
My lord, appearing for petitioner, filed amended writ petition, my lord, on 6th January. That is not put up, my lord.
Lord, one request, I'm sorry. May I excuse me, sorry. Matter has been going on like this. Let it be the last date. Before that, let him organize. I will also see to it that is served.
What first?
Tomorrow itself, my lord, my parties are, they will go and 17th.
ಹಾಕಿದ್ರೆ amended petition. When did you file the amended petition?
6th January we have filed.
Just put up. Yes.
Please, ma'am.
Copy ಕೊಡಿ ಅವ್ರಿಗೆ.
Please, I have served the copy to the government, my lord.
R2 ಕೊಡಿ.
Yes, my lord, please.
My lords, I appear for the petitioner, my lords. My lords, in this matter, the government had to give their response about the notification for special concessions for the people working in North Karnataka, my lords, Hyderabad, Karnataka region.
Madam.
Lordship, on that 317, only while considering the Lordship, Vijay Kumar sir will argue on this matter.
My lords, this has been going on since long, my lords, more than 6 months. They've been only been saying double AG will come, that person will come, but they're not ready to argue, my lords. Now we are in the 5th year, my lords.
Yes, madam.
Lordship, by next date of hearing final it will be.
If you don't argue
My
next
lords,
time,
I would
take it as
request.
Yes, madam.
Lordship,
If you don't argue next time, I take it as reserved.
yes, yes, finally.
Date may be given, my lords.
20. Friday, 17.
Obliged.
Bench matters.
Week after next, Lordship, week after next, 17.
17.
Week of next Friday week.
Yes.
On submission, my lords. Serial number 90, BBMP official is present. The court had directed his presence for issuance of e-khata, a simple matter, my lords.
Serial number?
90. 90. 91, my lords, I'm sorry, 91.
91 now. Now serial number?
91. I may refresh my lord's memory. What has happened is I had filed e-khata applications. Twice over it has been rejected. There's a BDA sale deed that's been executed. It has to be registered.
Father's name and Dada.
For me? Huh.
Yeah, father's name.
Fathers, yes. So.
Had his father had a company. Lease was the lease from sale. Now, my lord, the government of Karnataka, my lord, they have
My lord, I do understand this problem, my lord, because without this, this cannot be done, and without this, this cannot. Probably this may be an exception, my lord, wherein the khata may be transferred to him, not by law, but lordship passes an order. Then, my lord, we will definitely be considering that, but we will see that the khata is being done. But right now, my lord, with the circulars in operation, my lord, it's difficult, my lord, because
The Kata was in the name of H. Anant Bhatt,
yes,
who has a lease cum sale agreement in his
he
name.
is from the BD.
When did he die?
2013, my lord,
Date Andre?
My lord, he has passed away on 10/2/2013.
When was lease cum sale agreement executed?
3/9/1994.
You have sought for execution of the sale deed.
No, I have sought for issuance of e-khata. Sale deed has already been executed by BD. I have annexed it also.
In your favor.
Yes, only the registration is pending.
When was that?
My lord, 25th of October 2024.
The 5th of
October 2024.
pending registration.
Yes, my lords.
What is the prayer that you have sought for?
I've sought for issuance of e-khata, my lords. A writ of mandamus directing the respondents to.
What difficulties until there's a sale deed, you can't do it, Antana? These facts are not in dispute. The petitioner is the only son of Shri H. Anant Bhatt, who was allotted site bearing number
156 of Saraki second stage. Now JP Nagar second phase.
156
Of Saraki second phase.
on Saraki second phase extension.
Second extent, second.
JP Nagar second stage, second phase. Measuring 65 feet by 45 feet.
45.
The BDA executed a lease cum sale agreement in favor of Anant Bhatt on 3/9/84. On the basis of this allotment and lease cum sale agreement, the BDA also registered the Kata in the name of Anant Bhatt. Unfortunately, Shri Anant Bhatt passed away on 10/2/2013. And the petitioner, being his only son, sought for execution of a sale deed from the BDA as the lease cum sale period had elapsed. The BDA accepted this request and have executed a sale deed on 25/10/2024. And the said sale deed is also presented for registration. However, the sub-registrar has kept the registration pending on the ground that the petitioner was required to furnish an e-khata as per the requirement of the government circulars issued in that regard. Learned counsel appearing for the BBMP submits that though the khata was turned in the name of Shri H. Anant Bhatt, the e-khata cannot be issued in the name of his son unless the registered sale deed executed in his favor. He also admits that for the purpose of registering of the sale deed, an e-khata is essential. In the light of the undisputed fact that the khata was in the name of H. Anant Bhatt during his lifetime, on his death, the petitioner, being the only son, has undoubtedly succeeded with the property. As a consequence, the BBMP will have to register an e-khata in his favor, notwithstanding the fact that there is no sale in his favor. It is to be noticed here that the khata would be transferred not on the basis of a document in the event of the death of a khatadar, but in the light of a succession that his children in right of succession in favor of the children of the khatadar. Consequently, it will be necessary to direct the BBMP to register an e-khata in favor of the petitioner immediately. Next, on the issuance of the e-khata, the sub-registrar shall proceed to complete the registration in favor of registering the sale deed in favor of the petitioner. The petition accordingly disposed of.
One request, Your Honor, my lord. 2 weeks' time may be fixed for issuance of e-khata. I can, the 25th of February is the last date for me to.
Directed to issue an e-khata in favor of the petitioner within a period of 2 weeks. And the sub-registrar is directed to complete the registration within 2 weeks thereafter.
Grateful.
Passed over matters, serial number 10. Nagaraj Naidu.
Regarding this matter, the members before filing their
no confidence letter. I have filed a complaint before the Commissioner for Panchayat Raj, my lord. I'm producing here. Please
So
file.
what can be done? Suppose you were complaint, what should
Disqualify Madi and help it to 5 members. I have filed a complaint. That investigation has been initiated, my lord.
once you give a complaint, they proceed. You don't need to worry about that. ನಿಮ್ದು ಹೇಳಿ sir.
ಅಲ್ಲ ಅವ್ರು ಬಂದಿಲ್ಲ ಮೀಟಿಂಗ್ ಅಟೆಂಡ್ ಮಾಡಿಲ್ಲ ಸ್ವಾಮಿ ಅವ್ರು ಡಿಸ್ಕ್ವಾಲಿಫೈ ಆದ್ರು ಅಂತ ಅಂದ್ರೆ ದಿಸ್ ಮ್ಯಾಟರ್ ವಿಲ್ ಬಿಕಮ್
These facts are not in dispute.
Mala kindly take up the matter next week, Mala.
On, when was the first notice?
That is
On 4/12.
4/12, Mala.
4/12/2024.
Yes, Mala.
9 members of the Panchayat moved a motion.
8 members, Mala.
9 and
9 is there, but only 8 members has moved the letter, Mala. 1 member has not signed.
on 4/12/2024. A requisition was given by 9 members of the Panchayat, though signed only by 8 members, to the Assistant Commissioner, requesting him to convene a special meeting to consider a motion of no confidence that they intended to move. On the basis of this notice, the Assistant Commissioner convened a meeting on 31/12/2024. However, the petitioner being aggrieved filed WP 34476/2024 and this court by an order dated 18/12/2024 granted an interim order. However, while granting an interim order, this court has also stated as follows, page 44. As could be seen from the above, this court permitted fresh proceedings to be initiated, notwithstanding the interim order that this court had granted. It was permissible in law. On the basis of this liberty granted by this court, the members have once again given a motion of no confidence on 31/12/2024. And on the basis of this requisition, the meeting is convened on 21/1/2025 to enable the signatories to the requisition move a motion of no confidence. Being aggrieved by this, the petitioner is before this court. Then on consider the petitioner submits that since the petitioners were consistently absent, the petitioner had given a petition to the authorities to disqualify them, and as a retaliation, they have moved the motion of no confidence. She therefore submits that the entire initiation of proceedings was manifested and are therefore required to be quashed. The right to move on no confidence motion rests with the members of the Gram Panchayat. And the reasons for moving a motion of no confidence is simply that they have no confidence in the adyaksha. Whether this move is vitiated by malafides or not would be an irrelevant factor, since the petitioner, who is the adyaksha, will have to prove that he has the confidence of all the members of the Panchayat. The requisition was given as required under the provisions of the Act, and on the basis of the requisition, the Assistant Commissioner has acted in accordance with law by convening a special meeting. In my view, there is no infirmity in the convening of a special meeting, and therefore the requisition is dismissed.
Number 36.
Yes.
It's a cover by judgment, my lord, is the inclusion of father's name in the death certificate, my lord.
There is. On.
My instruction is that on your Aadhaar, on your, they are produced on the Aadhaar card.
What else you want?
Maybe given some other supporting documents also.
Like what?
Like school certificate or national.
ಯಾರು ಇವ್ರು ಬೇಕಾ?
Where they.
Deceased, my lord.
His father was an agriculturist. What was your father doing?
He's an agriculturist, Mala.
In Kande.
Yes, Mala.
ಕೊಟ್ಟಿದಾರಲ್ಲ.
Voter ID.
That base only I asked you to. ಏನ್ ಹೇಳಿ ಸುಮ್ಮನೆ don't, the person is dead. You want to arrest even
Some other person, because the addresses which they have given are different, the death certificate address is different. Aadhaar card address is different. So, this actually, so, we want, we can ask for some documentation.
ಒಬ್ರೇ ಮಗನೇ ಅಂದ್ರೆ ನೀವು ಒಬ್ರೇ ಮಗನ?
ಹೌದು.
ಬೇರೆ ಅಕ್ಕ ತಂಗಿರು ಅಣ್ಣ ತಮ್ಮಂದ್ರೆ ಯಾರಿಲ್ಲ?
As of ನನ್ನ ನಾಲೆಜ್ ಇಲ್ಲ ಮಲ್ಲ, ಒಂದು ಒಬ್ಬರೇ ಗಂಡು ಮಗು ಅಂತ ಹೇಳಿದ್ರು.
Some amount is kept in that. Some other officers should not able to do this, so we will take some other documents.
Find out what is the document you want. I'll ask him to furnish it. The moment I let go of this petition, will again give one endorsement, again they will come to the court. I think for small things like this, you should not make them run around. Or not revoke or again by document ಕೇಳ್ರಿ ಅವ್ರಿಗೆ. You give it to them, I'll see that it is done here only instead of asking them to pass one more order. Go meet them once.
15 minutes. Mala, maybe taken up in the 20th, Mala.
You first ಹೋಗಿ ಬನ್ರಿ ಅಲ್ಲಿ. What is the problem?
15th I'll not be here, Mala. Case in Udupi.
Ask your client to go meet that officer.
Further consideration, seal number 56, Ajay Kumar Patil.
ಅಲ್ಲಿ ಗವರ್ಮೆಂಟ್ ಅಡ್ವೊಕೇಟ್ಗೂ ರೆಕಾರ್ಡ್ಸ್ ತರಿಸ್ಲಿಕ್ಕೆ ಹೇಳಿದ್ರು, ಅವರಿಗೂ ಸ್ವಲ್ಪ ರೆಸ್ಪಾಂಡೆಂಟ್ಸ್ ಆಲ್ಸೋ ಹ್ಯಾಡ್ ಬೀನ್ ಡೈರೆಕ್ಟೆಡ್ ಟು ಪ್ರೊಡ್ಯೂಸ್ ಸಮ್ ರೆಕಾರ್ಡ್ಸ್. ನಾನು ತರಿಸಿದ್ದೀನಿ, ಬಿಕಾಸ್ ದೇ ಹ್ಯಾವ್ ಬೀನ್ ಡೈರೆಕ್ಟೆಡ್, ಐ ಹ್ಯಾವ್ ನಾಟ್ ಪ್ಲೇಸ್ಡ್ ಇಟ್ ಆನ್ ರೆಕಾರ್ಡ್, ಬಟ್ ಎವ್ರಿಥಿಂಗ್ ವಾಸ್ ಇನ್ ದಿ ಫರ್ಮ್ಸ್ ನೇಮ್. This is relating to, your lordship may recall, permits and the registrations of the buses.
The permit was in the firm's name.
My lord, firm, everywhere, even as per their records, all the permits are in the name of the firm. Two names appear first. Below that, partners ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಬರೆಯುತ್ತೆ. ಪ್ರತಿಯೊಂದರಲ್ಲೂ ಅವರೇ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿರೋ ಡಾಕ್ಯುಮೆಂಟ್ಗಳಲ್ಲಿ. ಹೀಗಾಗಿ ತಾವು ಏನ್ ಹೇಳಿದ್ರ, ಇಬ್ರು ಪಾರ್ಟ್ನರ್ ಅಲ್ಲಿ ಇಬ್ರು ಸತ್ತೋಗಿದ್ದಾರೆ. ಇವಾಗ ಒಬ್ಬ ಪಾರ್ಟ್ನರ್ದು ಮಕ್ಕಳಾದ್ರೂ ಹೆಸರು ನಾನು ಹಾಕ್ತೀನಿ ಅಂತ ತಾವು ಹೇಳಿದ್ರ. ಆ ಸ್ಟೇಜ್ ಅಲ್ಲಿ ಇದ್ದಾಗ ಅವರು ಸ್ವಲ್ಪ ಅದು ರೆಕಾರ್ಡ್ಸ್ ಎಲ್ಲ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ಬೇಕಾಗ್ಬೋದು ಅಂತ.
Regarding respect of permit, they are claiming that as a whether we are got the right, that is their claim. My lord, in this aspect, my lord, they have to make a, they have to go before the transport for the reason, for administration that is the owner of the.
Then why did you delete somebody's name?
Deletion, your lord's friends.
If you could have said the same thing about the deletion also. You became a civil court then for that purpose.
Was not a form, in the name of Vijay Motor, Vijay Motor, two brothers for their name.
ಪಾಲುದಾರರು ಅಂತ ಬರೆದಿರ್ತಾನೆ permit ಅಲ್ಲಿ. It is not as their individual names. You were specifically said partners of a firm.
Out of 18 permits, 12 permits that earlier it was passed. In 2011, the firm, the dissolution, the firm was, the dissolution suit was filed. Then during the pendency, only three, one died and two were remaining. Now that out of two, the other one, the husband of this present, the permit holder, he also died. So there is no firm is in existence. Even from this one after that, it is only.
ಇವಾಗ ಯಾರ ಹೆಸರಿದೆ ಅದು?
ಈಗಿರೋದು ಹಸ್ಬೆಂಡ್, ನಮ್ಮ ಅನ್ಕ್ಲೈಂಟ್ ಹಸ್ಬೆಂಡ್ ಹೆಸರು ಇರುತ್ತೆ. ಪ್ರಕಾಶ್.
ಎಷ್ಟು?
ಪ್ರಕಾಶ್ ಹಸ್ಬೆಂಡ್ ಆಫ್ ಜಯಶ್ರೀ ಕೃಷ್ಣ.
ಜಯಪ್ರಕಾಶ್.
ಜಯಪ್ರಕಾಶ್ ಅವ್ರ ಹೆಸರು ಇರೋದು ಪರ್ಮಿಟ್ ಇರೋದು. ಬಸ್ಸಸ್ ಅವ್ರ ಹೆಸರು ಇರೋದು. ಈಗ they are not the applicants for transfer of permit. After the death of the permit holder, section 82 says person succeed into the possession of the vehicle intended for transfer. Now, as a firm, the firm is not in existence. There should have been administrator appointed by the civil court to look after the firm affairs. That has not been done. For the purpose of section 82 is.
So what should happen? Suppose the firm does not exist. How can it stand in your name then?
No, it is my 2006 itself, it is my
How?
name.
No, you are saying that the firm does not exist. Then how can it stand in the
No,
name of,
it is dissolved, it is dissolved firm.
then how can it stand in the name of one particular partner?
No, it is as per the order of 2016. That out of.
On your request,
No, it is as
On
per
your
the order of
request.
the RT, as per the order of the RT.
on your request.
Yes, it is my application.
How can
not
you,
my request.
if you are saying that the firm did not subsist and it stood dissolved, how could you have made an application? On what basis did you make the application?
No, it is, once other person died, I made an application under section 8.
ನೀವು
Transfer was made.
ನಿಮ್ಮ ಆರ್ಗ್ಯುಮೆಂಟ್ ನಿಮ್ದೇ ಒಂದು ಕಾಂಟ್ರಡಿಕ್ಷನ್ ಆಗ್ಬಿಡುತ್ತೆ. If the firm is dissolved,
Firm dissolved.
your name can't be entered.
No, that it is not showing under the motor vehicle side. That's it, kindly say, section 82, what the division means on.
If you are saying that the firm stood dissolved,
Yes.
you will not be entitled to succeed to the vehicle.
No, that section 82 says that on the date of this one, death of this Vijay Prakash, it was in his name.
ಅದ್ ಕೇಳಿದ್ದು ನಿಮ್ಮ ಆರ್ಗ್ಯುಮೆಂಟ್ ಹುಷಾರಾಗಿ ಮಾಡಿ ಅಂತ. ನೀವು ಫರ್ಮ್ ಡಿಸಾಲ್ವ್ ಆಗೋಯ್ತು ಅದಿಲ್ಲ ಅಂತಂದ್ರೆ ಯಾರು ಹೆಸರಲ್ಲಿ ಇರಕ್ಕಾಗಲ್ಲ ಅವಾಗ.
ಯಾರ ಹೆಸರು ಇರಕ್ಕಾಗಲ್ಲ ಪರ್ಮಿಟ್ಸ್ one must be in operation.
ಸೊ ಅದಕ್ಕೆ ಮಾತ್ರ
ನಾವು ಓಡಿಸಲ್ಲ, ಒಬ್ರು ಓಡಿಸ್ಬೇಕಲ್ವಾ?
ಅದಕ್ಕೆ
ಸರಿ, ಬೇರೆ ಈ ಪಾರ್ಟ್ನರ್ಶಿಪ್ ಫರ್ಮ್ ಬೇರೆ ಅದರ್ ಕಾನ್ಸೆಪ್ಟ್ ಬಿಸ್ನೆಸ್ ಇಲ್ಲ ಸರಿ. ಇಲ್ಲೇನಾಗುತ್ತೆ, ಪರ್ಮಿಟ್ ಅನ್ನು ಯಾರು ಓಡಿಸ್ಬೇಕಾಗುತ್ತೆ. ಈಗ ನಾವು ಓಡಿಸಿದ್ರು ಕೂಡ ಸಿ ಹ್ಯಾಸ್ ಟು ಗಿವ್, ಸಿ ಹ್ಯಾಸ್ ಟು ಬಿ ಆಡಿಟೆಡ್ ಅಂಡ್ ಸಿ ಹ್ಯಾಸ್ ಟು ಗಿವ್ ಅಕೌಂಟ್. ಪೆಂಡಿಂಗ್ ಸೂಟ್ ಬಿಫೋರ್ ದಿ ದಟ್
ಮಾಡ್ಲಿ, ಪರ್ಮಿಟ್ ಎಲ್ಲರ ಹೆಸರು ಇರ್ಲಿ ಅಷ್ಟೇ. ಯಾರ್ಯಾರು
ಅದಕ್ಕಿಂತ ಮುಂದೆ ಯಾರ ಹೆಸರು ಇವಾಗ ಈಗ ಒಬ್ಬರ ಹೆಸರು ಇತ್ತಲ್ವಾ?
ಫರ್ಮ್ ಹೆಸರಲ್ಲಿ ಪರ್ಮಿಟ್ ಇದ್ರೆ ಆ ಫರ್ಮ್ ಅಲ್ಲಿ ಹಂಗಾರೆ ನಿಮ್ಮ ಹೆಸರು ಬೇಡ ಅಲ್ಲ. ಫರ್ಮಲ್ ಬೇಡ ಹಂಗಾರೆ ನಿಮ್ ತೆಗೆದಕ್ಕೆ ಬರೀ ಅವರು ನಿಮ್ ತೆಗೆದಕ್ಕೆ ಬರೀ ಅವ್ರ ಒಬ್ರದ್ದು ಯಾಕೆ ಕೇಳಲ್ಲ?
ಅಲ್ಲ ಸ್ವಾಮಿ, ಅಲ್ಲ ಅವ್ರು ಕ್ವಶನ್ ಮಾಡ್ಬೇಕಾದ್ರೆ 2016 ಆರ್ಡರ್ ಆಯ್ತು, ಆಗ್ಲೇ ಕ್ವಶನ್ ಮಾಡಿದ್ರು.
ನೀವ್ ಹೆಂಗೆ ಕೇಳಿದ್ರಿ ಅಂತ ನಂಗೆ ಅರ್ಥ ಆಗ್ತಾ ಇಲ್ಲ.
ಅಲ್ಲ, ನಾನು ಅದಕ್ಕೆ ಒಂದು ಸಿನಾಪ್ಸಿಸ್ ಮಾಡಿದ್ದೀನಿ. 12 ಪರ್ಮಿಟ್ಸ್ ಅಲ್ಲಿ ಏನೇನಾಯ್ತು ಅದ್ರಲ್ಲಿ, ಆಮೇಲೆ ಅದು ಹೇಗಿದ್ದಾಯ್ತು. ಈಗ ಅವರು 2016 ನನ್ನ ಹೆಸರಿಗೆ ಬಂದಾಗ ಅವ್ರು ಕ್ವಶನ್ ಮಾಡಿದ್ರು, ಅದನ್ನ ಅವ್ರು ಹಾಕ್ಲಿಲ್ಲ, ಅದನ್ನ ಅವರು ಕೇಳಲಿಲ್ಲ. ನನ್ನ ಹಸ್ಬೆಂಡ್ ಓಡಿಸ್ತಾ ಇದ್ರು.
RTO ಅವರು ನೀವು ಹೇಳ್ದಂಗೆ ಕೇಳಿದ್ರು.
ಇಲ್ಲ, ಅದಕ್ಕಿಂತ ಮೊದಲೇನೆ 2016 ಅಲ್ಲಿ ನಮ್ಮ ಹೆಸರಿಗೆ ಬಂದು ನಾನು ಗಾಡಿ ರಿಪ್ಲೇಸ್ ಮಾಡಿ ನನ್ನ ಪೊಸಿಷನ್ ವೆಹಿಕಲ್ ಇದೆ. ಈಗ ನಮ್ಮ ಪೊಸಿಷನ್ ವೆಹಿಕಲ್ ಇದ್ದಾಗ ಸೆಕ್ಷನ್ 82 says person succeed into the possession of the vehicle is entitled to transfer, and division bench says any order passed under section 82 will be a subject to final decision of the civil court pending ಅಂತ. ಈಗ ಅದು ಅಲ್ಲಿವರೆಗೆ ತಾನೇ ನಮ್ಗೆ ಬರ್ತಿರೋದು, ಅಲ್ಲಿ ಮತ್ತೆ ಅಲ್ಲ, their right is not lost.
ಇಲ್ಲ, 18 stage carriage permits, 12 were in the joint name of Srinivas Shenoy and KV Jayaprakash.
Yes.
ಮಿಕ್ಕಿದಾರು
12 ಮಿಕ್ಕಿದ್ದು 8 ನಮ್ಮ US ಒರಿಜಿನಲ್ ಜಯಪ್ರಕಾಶ್ ಅಲ್ಲಿ.
Is it a fact?
ಅವ್ರ ಹೆಸರಲ್ಲಿ ಹೌದು, ಬಟ್ he was the one who was authorized to obtain the permits for the firm. ಅವನ ಇಂಡಿವಿಜುವಲ್ ಹೆಸರು ಮೊದಲು ಕೆಳಗಡೆ ಪಾಲುದಾರ ವಿಜಯ ಮೋಟಾರ್ ಸರ್ವಿಸ್ ಅಂತ ಆ ಉಳಿದ್ರಲ್ಲಿ ಅದರಲ್ಲಿ ಪ್ರತಿಯೊಂದರಲ್ಲೂ ಪಾಲುದಾರ.
Show me those 6 permits which you claim was standing in your.
I produce that is in my statement of objection. I produce. Endorsement and
Page number.
How WP? 16.
15/6/26 ನಲ್ಲಿ I produce. First, I produce the R3A in the response and the statement of objection.
They 1664 ಅಲ್ಲಿ.
R3A1 ಇಂದ ನಾನು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿ.
1662.
R2A ಅಂತ ಇದೆ ಅಲ್ಲಿ.
R3A1 ಅಂತ.
ಯಾವ ರೇಟ್ ಪಿಟಿಷನ್ ನಿಮ್ಮ ಹತ್ರ? ರಿಫ್ಲೆಕ್ಷನ್ಸ್ ರೆಫರ್ ಮಾಡ್ತಿದ್ದಾರೆ.
Statement of objection.
ಯಾವ WP? ಈಗ ನೀವು ರೆಫರ್ ಮಾಡ್ತಿರೋದು ಯಾರು? 16 642.
Permit and subsequently renewal endorsement, the order, the RTA.
Hold on. You admit that 12 were joint names of Shenoy, Shima Shenoy and Jayaprakash.
Then his name was deleted thereafter.
ಅಲ್ಲ, ನೀವು ಇನ್ನು 6 ಅವ್ರ ಹೆಸರಲ್ಲೇ ಇತ್ತು ಅಂದ್ರಲ್ಲ ಇಂಡಿವಿಜುವಲ್ ಆಗಿ. ಜಯಪ್ರಕಾಶ್ ಎಲ್ಲಿದ್ದಾರೆ?
8 6 ಮಾತ್ರ.
6. Which are those permits?
You mentioned it, the copies of produced, I mentioned it in my synopsis, I mentioned it.
ಇಲ್ಲ ಬರೀ 12 ಹೇಳಿದಾರೆ, ಇನ್ನು 6
Next paragraph.
Now where are the permits? All the 18 permits.
Permit copies that are produced with along with the statement.
ಅದನ್ನೇ I'm asking you page number.
Statement of election, that is copies of permit as well as the renewal endorsement.
ನಿಮ್ಮ ಹತ್ರ ಇಲ್ವಾ ಕಾಪಿ ಇಲ್ವಾ?
ಟೂಲಿಂದ ನಾನು ಇಲ್ಲಿ ಒಂದು synopsis in what can take page 7 ನಲ್ಲಿ permits were not in the joint name. Permit.
I want to verify that. That is why. I want to verify whether it was in your individual name or you were described as the partner of that Vijaya Motor Services.
It is, it was in the name
ನಿಮ್ಮ ಹತ್ರ ತಂದಿ ರೆಕಾರ್ಡ್ಸ್ ತಂದಿದ್ದೀರಾ? 18 ಪರ್ಮಿಟ್ ಇದೆಯಾ ನೋಡಿ.
ತಾವು R2A34 ತಮ್ಮ ಗಮನಕ್ಕೆ ತಂದ್ರೆ ಇನ್ WP 16642 R2A34 ಅಂತ ಪೇಜ್ ನೇಷನ್ ಅನ್ಫಾರ್ಚುನೇಟ್ಲಿ ನಂದರಲ್ಲಿ ಪೇಜ್ ನೇಷನ್ ಇಲ್ಲ. R234 ಅದರಲ್ಲಿ ಪರವಾನಗಿ ವರ್ಗಾವಣೆ ಹಿಂಬರಹ ಜಯಪ್ರಕಾಶ್ ಬಿನ್ ಲೇಟ್ ಇವರು ಪಾಲುದಾರರು ಶ್ರೀ ವಿಜಯ ಮೋಟಾರ್ ಸರ್ವಿಸ್. ಅವರ ಹೆಸರು ಮೊದಲು ಬರ್ತಾ ಇತ್ತು, ಆಮೇಲೆ ಪಾಲುದಾರರು.
Earlier it was on the name of one Lease for the period from 97 to 2002. It was transferred to the name of Jayaprakash on 27/8.
ಬರೀ ಜಯಪ್ರಕಾಶ್ ಅಂದ್ರೆ ಒಪ್ಕೊಳ್ತೀನಿ. If ಜಯಪ್ರಕಾಶ್ is described as a partner.
ಅಲ್ಲಲ್ಲ, ಜಯಪ್ರಕಾಶ್ ಹೆಸರಿಗೆ ಜಯಪ್ರಕಾಶ್ ವಿಜಯ ಮೋಟಾರ್ ಸರ್ವಿಸ್ ಅಂತ ಹೇಳಿದ್ದಾರೆ.
ಹೌದು.
ಓದಿ.
Permit number 118/96.
ಇರಾಕೊಪ್ಪ ತಾಲೂಕು ಇವರು ಹೊಂದಿರುವ ಪರವಾನಗಿ ನಂಬರ್ 118/96-97 ಅವಧಿ 13/16/3 ಇರುವುದನ್ನು ಇವರ ಹೆಸರಿನಿಂದ ಶ್ರೀ ಕೆ ಜಯಪ್ರಕಾಶ್ ಬಿನ್ ಲೇಟ್ ಕೆ ವೆಂಕಟೇಶ್ ಶೆನಾಯ್ ಪಾಲುದಾರರು ಶ್ರೀ ವಿಜಯ್ ಮೋಟಾರ್ ಸರ್ವಿಸಸ್ ರಸ್ತೆ.
ಅವ್ರದೇ ಡಾಕ್ಯುಮೆಂಟ್
118 is what in the name of Mumbai Sisur originally. That yes, this one got it transferred to his name.
You do one thing, you furnish all the 18 permits along with the application requesting for transfer. Who made the application in what format? All the 18 permits. Or asking to file an affidavit indicating in whose name it was standing and in at whose request it was transferred. ಅಷ್ಟೇ ಅಲ್ವಾ?
ಅಷ್ಟೇ.
ನಾನು synopsis ಹಾಕಿದ್ದೆ that I was because my position is because now the permit is not in existence. Till the disposal of this one, someone's name must be there.
You file it today only or what is it? With the file ಮಾಡಿದ್ರೆ ಏನ್ ಮಾಡ್ತೀವಿ? Next Friday.
Seal number 57 adjourned. Seal number 58, Shri Pawan Chandra Shetty.
Released.
For final hearing, seal number 59, Shri N. Ramchandra. Seal number 59, Shri N. Ramachandra. Srimati Geeta Devi Papana, Shri correspondent.
Actually, card fraud. They have preferred MOA. MOA there is, MOA has been different from the preferred RS. The permanent index, that is pending petition and art.
There is no appearance on behalf of the petitioner. Matter being of the year 2013, there is no justification for petition that for dismissal of us.
Bill number 60. Arjun Rao.
Hearing for the petitioner, Your Honor. Your Honor, we only filed our NOC Wakalat recently. The matter has come up for the first time since then. 2 weeks' time may be granted to prepare, Your Honor.
It's a 10-year-old matter, Your Honor, I can't grant you time.
Your Honor, I understand, Your Honor, short accommodation, 2 weeks' time, we'll advance our final hearing.
In matter, Your Honor.
Matter relating to review of advertisement and collection of room rent, license fee in respect of erection of holdings.
Where, Willie?
The Appidanadi within the limits of the Appidanadi Gram Panchayat. David.
You issued them a demand notice, huh?
He issued determined and issued the demand notice, not paid. They have obtained an interim order from the court and carrying on the litigation without even paying even the ground rent or the license fee as required under the act.
It is on private land or on?
It's on the property belonging to the municipality. Gram Panchayat.
Monday, get ready by Monday.
Your Honor, 1 more week time, Your Honor.
Wednesday,
Wednesday.
Much obliged.
number 61. Vivek Gunjan.
I appear for the petitioner, my lord. We will take on next week, my lord. So senior counsel wants to turn the next week, my lord, is in another court.
Yeah,
We
what
take
is
it the
matter
next
about?
week. Pardon, my lord.
What is the matter about?
Matters about the layout has been approved, showing the road on my land, my lord. So they want access on my land in excess of what the land they own. That is the issue, my lords.
No. They have challenged the conversion.
Earlier, they
order,
have
my
sold some land to me. On that land, now they want to show the road. They have got another access. That's the issue, my lords.
Your case is that they have formed a layout, they have approved a layout in, that should be your
Huh?
land.
But
That is his case.
Conversion is challenged before. He is challenging my conversion order, my lord, in my favor. I've already
Next
made
one.
the layout.
So he is challenging annexure B, ತಾನೆ?
The conversion order ne challenge ಮಾಡ್ತಾರೆ.
This is ಪ್ರದೇಶ ವಸತಿ ವಿನ್ಯಾಸ ಅನುಮೋದನೆ ನೀಡುವ ಬಗ್ಗೆ. Is challenging an approval grant to a layout plan.
Approved, yes,
Ultimate
layout
only turned
plan
to
is
page
also
51.
approved. And when I sold 1 or 2 sites, he came before this honorable court. I filed my counter, my lord, in which I actually
What is the land that you are claiming?
the family owned some land. They sold me an extent of 297 feet of land into 165 square feet, my lord. That land on the southern side, there is a government compound wall, hospital wall. My lord. From there, it comes to 297 feet. Now, they have shown that portion which has been sold to me as access to the road. Your lordship may turn to page 51. The yellow mark what I have showed, my lord, is the road which they want to show on my land. When they have got a land on the right side, they can definitely take that, this thing, my lord. Page 51. At least had notice been issued to my lord, I have shown that it is my land.
And India of survey number?
Yeah, lordship may kindly, this portion,
What is your survey number?
that portion is my land, which is sold to me.
What is your survey number?
Huh?
Survey number.
What, my lord?
Nim survey number ಯಾವುದು?
ಕೇಳ್ತಾ ಇಲ್ಲ. That is the reason I want to engage senior counsel.
Which is the land that they are claiming? So that-
This land actually belongs to me. On this land, without even notice to me, the layout has been approved by the planning authority.
ಯಾವ ಜಾಗ ಕೇಳ್ತಿರೋದವರು? ಅಶೋಕ್ ಅವರೇ.
my lord,
ಜಾಗ ಕೇಳ್ತಿರೋದವರು?
45/1 is the survey number, in which my lord belonged to Mr. Siddhappa. He had one daughter and 2 sons. And there was a division among them. And the 2 brothers
they sold about 1 acre of land. In the remaining extent, they have
What is the land that he is claiming?
45 or
Five.
5, my lord. Believe.
Where is 45/5? It's only shown as 45/4. Which is 45/5?
Lordship, may kindly, earlier he filed a suit against me. At page 84, your Lordship, a commissioner was appointed to measure the lands. He withdrew the suit thereafter. This is what the learned judge has recorded at page 84, my lords. And even para 18, even otherwise on careful perusal of the sanction plan, one producer plaintiff, one can make out it does not show the extent of land one alleged by the plaintiff and his brother in favor of the defense producer. In fact, from the above said release deed, the plaintiff's brother in respect to the suit land came to exist after the approval of the layout conversion of the sanctioned plan.
And he has
Only
got,
contains their approval. My land should not show as of access. Let them show independent access on their land.
Who appears for the planning authority? Who has granted approval?
Planning authority ಯಾರು ಕೊಟ್ಟಿದ್ರು?
Karnataka,
Here, approved is here.
Respond number six.
respondent number 2, my lord, has sanctioned all.
Who appears for them?
Huh?
Who
Who
appears?
appears for them?
List ನೋಡಿ ಯಾರು appear ಆಗ್ತಾರೆ.
ಯಾರು?
Raju.
Raju.
Yes, Raju. Or objection ಹಾಕಿದಾರಾ?
In
objection
the order, my lord, your lordship, turn to page 84, my lords,
ಹಾಕಿಲ್ಲ.
where the commissioner was appointed. Learned judge has examined
Respondent 2 has
how they
filed
have practiced fraud, my lords,
statement of objections.
and said, let the land be measured. And the moment it was disseminated, they withdrew the suit, so that if the commissioner's report comes out, the cat will be out of the bag.
No, as the authority filed its counter. Second respondent.
Page 84, my lords, at para 813.
No, as the authority which granted the approval, as they filed their counter.
Yes.
As Raju filed the counter,
Yes, yes, yes. He has given the copy to me.
ಯಾವತ್ತು ಫೈಲ್ ಮಾಡಿದ್ದಾರೆ?
ಇದು ಬಹಳ ಹಿಂದೆ ಆಗಿದೆ, ಇದು ಸುಮಾರು ಸಾರಿ ಬಂದಿದೆ.
ಯಾವಾಗ ಡೇಟ್ ಹಾಕಿದ್ದಾರೆ?
ಅಲ್ಲಿ 1 ನಿಮಿಷ ನೋಡಿ.
ಸಿಕ್ಕಿರ್ತದೆ. ಸಿಕ್ಕಿತ್ತು.
Quotes. ನಾವು ಬರ್ದಿಲ್ಲ, ಅವರು ಬರ್ದಿಲ್ಲ.
Planning authority has not filed any swift objections, my lord. The respondent 4 and 5, 1 and 2 have filed.
Who had filed this OS 46/2014?
Yeah, yes. Okay.
One.
Who had filed this OS 46/2014?
They had filed this
So the-
suit file, Mark.
No.
That I am interfering the
Third
respondent 1 and 2 had
Para 6,
against me.
para 6.
Para 13, my lords.
Come to para 6 of the counter of R2.
In this at page 84, para 6 is the
Of the
point
counter,
number 1, the reason started paid.
para 6 of the counter of the second respondent.
Petitioner
Other, I don't have that, my lord. I'll
Not
produce it tomorrow, day after tomorrow, my lords.
petitioner and her husband had filed the suit, my lord, in
What
verse
happened to-
46.
What happened to that suit?
There are 6 of my counter.
ಏನಾಯ್ತು?
Of his count, Raju's count.
That was withdrawn by them.
ಎಲ್ಲಿ ಬರೆದಿದ್ದಾರೆ withdraw?
ಇಲ್ಲಿ ಹೇಳಿದ್ರು ನೋಡಿ, suit so and so,
ಅದ್ ನಮ್ ಕೌಂಟರ್ ಅಂತ ಹೇಳಿ.
Seniors-
ಕೌಂಟರ್ ಇರ್ತಾರೆ.
no, my counter, my lord, not his counter.
ಇದಾಗಿ ಸೌಟ್ ಕೌಂಟರ್ ಬೇಕಂತ.
And the file of the senior civil at JMFC suit declaration and for permanent injunction.
No, in para 6 of the counter of Raju, R2.
No, I am reading my counter, my lord, in
See his counter in
ಏನ್ ಹಾಕಿ?
it is submitted that if at all petitioner is having any right, title or interest over the land bearing survey number 45/1, it is for her to get the declaratory relief from hands of civil court. As admitted by the petitioner, it seems that she and her husband have filed a suit in OS 46 of 2014 on the file of the senior civil judge and Dame FC Sira for relief of declaration and injunction. Unless she declares as the owner of the said property, she cannot maintain the presented petition against the respondents. To the knowledge of this respondent, even the third respondent also filed OS number 35 of 2014 on the file of the senior civil judge JMFC Sira against the husband of the petitioner for the relief of injunction. Unless the said suits OS number 46 of 2014 and 35 of 2014 are disposed of, and unless the petitioner is declared as the owner of the land in question, she cannot claim any relief from the hands of this honorable court.
Then what happened to that suit?
Both the suits, when she withdrew the suit, our suit was for bare injunction, we also withdrew it. That's what I have stated in my count,
You are for which respondent?
third respondent. In whose favor conversion order is granted, in whose favor the layout plan is granted.
Where have you said that the suit was withdrawn?
Yes. Kindly see, my lord, in paragraph 6. It may not be out of place to submit that the petitioner herein and her husband together had filed a suit in OS number 46 of 2014 on the file of the senior civil judge and JMFC, suit for declaration and for permanent injunction and other reliefs. Again, the third respondent, that is myself,
That is
And
not the fact. my lord.
P.S. Tyagaraj.
What has happened is, my lord, we are not concerned with the what property the family owned. We are concerned only 45/1.
Against whom did you file OS 46/2014?
Please, my lord.
ನೀವ್ ಹೇಳಿ ma'am.
Please, what happened, my lord? There was another piece of land adjoining regarding that suit was filed because they were interfering that portion against my husband. And in that suit, my lord, since they were interfering, we filed the suit and when they withdrew the suit, my lord, that I am not interfering, I too withdrew the suit. That is the reason I'm telling my lordship may kindly invite attention to page 84, my lords, where the learned judge has come to the conclusion for appointing commissioner of grading all these things. Page 84, my lords, para 813.
No, this is OS 35/2014. What about OS 46/2014?
I haven't, it was, Because we don't
46, I had also, he filed a suit against me.
for
And he tried to interfere in other portion of the land.
What is the effect of your suit being dismissed against him?
Against him that he should not interfere in the other portion.
Your
of-
suit was a declaration. If your
And
suit
for-
is
I'll
declaration
just
is
check up.
dismissed.
my lord, on it. It's not a suit for declaration.
for declaration and for permanent injunction.
Please, my lord, there were two scheduled properties in that suit. One is this property and another property. If I'll read this portion of the order, my lord, the civil judge, my lord, which shows very clearly what has transferred. At page 84, my lord, para 13.
You are permitted to withdraw the suit with liberty to file a fresh suit. Have you filed a fresh suit?
Both of us filed against each other. We both of, then when he withdrew, I also withdrew with liberty to file a fresh suit. That suit was something different, my lord, because there were two scheduled properties. I had included this mention, this also in the suit. Now, your lordship may kindly turn to
Kunjal, who is to decide whether your land is included in the layout plan or not?
our first suit for injunction ಹಾಕಿದ್ರು.
ಅವ್ರದ್ದು ಬಿಟ್ಬಿಡಿ ಇವಾಗ ನೀವು ದಾವಾ ಹಾಕಿದ್ರಿ ಡಿಕ್ಲರೇಷನ್.
ಹಾ.
ನೀವು ವಿಡ್ರಾ ಮಾಡ್ಕೊಳ್ತೀರಾ with liberty to file a fresh suit.
ಹೌದು.
If you don't file a fresh suit,
Because what that is the reason filing of fresh suit does not arise because
then why do you seek for liberty then?
no, that's a reason, my lord. We are now concerned with only the approval of the layout.
Your challenge to the layout approval is that your land is included. Isn't it?
Please, my lord, what had happened in the previous, the suits, my lord, I'll produce, that plaint also I'll produce, how it was transpired. Then your lordship,
Suppose your suit declaration is dismissed. How can you still contend that this court has to accept or the authorities have to accept that your land is included in the layout plan? You have decided to approach a civil court. You should have taken a decree on merits.
no, even if that suit is withdrawn, my lord, if to have a bearing on the layout which has been approved. Layout which has been approved, my lord, had it been notice been issued to me, I would have
Why should they issue a notice to you? I seek for approval of layout plan for my land. Why should they issue notice to you?
No, because in the layout, they will have to show the lands in which they got the title. They have shown my land in which they have no title to approve the layout.
Whether your land is included or not is a matter to be decided by the trial court, not by the planning authority or by this court.
My submission is this, my lord. Whether the planning authority can sanction layout on the layout land belonging to others.
Who's to decide what is your land and their land? Say, planning authority can decide that.
No. While approving the layout, my lord, they will have to produce all the title deeds. Now, if they have not produced a title deed,
The authority has simply said this land was converted. And once it is converted, I am bound to consider their layout plan on the basis that they are the occupants, they are the owners. They will not go into a determination of title.
No, that is what I would like to satisfy, my lord. Lordship, kindly take it on next week, my lord. I have discussed with the senior. I will explain to that, my lord. Your suit will not come in the way. That's my submission, my lord.
Apart from that, if I can submit against those two annexures, alternative remedies are there. As again, the conversion order, my lord, and appeal lies.
And I will also place the plaint in that suit
Also.
also before the court, my lords.
Bill number 62, S.C. Vijay Kumar.
ಯಾವತ್ತು? Date ಕೊಡ್ತೀವಿ.
My lord, very for petitioner. My lord, in this case, my lord, I appear for government. My lord, there was a direction to file inquiry report, my lord. Report, I have taken the instruction today. Report is ready, my lord. By Friday, I will file it, my lord. Due to some there was a little bit mistake in the part of the government, my lord. That was the reason, my lord. Within Friday, I will file it, my lord. It is ready, my lord. Report is ready.
List. 20.
Very much okay.
For hearing B group, seal number 63, CPN Rajesh Pura.
First respondents council.
That's a case where, my lords, an unauthorized layout is being formed. And I made a representation to the authorities to take action. And the fourth respondent, deputy commissioner's delegated authority issued a direction that my representation is to be considered and action is to be taken.
Public interest. Public interest.
I gave a representation, my lords, because sites being formed. So
So what is your interest on that? Do you have any interest in the land?
I am not interested. Personally, I am not interested. Personally, I am not interested.
Okay. Suhas
Ultimately, my lords,
ಏನಾಯ್ತು ಆಮೇಲೆ ನೀವು ಕೊಟ್ಟದ್ಮೇಲೆ?
ಏನು action ತಗೊಳ್ಳಿಲ್ಲ. So filed a writ petition.
they continue to work on the property. After the writ petition is filed, they have kept it quiet. Till today, the municipality has not filed any objections. Not
Place for the municipality.
I appear. My lord, the municipality, they first said it is not converted. Government was directed to produce, they produced that order. There is a conversion order. Now, they have paid betterment charges and asked for katas in individual sites which have been allowed. That is where it stands.
No, then according to this, is not an unauthorized layout. What is your stand?
My lord, what they have done is they have asked for katas for individual sites. And they have paid betterment charges for each of them, and we have issued kata. That's all.
No,
we have.
in your view, is it an authorized layout or non-authorized layout? Because you have to take a stand, isn't it? If it's an authorized layout, you need to take steps. If it's not an unauthorized layout, say so. I'll record a statement and close the matter. According to me, it's unauthorized. According to you, there's an order of conversion. You have collected betterment tax and registered individual katas. So
Yeah,
what is the effect? Are you saying that the layout is legal or illegal?
Regarding that, we have no specific stand. We have just issued katas based on the applications. That's all we are able to say.
And then layout plan approval ಇದೆಯಾ ಇಲ್ವೋ?
Layout approval ಅಂತಂದ್ರೆ, I purchased the land under a registered sale deed. It's a converted land. Now I approached the Panchayat for individual kata in respect of each site that I have. So formed in the layout. Then I approached the Panchayat, kindly go to R54. That I have produced along with my.
So layout approval ಇಲ್ಲ. Layout approval ಇಲ್ಲ.
I have submitted the plan as per exhibit W produced along with the writ petition itself.
But the Panchayat is the authority to grant approval.
ಪಂಚಾಯತಿ ಅವರು
ಅವ್ರು ಹೇಳ್ತಾನೆ ಇಲ್ಲ, ಅದನ್ನ ನೀವೇ ಒಬ್ರು ಹೇಳ್ತಾ ಇದ್ರ.
Town municipal council ಬಗ್ಗೆ
ಕನ್ವರ್ಟೆಡ್ ಲ್ಯಾಂಡ್.
ಇಲ್ಲ, ಕನ್ವರ್ಷನ್ ಒಂದು ಕ್ಲಾಸ್ ಇರುತ್ತಲ್ಲ. That in the case you want to form a layout, can only be done after the approval of the authority ಅಂತ.
Exhibit W filed along with the writ petition.
Next year?
Writ petition ಅಲ್ಲಿ ಹಾಕಿದ್ದಾರೆ.
page 129.
Page 129 in the writ petition. That is the one. So I have submitted.
ಮನೆ ಕಟ್ಬಿಟ್ಟಿದ್ರೆ ಇವಾಗ
ಕಟ್ಟಂಗಿಲ್ಲ, ಕಟ್ಟಿಲ್ಲ. 53 ಸೈಟ್ ಮಾಡಿದೀನಿ. ಎಲ್ಲದಕ್ಕೂ ಇಂಡಿವಿಜುವಲ್ ಖಾತಾ ಕೊಟ್ಟು ಪವರ್ ಕನೆಕ್ಷನ್ಗೆಲ್ಲ ಸ್ಟ್ರೀಟ್ ಲೈಟ್ಸ್ಗೆ ಎಲ್ಲದಕ್ಕೂ R54 ಕೆಳಗೆ ಪಂಚಾಯತಿಯವರು ರೆಸೊಲ್ಯೂಷನ್ ಮಾಡಿದ್ದಾರೆ. ದಟ್ ಅಕಾರ್ಡಿಂಗ್ ಟು ಮೀ ಇಸ್ ಸಫಿಷಿಯಂಟ್ ಕಂಪ್ಲೈಯನ್ಸ್.
You need to take a stand, isn't it, whether the layout is legal or illegal? You can't be ambivalent about this.
ಲಾಸ್ಟ್ ಅಕೇಶನ್ ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕ್ತೀವಿ ಅಂತ ಟೈಮ್ ತಗೊಂಡು ಮೇಕ್ ಅ ಸ್ಟ್ಯಾಂಡ್ ಕ್ಲಿಯರ್ ಇನ್ ರೈಟಿಂಗ್ ಅಂತ.
ನಿಮ್ ಪ್ರಕಾರನೇ ಇಲ್ವಲ್ಲ, ರೋಲ್ ಇಲ್ವಲ್ಲ.
ಖಾತಾ ಇದೆ, ರೆಸೊಲ್ಯೂಷನ್ ಇದೆ ಪಂಚಾಯತ್.
ಖಾತಾ ಅವ್ರ ಕಂದಾಯಕ್ಕೋಸ್ಕರ ಖಾತಾ ಮಾಡ್ಕೊಡ್ತಾರ ಅವರು.
ಪೇಡ್ ದಿ ಬೆಟರ್ಮೆಂಟ್ ಚಾರ್ಜಸ್ ಆಲ್ಸೋ.
How do you collect betterment charge on what authority do you collect?
My lord, at that time it was permissible, it was collected and it was done. Later it was struck down, that's.
You have the jurisdiction to approve the layout plan. Who has to approve the layout plan? In the conversion order really?
Conversion order is not produced, my lords. Government ಅವರು ಸಬ್ಮಿಟ್ ಮಾಡಿದ್ದಾರೆ. Kindly go through the order dated 12 July 2022.
ಯಾರು ಆರ್ಡರ್ ಮಾಡಿರೋದು?
Government, since the conversion order RPA ಸಿಗ್ತಾ ಇಲ್ಲ ಅಂತ ಹಾಕಿದ್ದಕ್ಕೆ the government was asked to produce the records. 12/7/2022. 22. The government advocate appeared and then said the land is converted.
No. ಅದ್ರಲ್ಲಿ ರೆಫರೆನ್ಸ್ ಇದೆ ಸೇಲ್ ಡೀಡ್ ಅಲ್ಲಿ.
And even in sale deeds, the conversion order number, everything is referred.
ಇಪ್ಪತ್ತೆರಡು 23
12th July 2022. Memo filed by government advocate.
The question of locus standi I have been raising there.
all the time. The fact that they have registered the Khata in their favor and collected taxes, they are giving an impression that it is they recognize the validity of the sites formed, isn't it?
My lords, my
Unless
case,
you challenge that particular action.
lords, they have not sanctioned a plan. They have not sanctioned a Panchayat.
Until you challenge the decision of theirs to collect betterment charges.
They have not produced any document to show that they have collected betterment charges.
Made a statement now.
That's what, my lords, they're not putting anything in writing. And the conversion order is also not there. My lords have seen the memo filed by the government advocate. Alienation podi agide, durasta agide antar. Conversion order ellide, they have not produced.
The order of the court indicates, but there is a document on record which indicates that the properties in question is converted for non-agricultural purposes. That is what is recorded with this court.
My lords, kindly see, my lords, what is produced is a table, form, register showing particulars of
It
alienation.
has recorded on 12/7/2022 that the file was produced, though the official memorandum is not available. There is a document which indicates that the land in question is converted. Therefore, the land is converted. So the use of the land can't be doubted now for non-agricultural purpose. If they have not approved the layout, but they have gone on to register the Khata and collected betterment charges, then until you challenge those actions,
Yes, that material is not before my lords.
I will record a statement, then you file a challenge.
No, they should produce that document before my lords.
Statement is there. This writ petition is not there for you to collect documents and then file. You should have.
Plus, they should file the objections. They took time, my lords.
I will record a statement. Why should we keep this petition pending?
Plus, it's a statement made without any basis, my lords.
ವರ್ಷ ಆಯ್ತು ನೀವು ತಿನ್ಲಿಲ್ಲ ಅವರು ತಿನ್ಲಿಲ್ಲ ಆಸ್ತಿನ ಸುಮ್ನೆ.
My lords, it's like this. This was a property which was given on gift basis by a person for starting a educational institution. Now that educational institutions for 48 years was non-functional. And someday one fine person comes and says, we are the office bearers of this educational society. And for 48 years, they go to the registrar and say that they have made the necessary resolutions and regularize the society. And then immediately sell this property to respondents 2 and 3.
How are you related to all this?
Plus, I am not related to all these, my lords, because my lords, it's not correct. Suppose I put myself in the, I want to go and purchase a site in this layout. If such a situation is there.
Don't purchase. Now that you know.
No, correct, my lords, correct. I'm a alert person, I may not purchase. But does not the municipality and the other authorities have a obligation, statutory duty under section 170, especially, my lords, and 171 of the Municipalities Act, that they must take care that these things do not happen.
We're talking public interest.
Plus, then the matter may be referred to the division bench. My lords.
Not after 12 years.
Plus, then my writ petition was not.
What have you said in your writ petition?
Plus,
Interest.
I have not said anything about my personal interest.
Then I dismiss it only on that ground.
Let's say if my lords feels that this is a public interest, the matter may be.
If you have said so in the petition that you're filing in public interest, I'll refer it.
Let's kindly see, my lords.
What have you said? You should say that you are filing it in public interest because of somebody who can't.
Only para 25 months.
Close it.
That's only, this will give a stamp of approval for the illegalities, my lords.
No, I will not say anything on the merits. I'll say that if the layout is illegal, they will take appropriate action. You don't have to worry.
And that, if my lords clarifies, ultimately, my effort is to say, compel them to take some action. They have to say something. They cannot get away, my lords. That's what is the, ultimately, under Article 226, my lords will direct them to take.
The unauthorized layout, found by respondents 2 and 3, which should be property. Madam is also sought to direct respondents 1 to 4 to take action against respondents 2, 3 and 5 for manipulation and creation of records such as conversion orders, layout sketch, etc., etc. At the very outset, it is to be noticed here that the interest that the petitioner possesses in the land in question, that is, serial number 20/1/3 is not forthcoming. And counsel appearing for the petitioners, candidate admits that the petitioner has no direct interest in the land in question. In my view, if the petitioner has no interest in the land in question, he cannot file a writ petition for a direction to demolish the unauthorized layout. In the event, the layout found by respondents 2 and 3 is illegal. It is needless to state that the respondents number 1 to 4 will consider that issue and pass appropriate orders in that regard. Subject to the above, the writ petition is dismissed.
Grateful.
Number 64. Kumar.
Is the next area?
My lord, annexure A is, my lord, the demand. Circular issued by the corporation, my lord. That is the BBMP.
Covered by a judgment.
Betterment tax. Sir.
No, improvement charges.
Improvement charges without, my lord, any statutory backing. One circular is issued. Circular, my lord, can't. They
It is
can't
covered
impose-
by the judgment. Covered by judgment of Gokulam. I produced it along with my objection statement. Gokulam Shelters Private Limited, where the circular has been upheld. Page number 61, R2. Page 61. In this, my lord, in one of the petitions, my lord, your lordships were also doing this. Page 61, make I see.
61.
Same circular.
Same circular. It has been upheld. ಅಪೀಲು ಒಬ್ರು ಹಾಕಿದ್ರು DNP ಆಯ್ತು.
What should Mr. Solda?
Objections ಅಂತ ಹೇಳ್ತಾರೆ. ನನ್ನ ಹತ್ರ ಇಲ್ಲ. ನಾನು ಅದು ಹಾಕಿಲ್ಲ.
Objections ಕೊಟ್ಟಿದ್ದಾರೆ, ಸರ್ವ್ ಆಗಿದೆ ಸರ್.
ಹೌದಾ? ಎಲ್ಲ ಇರ್ಬೋದು. ನನ್ನ ಹತ್ರ.
Sir, I can give you one copy of the order.
Yeah.
ಇದೆ, I think one copy ಇದೆ. So, one copy of the order.
Same 1/7/2014.
ಹೌದು. Same circular. Based on that, I have issued a demand notice to. Page 57, sir. Page 57.
Then this is, you know, what happened in the appeal.
Appeal is dismissed for non-prosecution.
Oh.
One of the parties had gone.
ನಮ್ದು ಇದ್ರ ಜೊತೆಗೆ ಇತ್ತಂತೆ ಆಮೇಲೆ ದಿಲ್ಲಿಕ್ ಆಯ್ತು. Only thing is, my lord, I would submit, my lord, that the Supreme Court judgment, my lord, one judgment I'll give you, lordships. Ultimately, my lord, it's for your lordships too.
But then I have to disagree with this order if I have to take a different view.
Can I just pass on one judgment for my lord's consideration?
Appeal ಹಾಕ್ಬಿಡಿ ಅಷ್ಟೇ. I'll follow this judgment, file an appeal. That will be the better option. Because he says writ appeal is also dismissed.
Dismiss for non-prosecution ಅಂತ ಹೇಳ್ತಾರೆ.
Dismissed for non-prosecution.
ಇರ್ಬೋದು, my lord, I don't want to, my lord. He may be right. I don't know. I'll
Yes,
accept, my lord, whatever he
I
says.
just
No, no,
verified.
but I can't disbelieve, my lord, my learned friend at all.
I'll dismiss this writ
In
petition.
fact, my lord, tax can't be collected, my lord, by means of an executive fiat. Enough.
But you know, This court has taken a view already.
No, it is based on a rule which has been approved by the government. There is a rule to that
It
effect.
was 9 years ago.
appeal. ಆಯ್ತು ಅಷ್ಟೇ ನಾನು ಇನ್ನೇನು
Where in
ಹೇಳಕ್ಕಾಗಲ್ಲ.
this petition is to quash the circular dated 1/7/2014, on the basis of which the corporation seeks to collect improvement charges.
Demand ಇಲ್ಲ.
ಹೌದು.
Not possible for the BMP points out.
My lord, can I add one thing? Even, my lord, if this circular is there, can I request your lords to look at, my lord, the circular itself?
But that is the only prayer, isn't it?
Illa, there are two. Demand notice is challenged. Demand, my lord, yes. Can I put it in this manner, subject to my being corrected by your lord? There has to be some improvement in the area. Without any improvement, my lord, can they demand is the question? Because even if the circular is accepted as, my lord, authorizing them,
Does the circular say that only if there's an improvement they should collect it?
my lord, can I pursue your lords to just have a look at it?
It only fixes the rate, isn't it? Annexed
ಹೌದು.
circular.
ಅಲ್ಲ ಅದ್ರಲ್ಲಿ ಫಿಕ್ಸ್ ಆಗಿಲ್ಲ. ಕಮಿಟಿ ವಾಸ್ ಫಾರ್ಮ್ ಬೈ ಮೀ. Committee, my lord, after pursuant to a direction by this court in writ petition number 40 of 2013, my lord, a committee was formed. Thereafterwards, my lord, committee gives a report. That report, as per that report, my lord, 250 is 250 rupees per square meter is the amount which is fixed. That committee report is also not challenged before your lordships, no?
Pilakpudi order. I'll be trying to get over this order.
No. I don't want your lords to get over it at all. And maybe I'd be able to persuade your lords, it doesn't matter. Because ultimately, my lord, whether your lords refer it or I file an appeal, it will be the same. Only thing is, ಅಲ್ಲಿ ಸುಧಾರಣಾ ವೆಚ್ಚ, my lord, improvement ಆಗಿದ್ದಕ್ಕೆ, my lord, they can claim. ಇದು ಏರ್ಪೋರ್ಟ್ ಹತ್ರ ಅಲ್ಲಿ ಏನು ಮಾಡಿಲ್ಲ. Neither, my lord, there are drain.
With that yardstick, nobody needs to pay any taxes to the country.
Tax ಅಲ್ಲ, ಇದು improvement charge because the very circular says it is improvement charge.
It's the fact that this court in WP number so and so has upheld the circular and dismissed a batch of writ petitions. In view of the fact that the circular which is implemented this writ petition is already upheld by the coordinate bench of this court. The relief sought for petition cannot be granted. Petition is accordingly dismissed in terms of the order passed in so and so.
ನೋಡ್ರಿ ಇನ್ನೊಂದು ಯಾವ್ದು ಕೊಟ್ಟಿದ್ದೀನಿ. Please.
Rest will be repeated.
Please. ನೋಡಿ.
Court officer. Court officer.
Yes, that's.
17th ಬಿಟ್ಟು ಕೊಟ್ಬಿಡಿ ಒಂದು 67 ಗೆ 17th ಬಿಟ್ಟು ಬೇರೆ ಯಾವ್ದು ಡೇಟ್ ಕೊಡಿ ಈ 7 ಗೆ
Excuse me, court officer.
ಆಮೇಲೆ ಹಳೆದೆಲ್ಲ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಬರುತ್ತೆ.
17th ಮೇಲೆ ನೋಡಿ 67
Court officer sir, serial number 65 sir. Court officer sir. Serial number 65 list number 1 ಏನಾಯ್ತು sir?
65.
65.
ನೆಕ್ಸ್ಟ್ ಫ್ರೈಡೆ ಬರುತ್ತೆ.
65 next Friday. Okay, grateful. Thank you so much sir.
Sir, 68.
ಫ್ರೈಡೆ ಬೇಡ ಸರ್. ರಿಪೀಟೆಡ್ ಮ್ಯಾಟರ್ ಸರ್.
65.
ಇದೆಲ್ಲ ನೆಕ್ಸ್ಟ್ ಫ್ರೈಡೆ ಬರುತ್ತೆ. ಸ್ವಲ್ಪ ಲೇಟ್ 2 weeks.
76.
Sir, B group matters.
Sir, 68.
24 ಫಿಕ್ಸ್ ಮಾಡಿದ್ದೀವಿ. ಎಲ್ಲ ಡೇಟ್
Sir, next Friday. 88. CH
ಫ್ರೈಡೆ ಅಂತ ಬರುತ್ತೆ. ಡೇಟ್
17th.
ಡೇಟ್ ಫ್ರೈಡೆ.
73 next Friday.
17th.
ಸರ್ 88 CH ಮೂವ್ಡ್ ನೆನ್ನೆ ಬಂದಿತ್ತು ಇವತ್ತಿಗೆ ಹಾಕ್ಸ್ಕೊಂಡಿದ್ರು ಒಂದು 88
The serial number 89.
ಅಂದ್ರೆ ಹಿಯರಿಂಗ್ ನಡಿಬೇಕು ಸರ್ ಅದು ಸೀನಿಯರ್ ಕೌನ್ಸಿಲ್ ನೆನ್ನೆ ಇವತ್ತಿಗೆ ಹಾಕ್ಸ್ಕೊಂಡ್ರು
ಎಲ್ಲ ಹಳೇದು.
ಟ್ಯೂಸ್ಡೇ ವೆನ್ಸ್ಡೇ ಆ ಥರ.
ನೆಕ್ಸ್ಟ್
Sir, 72.
ಎಲ್ಲ ನೆಕ್ಸ್ಟ್ ಫ್ರೈಡೆ.
Okay, sir. Thank you.
Sir, ಯಾವ date ಬೇಕು?
21st ಕೊಡ್ಲಾ?
21st. ಓಕೆ
The serial number 89 next week.
29, 22,
Sir,
25,
serial number 90. 90, sir.
90, 2 weeks.
2 weeks after. Thank you, sir.
ಸರ್ ಲಿಸ್ಟ್ 1 68. ಹಲೋ
Sir,
ಕೋರ್ಟ್ ಆಫೀಸರ್ ಸರ್ ಲಿಸ್ಟ್ 1 68.
Next Friday, sir.
ಓಕೆ ಸರ್ ಥ್ಯಾಂಕ್ ಯು.